ಮಾಡ್ಬಿಟ್ಟು ಬಂದೆ ಆನ್ ಆಗಿರಲ್ಲ. ಅಲ್ಲಿ ನಾನು ನೆಕ್ಸ್ಟ್ ಒಂದು ಮಾಡ್ತಿರ್ತೀನಿ ನಿಮ್ದ.
ಹಲೋ.
ಮಾಡಿದೆ
mentioning a matter for Monday, my lords. A TOS matter. TOS matter. It is let down for. Huh? ಅಲ್ಲ ಏನಾಗಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ ವೆಡ್ನೆಸ್ಡೇಗೆ ಇಟ್ ಇಸ್ ಬಿನ್ ಲಿಸ್ಟೆಡ್ ಬಿಫೋರ್ ದ ರಿಜಿಸ್ಟರ್ ಪ್ರೋಟೋಕಾಲ್ ಫಾರ್ ಎವಿಡೆನ್ಸ್ ದ ವಿಟ್ನೆಸ್ ಇಸ್ ಟ್ರಾವೆಲಿಂಗ್ ಫ್ರಮ್ ಯುನೈಟೆಡ್ ಸ್ಟೇಟ್ಸ್ ಐ ಫೈಲ್ಡ್ ಅನ್ ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ ಅಡಿಷನಲ್ ಪ್ರೊಡಕ್ಷನ್ ಆಫ್ ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇಟ್ ಇಸ್ ಇಂಪರೇಟಿವ್ ದಟ್ ದ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಮೇ should be produced through her, so it may be taken up on Monday. I've served the copy as well. I'll inform the other side.
SCST matter.
Taken up on Monday.
SCST matter, I am the purchaser, but yesterday also movement. I am for but today, 2:30.
Antar urgency. Monday ಬರ್ಲಿ ಬಿಡಿ.
ಅಲ್ಲ ಅದು ಡಿಸ್ಪೋಷನ್ ಮಾಡಿದವರು ಸುಮ್ಮನೆ ಆಟ ಹಂಗಾಗಿ ನಾನು ಪರ್ಚೇಸರ್ ಮುಂದೆ ನಮ್ಮ ಮೂವ್ಮೆಂಟ್
For adjournments, page number 12, seal number 38 to 43, page number
Seal number 41 for responding. After vacation. Please wait.
Petitioner, my lords.
Please wait.
page number 13, seal number 44, 46, page number 14, seal number 47 and 48,
Serial number 48, my lord. Settlement ಮಾಡ್ಕೋತಾ ಇದ್ದಾರೆ, ಸ್ವಲ್ಪ ಟೈಮ್ ಬೇಕಿತ್ತು.
page number 15, seal number 49 to 52,
For the respondent, this matter Surendra appears, my lords, I will inform. Kindly have this matter next week.
My lord, serial
Seal number 15, ನನ್ನೇ ಇತ್ತು ಇವತ್ತಿಗೆ ಹಾಕಿದೀರಾ? Next week ಅಲ್ಲಿ argue ಮಾಡಿ. You have to file objection.
Let us see. Wait.
Now I will inform about that. Jaykumar sir, senior advocate, some information.
Please wait. Let us see.
my lord, serial number 49, my lord, appear for respondent number 5 to 11, my lord. I have informed
Lordship,
other.
appearing for the petitioner in this matter, it may be heard during the course of the day, your lordship. It's been pending for a long time.
page number 16, seal number 53 to 56,
My lord, serial number
47, my lord. 47, my lord. Respondent number 5 to 7.
Move ಮಾಡಿದ್ದಾರೆ. Please wait.
serial number 56, my lord, ಅದೆಲ್ಲ ಅಮೆಂಡ್ಮೆಂಟ್ ಪಿಟಿಷನ್ ಹಾಕ್ಬೇಕು. ನೆಕ್ಸ್ಟ್ ವೀಕ್, my lord. 56 petitioner ಇದರಲ್ಲಿ ಅಮೆಂಡ್ಮೆಂಟ್ ಪಿಟಿಷನ್ ಹಾಕ್ಬೇಕು.
I am for the
Serial number
respondent.
54, my lord.
Lordship may kindly fix a date, my lord. 35 years delay, my lord.
Serial number 54, your lordship, after vacation.
63 ನಲ್ಲಿ I want Monday or Tuesday, 63
ನಿಂದ 55
55, my lord.
ಏನ್ ಬೇಕು?
Take up hearing next.
List.
serial number 63 ನಲ್ಲಿ Monday or Tuesday kind because I could not able to get the records.
100 years ಎಲ್ಲ
Monday or Tuesday.
Wednesday or Thursday.
So serial number 61, R1 to R5, kindly seeking, requesting, senior is not keeping well. So can you post for after 1 week?
Date given matter, isn't it?
61, 6.
Appear for petitioner next week.
List.
20th,
Serial number 58.
page number 18, seal number 63 to 66,
Serial number 58, like I appear for the petitioner. Date was fixed. Lordships may kindly have it on Thursday.
Today is the date, isn't it?
Today's date was fixed. There's some inconvenience. Thursday, lordships may kindly have it.
List.
King orders fixed.
page number
Respondent.
Date fixed matter ಅಲ್ವಾ ಮೇಡಮ್?
page number 19, seal number 67 to 73,
Serial number 70, my lord. I am respondent number 4. Kindly have it done after vacation, my lord.
page number 20, seal number 74 to 78, page number 21, seal number 79,
Serial number 14, sir.
page number 22, seal number 80, page number 23, seal number 81 to 83,
83, my lord. I appear for the petitioner next week, my lord, any date. Interim order.
15 ಒಂದು ನಿಮಿಷ ಇರಿ, ನೋಡೋಣ.
ಅಲ್ಲ ಯಾಕಂದ್ರೆ senior today not in the station.
ನೋಡಿದ್ರೆ 15.
page number 24, seal number 84 to 88,
Lord, serial number 47, my lord.
Yes.
Senior not keeping well.
ನೋಡಿದ್ರೆ 2016. Please wait.
Serial
Fresh
number
matters?
38, ma'am. Serial number 38.
very good, sorry. Fresh matter, seal number 1, Shri Venugopal MS,
I appear for petitioner.
purchases writ petition, my lords. The appeal filed by the grantees, my lords, came to be allowed without hearing.
Date of the grant?
My lords, the date of the grant is 53, my lords, 2/10/53. 66 is the sale. My lords,
15 years.
15 years.
4-1.
My lords, the appeal filed by the grantees before the deputy commissioner was allowed without hearing the parties. Lordship may kindly peruse the order sheet.
It is there. Notice ಕೊಟ್ಟಿದ್ದಾರೆ, notice has been issued, madam. It is.
Page
CGB access notice for R1 to R4. Interim stay.
Seal number 2.
Bill number 2, my lords, is the petition by the grantee. The petition, the appeal before the DC was dismissed on the ground that due to the reasons of limitation. Grant was in the year 1968. The first sales happened in the year 1986, my lords. Now, my lords, the challenge before the assistant commissioner was in the year 2011. On the grounds of limitation that the appeal was filed after 4 years.
Division bench, I am told, is dismissing the petitions after 8 years. So I have to follow that.
Lords, but because the amendment is pending, that constitutional challenge.
Despite the amendment being pending, division bench is dismissing the writ petitions beyond 8 years. What should I do?
Notice being.
ಸಿಗ್ತಾ ಮೇಡಮ್ ಅವ್ರ ಕಾಪಿ?
My lord, ಇನ್ನು release ಆಗಿಲ್ಲ ಯಾವ್ದನ್ನು. Just many, my lord,
I'll
more than
examine Let it
14,
be kept.
15 matters has been discussed.
20th. Seal number 3, Shri Hanmantappa A.
The purchaser writ petition, my lord. The grantee filed an appeal before the assistant commissioner, my lord, for resumption of land, same was dismissed. Agreed with the same, my lord, they filed an appeal before the deputy commissioner. 29 is the grant, my lord, 82 is the sale, my lord. And approached the 2016, filed an appeal.
10 years, 29, no?
Please, my lord, 10 years, so, but it is a 4-2 violation, my lord. After the act came into force, the sale has taken first alienation.
Notice for R1 and R2. Notice. Interim stay.
Seal number 4.
But I appear for the respondent contesting the
Kindly
report.
pass out the case for hearing and
That last Friday nu pass over ತೆಕ್ಕೊಂಡ್ರು ಮತ್ತೆ ಬರ್ಲೇ ಇಲ್ಲ.
senior is engaged in another court.
Seal number 5. CPM Sidmalappa. Seal number 5.
Numbers, additional. Please, my lord, prior to act, my lord, sale has taken place prior to act.
Date of grant?
Grant is petition, my lord.
Now date of grant, ಯಾವತ್ತು?
Date of grant 1940, my lord. Sale has taken place 8/5/1960.
68.
60, yes, ma'am. And 2010
Where is the order of the applicant?
DC order, ma'am. He says delay. Page 29, my lord.
Twenty-nine.
31 ವರ್ಷಗಳ ನಂತರ ಸಲ್ಲಿಸಿರುವುದಿದ್ದ
Next year, next year.
annexure A.
Annexure grant certificate.
My lord, WP 28003, my lord.
20808.
DC order is at 96, my lord, page 96. This is, my lord, 1951 grant, my lord.
1951.
Yes, my lord. Sale has taken place, my lord, 62.
Beyond 10 years. Huh?
Yes,
Was it dismissed there?
my lord, ಇದ್ರಲ್ಲ dismiss ಮಾಡಿಲ್ಲ ಒಂದ್ಸಲ ಎಲ್ಲ ಅಂಶ AC is allowed. 65 sale, my lord, here, 65. Sale is at 65.
For the appellants, my lords.
Madam, AC here, my lord, page 66 ಅಲ್ಲಿ recorded findings, grant ಬಗ್ಗೆ ಯಾವುದೇ ದಾಖಲಾತಿಗಳನ್ನು ಸಲ್ಲಿಸುವುದಿಲ್ಲ. ಸ್ವಲ್ಪ ಬಿಟ್ my lord. Page 66 ಅಲ್ಲಿ my lord, assistant commissioner ಮೇಲೆ last paragraph.
Six.
Please, madam. ದರಖಾಸ್ತು ಡಿಮ್ಯಾಂಡ್ ಮೇಲೆ ಲಾಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್. ದರಖಾಸ್ತು ಡಿಮ್ಯಾಂಡ್ ವಹಿಯನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಸರ್ವೆ ಪುಟ 65, 56, 57 ಸಾಲು ನಮೂದಿಸಿರುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. ದರಖಾಸ್ತು ಡಿಮ್ಯಾಂಡ್ ವಹಿಯನ್ನು ಕುಲಂಕುಷವಾಗಿ ಪರಿಶೀಲಿಸಿದಾಗ ಕ್ರಮ ಸಂಖ್ಯೆ 30 ನಂತರ ಸ್ವಲ್ಪ ಸ್ಥಳಾವಕಾಶ ಬಿಟ್ಟು ಅಮಲ್ದಾರಿ ಸಹಿ ಮಾಡಿರುತ್ತಾರೆ. ಈ ಸ್ಥಳಾವಕಾಶವನ್ನು ಉಪಯೋಗಿಸಿಕೊಂಡು ಕ್ರಮಾಂಕ 35 ಎಂದು ನಮೂದಿಸಿ.
Yes,
my lord.
For the petitioner, my lord, senior is not keeping well, my lord.
I have granted you as a last chance today. We don't argue, I dismiss the petition. Anything else?
Kindly pass over.
AC or both the concurrent findings, my lord. AC and DC, they held same.
They have inserted this entry in the records.
Yes, please, my lord.
Kindly pass over the matter.
Seal number 6, Sri Jagan Mohan MT.
There's a date of grant on 6/1/1966. The grant is sold to this petitioner on,
New Year,
I'm purchaser. Then 14.
2014.
Oh. Initiated in 2020. Proceedings.
CGP accepts notice for R1 and R2, issue notice. The response, interim stay. ಬೇರೆ ಇಷ್ಟೊಂದು ಜನ ಇದಾರೆ ಗ್ರಾಂಟೀಸ್.
ಇಲ್ಲ, ಡೆತ್ ಆಗಿ ಅವ್ರು ಎಲ್ಲರ್ಸ್ ಎಲ್ಲ ಇಂಪ್ಲೀಡ್ ಆಗಿದ್ದಾರೆ.
Seal number 7, Sri Raghavendra Rao.
Appearing for the petitioners in this case, your lordship.
Yes.
We are for the children of the purchasers. The alienation is of the year 1974. The resumption application is filed in 2010 after the lapse of 35 years.
When is the date of the grant?
Your lordship, date of grant exactly is not available in the record. Both AC and DC do not refer to it. It appears to be in 6970.
6970, 15 years conditions, my lord, they say. 74 sale.
Accepts notice for R1 and R2. R1 to R4. Issue notice for response, interim stay.
A stay may kindly be granted, your lordship.
Yes.
Seal number 8,
Granted.
Much obliged.
Shri B Sharat Kumar.
This case I prefer the petitioner. Trial court advocate is Bangalore case.
ಆಗಿದೆ ಸಭಾಗಿ.
Serve ಆಗಿದೆ. I have given the acknowledgement.
ನೀವು ಸರ್ ಮಾಡಿ. RPD ಕಳ್ಸಿದ್ದೀರಾ?
Please, Marsh. From Bangalore to Gundlupet, I have asked for transfer.
No. PV Patil,
Please, Marsh.
West Supreme Name of PV
PV
Patil
Patil
is
is
appearing for respondent and released on
19th. Seal number 9, Shri Prakasha K.
The respondent husband has filed a petition for divorce at Kunigal, my lord. The petitioner is at Kadur, Chikmagalur district. I sought for the transfer of MC petition from Kunigal to Kadur, my lord.
ಮಕ್ಳಿದಾರಾ?
ಮಕ್ಳಿಲ್ಲ ಸರ್, ಮಕ್ಳಿಲ್ಲ. 6 ತಿಂಗಳು ಮಾತ್ರ ಜೊತೆಯಲ್ಲಿದ್ರು.
The wife is before this court seeking for transfer of MC 17/22, which has been issued by the husband before the senior civil judge at JMFC Kunigal to the senior civil judge in JMFC at Kadur. The petitioner notice was ordered of this petition, and the petitioner's counsel was permitted to take out notice on the counsel who representing the respondent to the trial court. An acknowledgement is filed by the counsel indicating that the counsel for the respondent in the trial court had received the notice. Despite service of notice, there is no appearance on behalf of the respondent. Therefore, obvious that the husband would have no objection to transfer the petition. So consequently, the petition filed by the husband in MC 17/23 is withdrawn from the file of the senior civil judge at JMFC at Kunigal and transferred to the senior civil judge and JMFC at Kadur.
Much of it.
Seal number 10, Shri Sandesh Kumar M.
In this matter, I tried to serve the copy to the trial court advocate, my lord. He is not available. Finally, 3 days time may be given, my lord. Matter will be posted for 19th, my lord. Meantime, I will get it served, my lord.
Seal number 11,
Interim of
ready. Seal number 11,
Petitioner, my lords. Trial court advocate is refusing the take notice, my lords. Notice the one that.
File an affidavit.
Please, my lords.
19th. Seal number 12, Shri Venkatesh R. Bhagat.
My lord, in this for the petitioners, my lord. My lord, respondent counsel said they are filing wakalat today. They will be
Who's the
filing, my
counsel?
lord. The matter may be referred for mediation, my lord.
Who's the counsel?
Pulkit Koil.
Madam?
They are
Pulkit?
filing wakalat. Pulkit Koil. Koil. GOEL.
Submits that Shri so-and-so as informed by her that entering appearance. Just to print his name and relist on.
My lord, it may be referred to mediation, my lord.
Without him,
They are filing today. It may be passed out, my lord. By 1:30, we will make a submission. They are filing wakalat today, my lord. It may be passed out, my lord.
released it on Monday.
Please, my lord.
Seal number 13, Srimati Jayanti. Seal number 13.
There is no appearance on behalf of the petitioner. It is obvious that the petitioner is not interested in pursuing the petition. Petition therefore dismissed, non-prosecution.
Seal number 14, Shri Chandan Gowda Patil.
Well, it's appearing for the petitioner in this matter. Well, we have already served the copies to the respondent counsel appearing before the trial court.
Objection to transfer this case.
Petition is filed by the wife seeking for transfer of GNWC 74/24. Spending on the file of the 7th Additional Senior Civil Judge, JMFC Bangalore Rural, to the Court of the Principal Judge, Family Court, Bangalore. Not counsel appearing for the respondent husband states that he has no objection with said transfer. In view of the above, GNWC 74/24 pending on the file of the 7th Senior Civil Judge and JMFC Bangalore Rural is withdrawn and transferred to Principal Judge, Family Court, Bangalore. Ali, how is the matter pending?
MC 3650 of 2020.
Principal Judge, Family Court is directed to ensure that GNW 74/24 and MC number
3650 of
3650 MC 15.
MC 15 is before the Sira court, my lords. It has to be transferred to family court.
There's no prayer for it.
My lords, there is one more petition, 14.1, my lords.
Where is that MC number you said?
MC number 15 of 2024, which is pending before Sira court.
No, the other one is pending in the family court.
Family court is 3650 of 2024.
3650/2024. Similarly, the petition filed by the husband for restitution in miscellaneous MC. 15/24 is pending on the senior civil judge at James Sirathapur is also withdrawn and transferred to the principal judge family court, Bangalore. So the principal judge family court shall ensure that all the three matters between the husband and wife are posted on the same date, so as not to cause any inconvenience to them. Conditions are accordingly brought.
Deeply obliged.
Number 15, Sheila for bias.
Appear for the plaintiff.
Appear for the respondent. This is a company matter, probate matter, my lord. This is a probate matter.
My lord, now the evidence has already been conducted. Issues may kindly be framed. In the event, my lord, if there is any issue, my lord, if there is a burden on me, my lord, I lead further evidence.
Now,
Or else,
I was a bit concerned about the procedure that is being
Procedure.
followed.
yes,
Well, the
Not
recording
very
is,
sure whether this is the correct procedure.
this may not be the correct procedure, my lord. What it was immediately after PN, they filed a caveat matter, it would have been transferred as TOS. Then, my lord, the earlier counsel, we brought it to the knowledge because the evidence was recorded in P&SC throughout. Then it came before the court and we said that it has to be in transferred as TOS. Then the officers transferred as TOS. Then issues were not framed. Then we submitted to the court, issues were framed. The court said that issues will frame later, issues can be framed later. This was what, then the evidence was reduced, my lord, evidence was done. My lord, the correct procedure, my lord, after P&SC, my lord, after TOS, issues has to be framed, evidence has to be led. Now, evidence has already been led in the matter. Issues may kindly be framed, otherwise I'll file draft issues. If at all there is any issues, my lord, evidence requires to be led in. So I will examine plaintiff.
but regarding the evidence which is recorded is in the probate, my lord, not in TOS.
Come again?
The evidence has been recorded, my lord, of the plaintiff, examined, cross-examined in 2019. Not in the TOS, my lord. TOS has only come into action only on 23.
No separate evidence, my lord, in
That your
P&SC and
lordship is
probate,
kindly
no
passed
separate
an order.
evidence can be led. I will adopt the evidence, whatever is led there in the
Lordship may pass
TOS
the order.
proceedings.
And for issues and as well as taking the evidence on record. ma'am.
What was the first petition that was filed?
Beg your pardon?
What was the first petition that you filed?
The TOS,
First petition is filed and done.
it was filed on 22nd September 2016, my lord.
22/9/2016.
When did you enter caveat?
Notice was issued and we came on record.
No, he said caveat was entered.
Yeah, no, the objections they were filed. That's
When was the citation ordered then?
citation, my lord.
18.
You filed the petition making them as respondents.
Yes, my lord.
On 6/7/2017, we filed the objection, my lord.
Who's the testator?
This is my father-in-law, my lord, and father of respond number 3.
What's his name?
Louis Gratian Marcel D'Souza.
Who is D'Souza?
Yeah, Louis D'Souza, my lord, he is having half share in the property along with his wife.
Did he die?
My lord, he expired on 2011-2015. 20th November 2015.
1950.
2015.
15, ma'am.
And what is the date of the will?
Date of the
Nine-
will, my lord,
19/11/2013.
19th November 2013.
How many children did he have?
2 children, my lord.
One son and one daughter.
One son is predeceased. The wife and this son are the respond number, defend number 2 and 3. 1 and 2 are the
Number one is the wife.
wife of the son,
The son, my lord. Daughter-in-law, my lord.
daughter-in-law.
Daughter-in-law.
What is the name of the son?
Son name, my lord,
Rodolphe.
Rudolph.
Rohan Rudolph, my lord.
Rudolph.
Rohan Rudolph D'Souza.
One son, my lord, Rudolph, and one daughter is defend number 3, Diana Nazareth.
This is not on. Yeah. His
Second son.
grandson.
Yeah, second one.
Who's R2? Rohan?
R2 is the son of Rudolph, my lord,
Grandson.
grandson of the deceased.
The request is in whose favor?
This is Sunil Nazrat, my lord, the son-in-law,
That is
This is Dinah's husband.
Dinah's husband.
My
Yes.
husband.
Dinah is the daughter and he is the son-in-law.
Christopher.
Sunil, yeah, Sunil Christopher Sunil Nazrat.
Yes, bequeath is property to Sunil.
Sunil, yes. Half share, my lord.
No,
When did you file objections, madam?
madam, we filed on 6/7/2017.
Where is the will?
Will, my lord.
Exhibit P22, my lord.
Exhibit.
22. Here we don't know.
Registered or unregistered will?
It's a registered will. ma'am.
Here. it-
When was the evidence commenced?
Evidence, my lord.
On 2/7/2019. 27/29. They filed an application, my lord, run of 2019 to, under order 7 rule 14, my lord, for this honorable court to permit to produce the documents. And on, it commenced, my lord, on
This was a law. We commenced.
29. Commenced on 14/12/2019, my lord.
Evidence filed, my lord.
Without the probate petition being converted into a suit, evidence started.
It was
Evidence
referred to evidence, ma'am. Recording the evidence.
On 14/11/2019, my lord.
I filed my examination in chief, my lord, on 2/7/2019.
Here, here.
How many witnesses have you examined?
I examined 3 witnesses, my lord, 2 attesting witnesses and the beneficiary under the will, the plaintiff. ma'am.
Your evidence?
Cross-examination also we have done, my lord.
Their evidence is closed. ma'am.
No,
They have not, now it is, they have not adduced any evidence.
No, my lord, on the last occasion, we brought to the notice of the registrar that this amended plaint is filed. It has not yet been accepted by the court. My lord, he did not agree to that. He's saying in the court it's a different proceeding, here it's a different proceeding.
Okay. Did you lead evidence? What is your, there's no evidence on your side?
No,
Oh,
ma'am.
We have,
So far, they have not
Okay.
led any.
we have filed it.
That's right.
No, if the evidence is complete, then all that remains is to hear the matter on merits.
No, my lord, our evidence is not started, my lord. Defendants.
That's closed, my lord.
Any order saying that no evidence on your side?
No, last time it was closed, my lord. They have taken time.
The registrar, my
Since sufficient opportunities were taken.
Separate application.
See, this order has been passed.
Is it so?
18/11/2022 order has been passed.
Strictly speaking, in a probate proceeding, the only issue to be framed is whether
Will, in respect to will, my lord,
Respect of
that's
the will, my
whether you are sound and disposing state of mind to execute the will.
whether the will has been duly executed.
Duly executed, my lord.
That is the only issue.
That is the only challenge also by them, my lord. He was not in a sound state of mind
No, property.
to execute the will. And on that only they have cross-examined.
Because both of you have laid evidence
Yes, ma'am.
in that
No.
line only.
No, I have not led, my lord.
They have not led in any evidence, my lord.
It's for that stage, my lord.
But they have filed documents and all. They also participated. It is, they have not also raised this defense at that point of time. It is inadvertently all of us participated in the proceedings with, then now or subsequently we realized this would have been converted.
18/11/2022.
And parties themselves, they participated in all this. The procedures, my lord.
I have filed an IA also, my lord, take the documents on record. And that an order has been passed on 18/11/2022, allowing the application,
18/11,
2022.
what was the application for?
Production of documents
Documents,
by additional
additional.
document.
What is the order on that?
Order, your lordship would get it, my lord, and.
That
18/11/22.
application is allowed, my lord, they are
It
permitted
was
to.
allowed, my lord.
Read it. When was it?
I 1/22 is filed seeking permission to produce the additional documents. Learned counsel for the respondent would oppose the production of documents and submit that photocopy of document were produced as the first instance. And now they are intending to produce the original copies and certified copies. In the circumstance, they
Was it
cannot.
allowed, madam? When was it allowed?
18/11/22. 18/11/22. Yes, madam. It was filed earlier, but the order
It
came to
was
be
not
passed.
allowed on the same day, my lord. Subsequently, it was allowed.
The order
filed-
passed by whom? By this court?
By this
Court,
honorable
this
court.
court, this court.
That is a final order.
Get it on 18/11.
18/11/22, my lord. And on the same day, my lord,
This order has come to the converting materials.
18/11/22. On the same day, my lord, order,
49
page 49, my lord.
of order sheet.
Eighteen eleven twenty twenty, there's no order allowing your application.
18/11/22, my lord.
Page 49.
Page 49.
After allowing the application.
Lord, same. day. From that stage, you'll have to go on.
Yes, my lord. They are to
But
file an
that TOS, my lord,
Now,
and it will not get converted to TOS. Then your lordship may kindly see the order, my lord. In same one,
Even without this being considered as a contentious issue, both of you have gone into trial.
yes, ma'am.
my lord, I just came on August 8, 2024. But both the parties have gone on trial.
Then both of you do one thing, both of you file a memo saying that this is the only issue that we have gone into trial and the matter can be proceed further. I'll pass an order saying that she be permitted to adduce evidence and the matter be closed. Because if I have to frame issues now,
Yes.
the entire evidence that is rendered will
Well, issues can now also be framed in case if I want to lead any further evidence, that liberty may be reserved. I don't have any further evidence. What can frame issue, my lord, in any point of time? my lord?
now tomorrow you
But
should not come and say that I went into trial without issues being framed. Therefore, my evidence is of no consequence.
My submission may be recorded in that case, my lord. And court has a power, my lord, to frame issues at any point of time.
No, but you can't go to trial without issues.
And so therefore, my lord, I will, whatever issues, if the issues framed, if there is evidence to be led further, my lord, I will adopt the earlier evidence. If any evidence to be led further, I will.
On 22/9/2016. This petition was presented seeking for probate of the will dated 19/11/2013, executed by, what is his name?
Louis Gratian,
Louis Gratian D'Souza,
Marcel.
under the will. Louis Gratian D'Souza.
Marcel D'Souza.
Had bequeathed his half share.
Half share.
In favor of. his-
No, my lord, mention the full share. In the will, my lord, it says full share. Complete and the absolute.
No, that full share means so far he had half share of that full share.
They did not.
His
They had stated, my lord, in the will also, I am the absolute owner of the property. Wife's name is not there.
Now, what did he bequeath according to you?
No, my lord, he bequeathed the full property,
Where he is not.
where he is only 50% owner.
Under the will, he made a bequest in favor of his son-in-law.
Son-in-law.
And as a consequence, son-in-law Sunil. Christopher Sunil Nazareth. Consequently, Christopher Sunil Nazareth presented the petition seeking for probate, and in this petition, he arrayed his sister-in-law as the first respondent and her son as a second respondent.
grandson of
The-
the testator, my lord.
Husband of the first respondent had predeceased the testator. He also arrayed his wife, Diana Nazareth, was the daughter of the testator as the third respondent. In these proceedings, in this petition, by oversight, though the proceeding was a contentious proceeding, the matter was proceeded with and evidence has also been adduced by the legatee. And the respondents have also participated in the trial and cross-examined the witnesses of the petitioner. On 18/11/2022, this court allowed the application filed by respondent number,
One in two, my lord.
filed by the first respondent seeking production of additional documents. On the same day, this court also directed the petition to be converted into a testamentary original suit and formally disposed of the petition for statistical purposes. At that stage, why was it posted before this court again?
It was posted, my lord, on the application filed by them.
No, this amended written statement.
Amended plain point.
Acceptance. No, it was posted, my lord, when I filed some documents, my lord, certified copies. To accept that documents, my lord, it was posted before the court, that point of.
My lord, on 13/12/23, the TOS was numbered, my lord. Which page?
Ma'am?
Which page?
Page 52, 53.
52, page 52, 53, my lord,
Of other sheet.
and 57 of the other sheet.
Thereafter, the petitioner has paid the court fee
It was disputed.
as demanded by the. Kಟ್ಟಿದ್ದೀರಾ ಅಲ್ವಾ? Court fee.
Court fee has paid.
My lord, we have filed an IA saying for the proper court fee, my lord. Because they have,
From court fee receipt for paid to 62,030. Court fee paid the court fee.
my lord, that we have disputed, my lord.
113. Thereafter, the matter was posted for non-filing of amended plaint by the petitioner who became the plaintiff as a reason of the proceeding being a contentious proceeding. The office also raised the objection of non-filing of draft issues. And this court, by an order dated 9/7/2024, the office objection regarding non-filing of draft issues were overruled since witnesses already been examined. This court also permitted the earlier counsel to retire on the same day. Thereafter, the counsel appearing for 4, 5 respondents, 1 and 2 alva ನೀವು?
1 and
1 and 2 filed an additional written statement. And the office
Also IA number, my lord, 1 of 24. Regarding court
The
fees, my
matter
lord.
for filing of objections to IA 1/24. What is it, IA 1?
My lord,
Court fee, my lord.
court fee, my lord.
They said that I have
Because,
not paid sufficient court fee.
Insufficient court fees. 25 lakhs.
The property is situated in Mumbai, my lord.
IA
It's an apartment.
Direction to the petitioner plaintiff to pay the court fee on the suit subject matter as per the valuation returned by the payment by the state authorities, Mumbai.
That has to be considered.
What order is passed on IA number 1?
No, no,
Oh,
because the
objection
IA
has not
itself
been
is,
filed, my
they have not complied with the objections in that IA office objection, but it is not at.
That is submission I have
lord.
it.
It's only one. At
The
page
office
5,
has
my lord, of the,
raised objections on this application.
my lord, in word we have written as 25,000 instead of 25 lakhs, my lord. Enumeration is correct, my lord.
IA.
Page 5 of the IA, my lord.
Government pay the budget.
The office valuation.
Ma'am?
Office valuation.
This is not valid.
The office thereafter raised an objection that the amount stated in the affidavit
Page 5.
was to be clarified. To which the council has submitted that by inadvertence in the affidavit, it had been mentioned as 25,000 instead of
Please, ma'am.
25 lakhs.
In words.
In words, my lord.
The matter is thereafter posted before this court. Why should they pay court fee?
My lord, the value is not correct, my lord. The apartment is in Mumbai, Chembur, and they said it's only 25 lakhs.
Is the schedule for payment of court fee for probate?
Court fee.
It's mentioned
An
about,
estimation, isn't it?
Schedule 2, Article 18, Clause 2, Clause 1.
Schedule 2, my lord, Article 18,
That is for the caveat under 289.
that's the caveat.
Take this. Indian taxation.
Under which schedule are you saying that he should pay it on 25 lakhs?
In the will, my lord, the apartment in Mumbai. We'll also put get it at
No, that is the bill. Exhibit P22.
exhibit P22. Apartment number 8 of building D, measuring
Under which schedule do you want him to pay on,
on this property, my lord. Immobile property.
Court fees.
which schedule in the
Schedule.
stamp pad?
It's only regarding caveat, my lord. And just bring it your notice. We don't know how it's come to the value, my lord. Base is saying on 25 lakhs.
Which article are you referring to
Yeah.
for him to pay?
In affidavit, we have stated that.
It's in the affidavit, my lord, we have mentioned, it's only regarding caveat. When filed under the Indian Succession Act, and it says, my lord, the value of the property involved, that comes under Schedule 2, Article 18 to 1, my lord.
Madam, on a petition filed for probate,
Please, my lord,
what is the court fee payable? Under which article should he pay?
for probate, my lord.
And I'll file my objection, my lord, to that application. I'll file my objections. Because it's,
Not counsel for the petition plaintiff seeks time to file objections to the application filed by the respondent regarding payment of court fee. Relist on. I want to make it clear as to what is the procedure to be followed.
yes,
Please, my lord.
For
Please, my lord.
yes,
20th.
20th.
Bhargav ji,
Please,
160.
ತಗೊಳ್ತೀರಾ?
ತೊಂದ್ರೆ.
The counsel for the petition has filed a memo seeking for withdrawal of the writ petition. In my view, though, the land cost of the petitioner submits that he has instructions to file the memo. In view of the above, writ petition is dismissed as withdrawn.
Number 17. Manjunath Esvi.
During course of day, I will comply, my lord. Comply, my.
Seal number 18. Shri Shiv Prakasham.
Well, I moved the memo. Reason is, the matter arising in the execution.
Matter, my lords, we have a lengthy matter. Maybe will not be possible today, but some other day in this matter.
Let it be some other day or even after vacation. Now, why I moved memo is, now one property is a vacant land. It is now in the execution in FD proceeding. There's the question in this writ petition. The vacant land, these persons, even on the last occasion also, overnight they put up girders and they will lease out to the warehouses. Now also, yesterday and day before yesterday, that vacant land,
Petitions filed against which order?
Mala,
Petitions filed against which order?
the order is,
The order in Pune.
this is on,
Milord, delivery of possession by demolishing the buildings, milord.
no,
I am the decree holder. I am supposed to get the property.
The order that is challenged is writ petition.
now, the delivery of warrant after the appointing commissioners and commissioner report, everything. is
Delivery
over.
warrant, milord, it
Now-
is,
Now, I will make my
your lordship would get it at page number 20, it starts at page number annexure A.
24
Operative
months.
portion is 24, milord.
In it, call it. It's all right. Take my time.
What was the decree for?
There are about,
Partition, milord, partition, final decree drawn. It has become final. It is thereafter, milord, delivery warrant was issued.
there are about 32 items.
You are which ADR?
My lord,
What is your rank in this FDP?
I am one of the defendant. Dependent.
You
Now,
did
in
not
super,
challenge the decree.
my lord, everything is over. Now, finally, the,
Challenge ಮಾಡ್ರಿ really, everything's over ಗೊತ್ತಾಯ್ತು ನಂಗೆ.
ಹೌದು.
Decree challenge ಮಾಡ್ರೆ
The
ಮಾಡಿ.
important issue in this matter, may I kindly take my lord to order passed on 23/8/2024 before the sample court. 23/8/2024.
Would it be taken up on some other day, milord?
It can be, even
Give
I
the
am,
synopsis, milord.
even I am
Yes,
also requesting.
yeah, yeah.
Reason why I
Right,
moved
right,
is,
right. Fine, fine.
my lord,
no issue.
dated is 23/8/2024 of this sample court. And again on 9/9/2024.
Yes. Yes.
That's the one property, one item property. It was agriculture land and it was vacant land. Now a portion is my dwelling house. Rest of the thing is vacant land. That has to be divided only and by appointing through the Tahsildar under section 54.
Final decree has not been challenged.
It has not been challenged, but on the final decree, they have misrepresented, obtained in my absence. That's what I stated.
Challenge the final decree or not?
Final decree is not challenged, Malad.
What is the effect of you not challenging the final decree? Can you raise any objection?
Malad,
Execution.
when they have played fraud on the court, that's the point, because it was argued.
Can the execution nullify the final decree?
To nullify the final decree, it may not be possible, but one property where the law and statute requires, how it has to be divided.
Can that be gone into an execution once you don't challenge the final decree?
Malad,
Can you raise this objection?
No, in the final decree also, that is the observation made with the humble court. May I kindly take the page number is 29, Malad?
Where is the final decree?
Final decree is 2014. My page number is 20. Final decree they have not produced.
Without you challenging the final decree, what is the point in you fighting?
My
the
lord,
execution?
one by one I am taking, because it has got some lengthy issues where
ಎಷ್ಟೇ issue ಆದ್ರೂ final decree challenge ಮಾಡ್ಲೇಬೇಕು ತಾನೆ. If you have not challenged the final decree, matter comes to an end.
final decree bandiro.
Only to execute that final decree. If you have not changed the final decree, what is the point in you raising all kinds of objections in the execution?
My lord, 1 minute. I am in the what is the finding given in the final decree is one thing. That final decree they have to execute. Now, other than this final decrees order, now they are going. That's what I am now before the sample court. My lord, this is page number 29. This is final decree order, man. This is final decree order. It has made clarified. 29, page number 29.
Yes.
My lord, in the second paragraph, in survey number 2/3, that is item number 27, 14 of Gunta situated in middle portion of the land north-south in length is allotted to the share of plaintiff. This is one portion.
So the middle portion.
Middle portion is allotted to the
middle portion of the northeast. North-south.
Yes. This middle portion in a survey number in a land, they have marked it in a white paper and they are given, that is on the basis of their procedure. Next.
You have not challenged that illegal decree.
My lord, next.
Now, once you don't challenge the decree, you are bound by this decree.
I am bound by the decree and there is an observation, kindly, my lord. Next paragraph, my lord. Next paragraph. In the last paragraph, in the above allotted portion, there is reconstruction. The same area has to be allotted where the vacant portion is situated in the same land, in the same survey number. If other vacant portion is not available in the same land, the plaintiff is entitled the portion allotted to him by removing the construction, if any. This is so clear. Now,
What is so clear about this?
now this is about 2 acres.
In the above allotted portion, there is reconstruction.
Reconstruction of my house where I was dwelling.
So there is reconstruction. The same area has to be allotted where the vacant portion is situated in the same land, the same survey number.
Where vacant land is situated in the same land, same survey number. In the same survey number.
Other vacant portion is not available.
Yes.
In the same land, the plaintiff is entitled for the portion allotted to him by removing the construction, if any. So he is the plaintiff.
He is the plaintiff.
If the other vacant portion is not available,
Yes.
then your construction portion should go.
Yes, correct. That's the meaning. That's the correct, exact
Now,
meaning.
Is there a vacant portion there?
Now that's what I am before.
Is there a vacant
Yes,
portion?
vacant land is there. Now the vacant land, they want to deface it by putting construction and they want to say, my house is to be demolished.
Now, the finding of the trial court is in survey number 2/3, there is vacant land.
Yes, page number 57, my lord. Page number 57.
The photograph.
Photographs I produced. I produced and to show the evidence that the vacant land is still available and that vacant land is to be carved out and it has to be 14 of guntas is to be allotted to this plaintiff. That's one.
ಈ ಫೋಟೋ ಗೊತ್ತಾಗುತ್ತೆ ಅದು 2/3 ಇದು vacant portion.
ಸರ್ವೇರ್ ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ದಾರೆ, ಸರ್ವೆ ರಿಪೋರ್ಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಇಲ್ಲಿ ಸರ್ವೆ ರಿಪೋರ್ಟ್ ಇದೆ.
ಕಮಿಷನರ್ ರಿಪೋರ್ಟ್ ಇದೆ. ಇಬ್ರು ಕಮಿಷನರ್ ಟೆಕ್ನಿಕಲ್
No hurry to decide today.
ಆಗಕ್ಕಿಲ್ಲ.
If you want an interim order, you have to satisfy me.
ಹೌದು
that there is a
ಇಂಟ್ರಿಮ್
case.
ಆರ್ಡರ್ಗೆ ಈ ವೇಕೆಂಟ್ ಲ್ಯಾಂಡ್ ಇದೆಯಲ್ಲ ವೇಕೆಂಟ್ ಲ್ಯಾಂಡ್
Interim order is already there.
ಸೆಕೆಂಡ್
There is an interim order which is operating.
ಏನಂತದೆ interim order?
ಕೆಳಗಡೆ ಕೊಟ್ಟು ಆರ್ಡರ್ ನ ಸದ್ಯಕ್ಕೆ ಸ್ಟೇ ಆಗಿ
ಎಕ್ಸಿಕ್ಯೂಷನ್ ಸ್ಟೇ ಮಾಡಿದ್ದಾರೆ
ಇನ್ನೇನ್ ಬೇಕು?
ಬಂದೆ ಸ್ಟೇ ಮಾಡಿದ್ದಾರೆ. ಈಗ ಈ ವೇಕೆಂಟ್ ಲ್ಯಾಂಡ್ ಯಾವ್ದು ಇಲ್ಲ, ಈ ಮನೆನೇ ಹೊಡೀರಿ ಅನ್ನೋದು ಒಂದೇ ಒಂದು ಪಾಯಿಂಟ್ ಪ್ರೋಗ್ರಾಮ್ ನಮ್ಮ ಇವ್ರದ್ದು ಹೆಚ್ಚಾಗಿಲ್ಲ, ಸುನಿಲ್ ಅವ್ರ ಕಡೆ
ಇಲ್ಲ, ಇಲ್ಲ.
ಬಹಳಷ್ಟು ಪ್ರೆಷರ್ ಅದು. ಆ ಕಾರಣ ನಾನು ಹೇಳೋದು
14
ವೇಕೆಂಟ್ ಲ್ಯಾಂಡ್ ದಯವಿಟ್ಟು ವೇಕೆಂಟ್ ಲ್ಯಾಂಡ್ ಡಿಫೇಸ್ ಮಾಡಿ ಅಲ್ಲಿ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡ್ತೀರಾ ಆಸ್ ಇಟ್ ಈಸ್ ಇದ್ರೆ.
ನಂಗೆ ಒಂದ್ ಅರ್ಥ ಆಗ್ತಿಲ್ಲ. ನಿಮ್ಗೆ ನಿಮ್ ಮನೆ ಉಳಿಸ್ಕೋಬೇಕು.
ಹೌದು,
ನಿಮ್ ಮನೆ ಉಳಿಸ್ಕೋಬೇಕಾದ್ರೆ ಬೇರೆ ಖಾಲಿ ಜಾಗ ಇರ್ಬೇಕು.
ಹೌದು.
ಖಾಲಿ ಜಾಗ ಇದ್ರೆ ನಿಮ್ ಮನೆ ಉಳಿಯುತ್ತೆ.
ಹೌದು,
ಖಾಲಿ ಜಾಗ ಇಲ್ಲ ಅಂದ್ರೆ ನಿಮ್ ಮನೆ ಹೊಡೆದಾಕ್ಬೇಕಾಗುತ್ತೆ.
ಕರೆಕ್ಟ್.
ನಿಮ್ಗೆ ಡೆಲಿವರಿ ವಾರಂಟು ಸ್ಟೇ ಆಗಿದೆ.
ಹೌದು,
ಅದಾದ್ಮೇಲೆ ಇನ್ನೇನ್ ಎಂಟ್ರಿ ಮಾಡ್ಬೇಕು?
ಅದಾದ್ರ ಮೇಲೆ ಈಗ
ಮಾಡ್ರಿ ಏನ್ ಬೇಕು ಅಂತ
ಬಂದೆ ಅವಸರ ಬೇಡ. ನೆನ್ನೆ ಮೊನ್ನೆ ಇವರು ಈ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಯಾಕಂದ್ರೆ ಒಂದು ಪೋರ್ಷನ್ ಆಲ್ರೆಡಿ ಈ ಗಾರ್ಡನ್ಸ್ ಹಾಕ್ಬಿಟ್ಟು ಶೀಟ್ಗಳು ಹಾಕಿ ವೇರ್ ಹೌಸ್ ಅಂತ ಕೊಟ್ಬಿಡ್ತಾರ. ಈಗ ವೇಕೆಂಟ್ ಲೈನ್ ಎಲ್ಲ ಹಂಗ್ ಮಾಡ್ತಿದ್ದಾರೆ. ಅದು ಯಾವ್ದು ಇದು ನೇಚರ್ ಆಫ್ ಪ್ರಾಪರ್ಟಿ
ಯು ಆರ್ ಅಕ್ಸೆಪ್ಟಿಂಗ್ ದಟ್ ಯು ವಿಲ್ ಹ್ಯಾವ್ ಟು ವೆಕೇಟ್.
ಇದನ್ನ ವೆಕೇಟ್ ಮಾಡ್ಬೇಕಾಗಲ್ಲ.
Why are you worried about the other vacant portion?
ವೇಕೆಂಟ್ ಪೋರ್ಷನ್ ನಾಳೆ ದಿನ ಇವರು ದೇರ್ ಡಿಫೆನ್ಸ್ ಇಸ್ ದೇರ್ ಇಸ್ ನೋ ಸಚ್ ವೇಕೆಂಟ್ ಪ್ಲೇಸ್, ಸೊ ಮೈ ಡ್ವೆಲ್ಲಿಂಗ್ ಹೌಸ್ ಇಸ್ ಟು ಬಿ ಡೆಮಾಲಿಶ್ಡ್ is there only one point program in this entire matter. There is no availability of vacant land. So when there is no availability of vacant land, my dwelling house to be demolished is their warrant.
You are disputing that there is a vacant portion?
Lord, the commissioner has given the report also, saying that there is no vacant portion. The trial court also specifically holds that it is not the case of the petitioner before the Supreme Court, there is availability of vacant land.
What is this
And-
argument? What is this argument on page 57? That it is vacant? That
Insofar as a small portion is there, small portion, vacant portion is there, it is not 14.5 guntas. In fact, before the trial court, the other judgment at
was a portion of this page number 57?
yes, ma'am.
Vacant.
There is a small vacant piece of land is there.
Who's trying-
That is not up to 14.5, that is 14, it is not 14.5 guntas. It is not in my possession.
Who's trying to put up structure here?
I am not trying to put up any
There is no
construction.
construction which is being put up. Not kindly see me not. There were 4 brothers. 1 minute, I'll just.
Both of you make a statement that you won't put up a structure in page 57? That photograph?
I am not putting up any
His
construction.
his argument is.
Photographs, these are all very old photographs.
ಅಲ್ಲ ಈಗ
This is not the state of-
ನೆನ್ನೆನೆ ತಗೊಂಡು
What
ಮೊನ್ನೆನೆ
the
ವೇಕೆಂಟ್
nature
ಪ್ಲೇಸ್
of-
ಇರೋದು
For
What
one
up, sir?
point, Minutes, I'll just point out the nature of the order passed was, Minutes. There were 4 brothers. There were partitions which were executed between.
Order. If you want to be arguing on merits, I'm ready.
Not today,
You
Minutes.
don't want to argue on merits today.
We don't.
Both of you want time. His argument appears to be that if there is a vacant portion, his house will be saved. In order to ensure that his house is
Vacant
demolished.
Yes,
Listen, in order to ensure that his house is demolished,
Yes.
you are trying to build a structure on this particular vacant portion, which will.
That is.
That is his apprehension. So therefore, are you prepared to make an undertaking?
May I just clarify that? Your lordships, I understood his apprehension. Minutes. Vacant portion in the land which was allotted to him. Kindly see Minutes. We had a partition between 3 brothers. The 4th brother Minutes said, I have not received my share. He filed a suit. Minutes. In the land which was allotted to all of us, Minutes, a portion of the land was Minutes directed to be given to the 4th brother who came up in the suit for partition. Minutes. I have already given away my land, Minutes, which I had to give to this, my 4th brother. Minutes. The argument of the other brother who is there before the court is, no, I won't give any inch of my land in my portion. Everything will have to be taken from the others. This is his argument. This is the argument what he's trying to make before the court.
Final decree merely states.
Final decree stated that
There is a construction in the portion allotted to him.
correct, Minutes. And
If
correct,
there's a vacant portion,
correct, Minutes.
that should be allotted to the other brother.
The vacant portion as on that day.
If there's no vacant portion, then his house will have to go.
Correct.
Minutes, his house will have to go, one part of it, Minutes, his house will have to go. Minutes, he has received more land in the said portion. That is why I said, Minutes, it is not going to, we will require some time because there are voluminous records in the matter. Minutes, now they are saying,
That is why I said, if you're not ready to argue the matter today, in this, he's referring to page number 57.
he's having a
If all of you undertake that you will maintain status quo in respect of this particular plot mentioned in page 57, I will simply record your statement and adjourn the matter.
Please, but I'll just take mention.
I am yet to get property, my lord. I don't have any property. He is supposed to.
ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಂಗಾರೆ ಇವತ್ತು ಮಾಡಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ನಾನು ಕೇಳಿ
ಆಯ್ತು ಸರ್.
ಇಲ್ಲ ಅಂದ್ರೆ
ಅಲ್ಲ ನಾನು ಹೇಳ್ತಾ ಇರೋದು ನಾನು question of me putting up construction does not arise.
you make the statement, record it
Yes,
and
my lord.
adjourn it. That is all.
Nothing has been allotted to me. I am not putting up any
He
construction.
has a point in the sense, in the event you put up some construction now,
Yes.
and that is used tomorrow to say that there is no vacant portion, therefore my house is to be
Yes,
demolished.
It is between them, my lord. It is
Therefore,
not.
if both of you make a statement that this page number 57 that is referring to will be maintained in the next date of hearing, I simply adjourn the matter.
I'll take note. One minute.
Yesterday,
I mean,
photographs I have
They
taken.
could have served us that in advance, but.
ಅಲ್ಲ,
We
member
should propose their apprehension, really, all right.
Photo, ಆ photo.
ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ, ಇಲ್ಲ ಅಂದ್ರೆ ಈ ಸ್ಟೇಟ್ಮೆಂಟ್ ಮಾಡಿ. ನಾನು ಐ ರೆಡಿ ಫಾರ್ both.
ಹದಿನೆಂಟರಿಂದ 20 ವರ್ಷ ಹಾಗೆ ಇದೆ,
ಎತ್ತಗಳು.
ಈಗಲೂ ಹಾಗೆ ಇದೆ.
ಅಲ್ಲ ಹಾಗೆ ಇದ್ರೆ ನಿಮ್ಗೂ
With respect
ನಮ್ಗೆ
to page 57, whatever is there at page 57, we will maintain.
ನಮ್ಗೆ ಏನು ಕಾಪಿ
status quo as it
ಕೊಡದೆ
stands.
ಹೇಳ್ಬಿಟ್ರೆ ನಾನೇನ್ ಮಾಡಿ.
Till the next. Yes.
You seen the photo that he is now produced.
ಕೈ ಕೊಟ್ಟಿದ್ದು ನೆನೆ ಸರ್ವೆ ಮಾಡಿ ಅದನ್ನೆಲ್ಲ ನೀವು ಕಾಲಮ್ಗಳು ಹಾಕಕ್ಕೆಲ್ಲ ರೆಡಿ ಮಾಡ್ತಾ ಇದ್ರು, ಅದು ಫೋಟೋ ತಂದು ಇಮಿಡಿಯೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಇದು ಬೇರೆ ಇದೆ. ನೋಡಿ ಇದನ್ನು ತೋರಿಸಿ.
I'll pass it over, I'll take it up at 2:30. Short. Whatever photograph he has produced.
ಒಂದೇ
ಸಾಹೇಬ್ರು ಹೇಳೋದನ್ನ ಕೇಳಿ. ಆಯ್ತು 2:30 ಹೇಳಿ ತೊಂದ್ರೆ ಇಲ್ಲ, ನೋ ಪ್ರಾಬ್ಲಮ್.
30 will not be there, sir. This is
Oh,
KP Sahib.
He has some inconvenience at 2:30, that's what he's saying.
This minutes, whatever is at page 2 of this memo, till next status quo can be made. ಅಷ್ಟೇ ಅಲ್ಲ, it's a concession being made at the course of the court. It is not that you deserve it.
ಓವರ್
Sorry,
ನೈಟ್
sir.
ಗರ್ಡರ್ಸ್ ಹಾಕ್ಬಿಟ್ಟು ವೇರ್ ಹೌಸ್ ಕೊಟ್ಟಿದ್ದೀರಿ, ಅದಕ್ಕೆ ನಾನು ಬರ
ಏನು ಸುಮ್ನೆ ಪ್ರತಿ ಸರಿ ಹಾಗೆ ಹೇಳ್ಬಾರ್ದು. It has to be served prayer hands.
ಲಾಸ್ಟ್
Has filed a memo closing 2 photographs.
Wait.
He contends that this is the vacant portion that is referred to decree, and attempts are being made to put up a construction so as to create evidence that there is no vacant portion. Learned counsel appearing for the respondents, P. Sunil Rao,
Denies, that is not the portion what is referred.
but denies the said assertion. But however, they submit that the area shown in the photographs which are enclosed to the memo.
At page 2, minutes, page 2.
Shall be the character of the plot shown in the photographs enclosed to the memo at page number 2, 3 and 4. Which shall be maintained.
I am not doing anything, that's all. It is not given to me at all. It is not in my possession also.
Prakash Sahib, ಅದೊಂದು memo ಇದೆ ಕೊಡಿ, 2, 3, 4, 3 and 4.
Sunil Rao specifically states that the status quo as it exists today in the rest of the plot indicated in the photographs enclosed to the memo at page 2 and page 4.
That portion is in his possession, my lord.
Till the next date
It
of.
is in their
It is
possession,
in
my
my
lord.
possession.
I am the decree holder. I don't have anything, my lord. ಅಲ್ಲಿ ನಾನು SV ಭಟ್ ಒಂದೇ ಆಗಿದೆ, ಇವ್ರದ್ದು ಬರಬೇಕು ಅಂತ ನಾನು.
ಮಾಡಲ್ಲ, ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಲ್ಲ, ಇದ್ ಕಡೆ ಎಂಟ್ರಿ ಮಾಡ್ರು.
ಅಲ್ಲ ಸ್ವಾಮಿ,
there was a
I am not coming in the way. I am not coming in the way. It is not my property. I am not putting up construction.
Relist on.
and entry order earlier granted is to be extended. Available.
ಅಲ್ಲ, ಈಗ entry order is now sought to be made against me. What I am trying to say is that I am the person who is seeking for delivery of possession of this property. I am not doing anything. But on the other hand, one portion is in his possession, one portion is in their possession.
Main matter ಮುಗಿತಿತ್ತು, ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರು.
ಹೌದು ಸ್ವಾಮಿ,
I am ready to give my
ಅಲ್ಲ,
share of
ಇವ್ರು
that which has to go.
ಇವ್ರು 7.25 ಗಂಟೆ ಕೊಡಕ್ಕೆ ಇವ್ರು ರೆಡಿ ಇದೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ, ಇನ್ನೊಂದು 7.25 ಗಂಟೆ ಅವ್ರು ಕೊಡಬೇಕು.
That is the problem. That is the.
ಅಲ್ಲ, ಈಗ ಆರ್ಡರ್ is sought to be made against me. I am not doing anything. That is what I am saying.
ಅಂತ ನನ್ನ ಅಲಿಗೇಷನ್, ಅವತ್ತಿಂದ ಅಲಿಗೇಷನ್.
ನಿಮ್ಮ ಅಲಿಗೇಷನ್ ಏನಾರು ಇರುತ್ತೆ, ನೀವು ಏನಾರು ಹೇಳ್ತೀರಾ. ನಿಮ್ಮ ಅಲಿಗೇಷನ್ ಕಟ್ಕೊಂಡು ಏನಾಗ್ತದೆ?
Sri Prakasha KB.
Who's R13?
For the appellant, kindly 1 week time, I will bring the LS on the record of the.
ಅವ್ರ ಮಕ್ಳು ಇದಾರ, ಆಗ್ಲೇ ರೆಕಾರ್ಡ್ ಇದಾರ?
I will verify. Last time ಹೇಳಿದ್ದೆ.
R14.
R13.
R14 is the wife. Please notice that R14, 15, 16 and 17 are the wife and children of the deceased R13. So since they're already on record, no steps need be taken separately. Necessary note be made in the cost rate. Make a note.
Kindly extend the interim order.
Number 20, Ravi HK.
Lord, the second purchases petition, my lord, PTCL proceedings. The grant is of the year 1964-65, my lord.
What
First
is your
sale,
what is the office objection?
Lord, office objection has been complied with, my lord. An office note is also made with regard to the petitioner's mother not being made a party in this petition.
There are 3 objections as to why you made somebody a party or something. Have you seen it?
Yes, my lord, because the petitioner was a minor.
Made any submissions to that?
Yes, my lord.
The first objection is R3 to be clarified in cost rate as per trial court.
Yes,
Who's R3?
Lord,
You not made you could have made a note on this, isn't it?
Lord, I have mentioned saying that she was the mother of the petitioner.
Where have you said? The office is raised an objection. R3 stated in your cost rate. Yeah, I think is not a party in the trial court. Then R2 from annexure B to be made a party in WB to clarify.
I'll verify now itself. I'll clarify.
Relist.
During the course of the day, I'll do it. Minor objection is that I'll do it.
You'll have to make a note on it.
I'll do it.
Number 21, MR Hiramata.
Lord, R4, my lord, was no more before the deputy commissioner. He was died before the deputy commissioner, my lord, and his LS already on record, brought on record before the deputy commissioner.
Stated by Land Council appealing for R5 to R9. But R4 had passed away during the pendency of the person for the deputy commissioner and his children. Yaro?
My lords, R5 to 9, my lords, are the children.
R5 to 9.
Before this court. And the Ali R8 to AE mad.
And they continue to be on record in this petition also. The said statement is taken on record and R5 to R9. They be treated as the LRs of R4. Necessary
Plus-
report be made in the cost rate.
This petition, my lord, the second application for restoration is filed.
Ready?
No, my lord. Raise time. Senior is out of.
Covered by lordship judgment, my lord.
Already ಇಲ್ಲ ಅಂದ್ರೆ ಬಂದಿರೋದು ಏನಕ್ಕೆ ಇವತ್ತು?
ಅಲ್ಲ ಅದೇ ನಾನು
The list.
dead.
20th. Number 22, Shri Shiva B. Raya. Till number 23, Shri Shiv Kumar N. Till number 24, Shri Sundar Rama.
Office objection, I'm told, Lord, is only that 2 of the defendants who had not yet been served, Lord, at that point in time, were not made parties to the writ petition.
Different number 2 and 3 of OS code to be made as party to the.
They were not made because they had not yet appeared before the court at the time when this
You
application
have
was
to make
taken.
them a party.
Beg your pardon, Lord?
You still have to make them a party, isn't it?
That's not done, Lord. I'll make them a party if requirement because the plaintiff filed the application for amendment. That application for amendment is allowed. I'm the defendant who contested the matter at that point in time.
You're challenging an amendment being allowed. What was the amendment sought for?
The amendment sought for, Lord, was according to us a mutually destructive plea. There's only one ground I'm going to argue, Lord. The plea that is taken is mutually destructive and that amendment cannot be allowed.
They take the consequences, isn't it?
No,
Why are you-
that's what, of course, some judgments seem to indicate that if it's a mutually destructive plea, then you cannot allow that.
It's to
amendment.
your benefit, isn't it? Why are you opposing that such?
No, that's true, but I'm saying the plaint itself on the face of it is not maintainable. But now the plea taken is exactly opposite of what they've said. The plea, my lord, it's a suit, my lord, for cancellation of a sale deed. The basis is that consideration under the sale deed which they had agreed upon was not paid. That's the argument. That, of course, not as to whether that is ground to set aside a sale deed is one question. That is one part of it. Now, then they say, and file an amendment application to say, give me the value of the consideration you've not paid. Now, why they are mutually destructive is because on the one hand, your stand is that the entire transaction is gone by fraud or the entire thing is created by fraud.
Alternative plea, isn't it?
No, but it's not an alternative plea. It's a destructive plea.
If they don't succeed in the cancellation, at least let us get the money that is due under that particular document is what they seem to be saying.
True.
Why are you opposing that?
Because, my lord, the reason is the suit as filed could never have been maintained.
That is a different thing.
Correct. Therefore, no, why I'm saying this is you can't have a scenario where, especially in the case of fraud, you either have to take a stand that it is fraudulent, or you have to take a stand that you're entitled to recovery of money, because the position is, in the first case, if you argue, you're saying that the transaction itself is invalid in law. In the second scenario, you're arguing that the transaction is valid in law.
In the alternative,
No, it can't,
What
that
if
can't
it's-
be in the alternative.
you take advantage of this. Why are
That
you-
can't be in the alternative, my lord.
It is in the alternative.
No, I'm
Suppose-
saying-
Suppose they don't succeed in the suit for cancellation. What is the remedy?
You can't get money.
Suppose they're able to establish that they were not paid the money. Why can't they claim money also?
I'll tell you, Lordship. What can be in the alternative is, in a suit for specific performance, you can say either grant me specific performance or damages and refund in the alternative. But when you take a stand of fraud that vitiates the entire transaction, then you cannot turn around and say that if I don't prove fraud, I will say that the transaction is valid and therefore I should get the money. It's like not saying either I am owner of the property by virtue of title or by adverse possession. If I fail in this, then you give me adverse possession. It is exactly contrary.
I plead fraud. If the court says, no, you're not able to establish fraud.
That's the end of it.
But if you're able to establish that under the transaction, you were supposed to pay him some money and that money was not paid, can't the court say pay the money to him?
Well, in my humble submission, I understand.
And get away with not paying money to him?
Therefore, you have to take one position in cases of this kind.
You can't dictate terms to him as to what is the
No,
fee that he takes.
of course, he can say whatever he wishes. That's an election he has to make. Insofar as he's concerned, he'll have to elect as to which of the two stands he must take. If he says,
Take advantage, Dhyan. Why do you oppose this? Take advantage.
no, then your lordships may leave all questions with respect to mutually destructive
You
plea
have to
open.
file the written statement, isn't it? You always have this right to file.
No,
whatever
now the
defense you want.
court not says it is not a mutually destructive plea. That not couldn't have been made.
This petition is filed challenging an order by which an amendment to the plaint has been allowed. It is a case of the learned senior counsel that under the amendment, a mutually destructive plea has been raised, and this mutually destructive plea would not have been allowed by the trial court. In my view, it is for the plaintiff to choose the pleas that he wishes to put forth before the court. So the question as to whether the pleas are mutually destructive or not will have to be determined after trial. So I therefore find no reason to interfere with this said order. It is however made clear that all contentions that are raised regarding the pleas that have been advanced by the plaintiff under the impugned order shall be kept open to be decided on merits.
The issue of mutually destructive plea can be
All
kept
pleas
open.
have said
All
all
pleas. Right. All pleasure.
Number 25.
On humble submission, Your Lordship. Serial number 23, Your Lordship. By the time we reached here, it was adjourned. We wanted to refer the matter to the Lok Adalat, Your Lordship.
CST matter in local matter.
Respondent number 3 and the petitioners have come to a compromise, Your Lordship.
I can't refer it to local. How can I refer? You are for the purchaser.
Yes, my lord.
Then how can there be a compromise? ಆಗಲ್ಲ ಬಿಡ್ರಿ ಅದು.
It's an action property. ಕಿಮ್ಮತ್ ಕಟ್ಬಿಟ್ಟು ತಗೊಂಡ್ರ ಅಂತ.
ಏನ್ ರಚನೆ ಮಾಡ್ಕೋಬಹುದು? The order of the retribution has to be set aside.
Yes, my lord.
Can that be set aside by consent?
But it's not an SCST property, my lord. Grant property.
Be done by the local. By consent, can you say that the DC has no jurisdiction? That should be a judicial order. It can't be referred to local.
Yes, my lord.
ನೀವು ಏನ್ ಮಾಡ್ಕೊಂಡು ನೀವು ಮಾಡ್ಕೊಳ್ಳಿ ಬಂದು ಹೇಳಿ ನಾನು.
Yes, ma'am.
Serial number 25.
Entry mark.
25.
25.
I appear on behalf of petitioners, my lord. In this matter, there are two objections. One is with blank papers has to be stitched to the application. There's some urgency.
Urgency.
Well, it's the DC has ordered for resumption of land.
You are for the purchase or the grant?
We are for the purchases.
When was the grant made?
The land was granted on 29/5/1962.
1968.
First sale is on 28/11/1968. We are third purchasers, my lords. LS of third purchaser.
When was the application resumption filed?
Application was filed on 14/1/2015, my lords. After a lapse of 49 years.
CGP accepts notice for respondents. 1 to 4. Issue notice to respondents 6 to 5 to 7. Interim statement. In the meantime, petitioner shall comply with the office objections.
Grateful, my lords.
Number 26. Shri Garuda Mariappa.
Swami, only the office of business is to serve the copy on the KVATR. My problem is the KVATR address is the ಚಿಕ್ಕಬಳ್ಳಾಪುರ ಟೌನ್ ಅಲ್ಲಿ ಅಡ್ರೆಸ್ ಹಾಕಿದ್ದಾರೆ ಸ್ವಾಮಿ. ನೆನ್ನೆ ಫೋನ್ ಮಾಡಿದ್ದೆ, ನಾ ಚಿಕ್ಕಬಳ್ಳಾಪುರದ ಒಂದು ಕಾಪಿ ಕೊಡಿ ಅಂದ್ರು ಸ್ವಾಮಿ.
ಅದು ಒಂದು ಸ್ಟ್ರಾಟಜಿ ಏನ್ ಮಾಡಕ್ಕೆ
ಲಾರ್ಡ್
without him.
Because the grant is the year 1964, sale is 74. After 35 years, they filed the PTCL before the learned AC. AC rightly allowed the matter, but however the learned this.
Notice for response. Ground counsel for the petitioner submits that the counsel who has filed the caveat is a resident of Chikbalapur and
Chikbalapura town, the address is Chittara Ramakrishna building, CB Pura.
The prayer made by the petitioner for grant of an interim order is being considered. Since under the impugned order, by virtue of the impugned order, the petitioner will be dispossessed. It is necessary to stay the operation of the order passed with the deputy commissioner till the next date of hearing. Release. Office objection completely.
ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ, ಇವಾಗ ನಾ ಮಾರ್ನಿಂಗ್ ಫೋನ್ ಮಾಡಿದ್ದೆ ಅವ್ರಿಗೆ.
To serve a copy of the writ petition by RPAD. Said statement is taken on record.
For hearing on seal number 27.
I appear for the petitioner in this matter, my lord. I have moved this IA seeking recall of the order dated 28/11/2024, by which the petition came to be dismissed for non-prosecution, my lord. The difficulty, my lord, is that I have not been receiving the SMS regarding the listing of the matter, which is why.
The CP of the year 2020.
Yes, my lord. There are multiple other interim applications that have been filed by the respondents. Those interim application issues are already framed. Those interim applications can be heard along at the time of final arguments, my lord.
My lords, the issues have already been framed by this honorable court, my lords.
What is the CP about?
My lord, this is a CP under the Admiralty Jurisdiction and Settlement of Maritime Claims Act 2017, my lord. My case is that I had supplied some fuel to the defendant vessel and I have been unpaid for it. That is the sum and substance of my claim, my lord.
You had the benefit of an order of arrest?
Yes, my lord. That order of there was an order of arrest that was passed by this honorable court. The order of arrest was challenged. Applications were filed under Order 7, Rule 10, Rule 11, challenging the arrest and seeking vacation of the arrest, my lord. My lord, Justice Punacha had passed a detailed order upholding the arrest and dismissing the applications in that regard that were filed by the respondent.
My lords, if I could make a kind submission, my lords. My lords, we had filed an application under Order 7, Rule 10 for return of plaint, my lords.
I'll recall the order. Now that they appear.
My lords,
they did not appear, therefore I dismissed it for non-prosecution. So I'll recall the order and post it for.
Yes, my lords. My lords, they need to file their objections to this, my lords.
To this.
My lords,
Recalling.
the application that we had filed, my lords, previously.
For the reasons stated in. IA 2/2024. The order dated 28/11/2024 dismissing the petition for default is recalled and the petition is restored. Objections be filed to the pending applications by the petitioner. Relist on.
May I make a suggestion, my lord? I will the petitioner will lead the evidence in this matter, my lord, and the IA that has been filed under Order 7, Rule 10 may be considered at the time of final hearing, my lord.
You first appear. File objections, then we'll go further.
Very well, my lord.
9 January. Make a note of this. You may not get an SMS again.
Very well, my lord. Obliged, my lord.
Seal number 28.
Number 4, my lord. Lords, I filed applications, my lord, to bring the legal aid of respondent number 4, and also, my lord, to come on record as the legal aid of petition, original petition. This is petition, my lord.
1, 2, 3 or R4.
R4.
R4, I
Put it sorted.
Yes, my lord. R4A, my lord.
ಬೇರೆಯವರು
ಅಲ್ಲ ಆಲ್ರೆಡಿ ಸರ್ವಿಸ್ ಆಗಿದಾವ್ರೆ ನೋಟಿಸ್.
ಒಬ್ರೇನಾ?
R4ಗೆ ಇನ್ನೊಬ್ರು ಎಲ್ಲರ್ಸ್ ಇದಾರೆ ಮೇಡಮ್ ಅವರು
R4A R4A
ಒಬ್ರೇ ಇರೋದು ಇನ್ಯಾರಿಲ್ಲ.
ಒಬ್ರೇ
ಮಗಳಿದ್ದಾರೆ ಮೇಡಮ್. R4 ಇದಾರೆ, ಅವ್ರ ಡಾಟರ್ ಒಬ್ರು ಇದಾರೆ, ಲಾವಣ್ಯ ಅಂತಂದೇಳಿ. ಅವ್ರನ್ನು ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ, ಅವ್ರನ್ನು ಎಲ್ಲರ್ಸ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬೇಕು.
ಕೊಡಿ ಡೀಟೇಲ್ಸ್ ಕೊಡಿ. ಅವ್ರು
Details
ವಕಾಲತ್ ಹಾಕ್ತೀರಾ?
ಪ್ಲೀಸ್ ಮೇಡಮ್,
ಹಾಕ್ತೀರಾ ವಕಾಲತ್ತು?
ಪ್ಲೀಸ್.
Land Council appearing for R4A submits that apart from R4A, there is another legal representative of the deceased R4, that is Lavanya.
Yes, madam.
He submits that she also be implicated as R4B in the rate of the state submission, when necessary to allow applications filed under IA 1 to 3 to bring the LRs of R4 on record. And apart from R4A, the daughter of the deceased R4, that is Lavanya, is also ordered to be implicated as R4B. Cause date will be amended. Petitioner,
petitioners.
petition applications are also filed to bring the LRs of deceased first petitioner on record. Since the right to sue service, IA 1, 2 and 3 of 22 are also allowed.
Plus
Cause date will be amended.
what happens in this case, my lord? Original file is not available, my lord. Original writ petition is also not available.
ಇಲ್ಲ ಮೇಡಮ್, ಯಾವ್ದು ದಾಖಲೆ ನಮ್ಮ ಹತ್ರ ಯಾವ ದಾಖಲೆನೂ ಇಲ್ಲ ಮೇಡಮ್. ಅವರೊಂದು
NY Guruprakash advocate ಅವ್ರ ಹತ್ರ
ಅಷ್ಟೇ ನಮ್ಮ
ಅವರು ಇಲ್ಲ. NY Guruprakash appearing for the earlier appeared for petition. ಅವ್ರ ಆಫೀಸಲ್ಲೂ ಫೈಲ್ ಇಲ್ಲ, ಅವರು ಇಲ್ಲ ಸರ್. NY Guru
ಏನ್ ಮಾಡ್ಬೇಕು ಈಗ?
ಒರಿಜಿನಲ್ AC ಆರ್ಡರ್ DC ಆರ್ಡರ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ ಅಷ್ಟೇ ಸರ್.
ಯಾರು?
ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ along with memo.
What do you want me to do now?
Petition amend ಮಾಡಕ್ಕೆ there is non availability.
ನೀವೇ ಮಾಡಿ.
I will file fresh petition.
The Shri R. Sashidhara is permitted to amend the petition or file an amended petition as the case may be. The memo filed to treat R4 to R6 as LRs of deceased R3 is also accepted.
I may be permitted to file fresh petition.
ಹೇಳಿದ 2 ಕೊಟ್ಟಿದ್ದೀನಿ.
And my lord, NY Guruprakash name may be deleted.
ಒಬ್ಬರೇ petitioner ಆ?
ಒಬ್ಬರೇ petitioner, ಅವರೊಬ್ಬರೇ sole petitioner is no more.
Since R. Shashidhara has entered appearance for the petitioner, name of NY Guruprakash be deleted.
in another IA copies is not
1999 then.
And my lord, I am filed memo, my lord, to treat the LRs R4 to R6 as LRs of R3, my lord.
Accepted. 99 da.
ಹೌದು 2000 ಅವರು ಇದರಲ್ಲಿ ಅಪೇಟ್ ಆಗ
99 madam.
Number 29.
But I appear for the respondent. The application is filed by the first respondent. The matter was disposed of on the 28th of August 2023. Whereby my lords were pleased to confirm the order passed by the Education Appellate Tribunal, upholding the judgment in terms whereof the first respondent was directed to be reinstated, and my lords, the petitioner college was directed, my lords, to pay
What is
all.
the amount deposited here? What is the amount deposited?
It is 2,67,000. I have mentioned that in the prayer. 2,60,152 rupees. Not it is my mistake, my lord, that this was not brought to my lord's notice, which is why the application.
So he had an order for payment of back wages also?
He had an order, and that order was stayed by this honorable court, my lord, subject to deposit of this money, and my lord, subject to continuation of current pay, my lord, salary, which
But
was.
now that it is dismissed, he'll be entitled to that amount, isn't it? How can you be entitled to that amount?
Precisely, my lord, I am the respondent. I appear for the respondent. It is the respondent employee.
Who's for the petitioner? Who's for the petitioner?
Not earlier, it was Mr. SN Bhatt who was appearing, who is no more. I believe his colleague has filed wakalat on his behalf.
This petition filed by the management, challenging the order of the Education Appellate Tribunal, by which the Appellate Tribunal had ordered reinstatement, was dismissed by this court on 28th of August 2023. Now an application has been filed by the first respondent stating that an interim order was granted by this court staying the order of the tribunal subject to the petition management deposits of rupees 2,67,152. And since the petition has now been dismissed, the first respondent will be entitled to the said amount. In view of the fact that the petition has been dismissed, thereby confirming the order of the Education Appellate Tribunal, the amount deposited by the petitioners will have to be made over to the first respondent. Accordingly, the application is allowed or registry is directed to release the amount and deposit in favor of the first respondent.
I'm so great. So great.
Number 30, Sri Basuraj Bannu.
For respondent 1 and 2 in this case. Question is, my lord, unauthorized cultivation of land. Your lordship observe in the order sheet. My lord, the authorities at the time of.
The other documents are produced, my lord.
Once. Your lordship.
Pre-hearing dates, one of the other documents. were
Kindly
produced
for the
and
moment.
Put to surprise, my lord. On all the hearing dates, my lord, one of the other documents are produced. Later I'm put to surprise. These were back, my date is on 2015. These documents were never produced before that is assistant commissioner or deputy commissioner, my lord. And last hearing date, your lordships are directed for to secure the records, my lord.
Yeah.
One document notation is ಮಂಜುನಾಥ್ ನಿಯಮಗಳ ಉಲ್ಲಂಘನೆ ಆಗಿರುವುದಿಲ್ಲ ದರಖಾಸ್ತು ಇನಾಮತಿ ಆಗಿರುವುದಿಲ್ಲ.
Now can you invoke PTCL Act?
Please, my lord, kindly may pass on. We have engaged this. Kindly pass.
May I request? Kindly see the.
Pass over. You don't want me to pass it over.
For hearing, my lord, for hearing.
That's what he said. He wants a pass over.
Any date may be fixed, my lord. I'm ready for him. Senior is engaged, my lord.
Even ready na ilvo.
My lord, these documents, my lord, for kindly.
Ready na ilvo.
For the moment, these kindly peruse the documents that I have produced. These are the endorsement issued by the very authority stating that PTSL Act is not applicable.
He wants a pass over. You want me to pass it over or you want to?
For the purpose of, my lord, hearing, my lord, if they say they are ready for hearing, I will also ready. I am also ready. My lord, but they are not making submission that whether it is for hearing or, my lord, for.
My lord, I said that. Let the panel come. I'm ready
Later,
for.
my lord, because later they should.
The authority is present.
20th.
19th. Sir?
19th.
My lord, I may kindly be allowed, my lord.
Next week ಮಾಡ್ತೀನಿ.
Alla, my lord, what happened is, for the moment.
Filed is not filed objection.
No, my lord. No, my lord.
So number 31.
Objections filed, my.
Lying. Ajay Kalyan.
ಐ ಅಲೋ ಮಾಡ್ಬಿಟ್ರೆ ತಿರ್ಗಾ ಈ ಕ್ಯಾಟಗರಿ ಬರಲ್ಲ. ಬಿ ಗ್ರೂಪ್ ಗೋ ಇಯರಿಂಗ್ ಬಂದ್ಬಿಡುತ್ತೆ. ರೀಚ್ ಆಗಲ್ಲ. ನಿಮ್ ಚಾಯ್ಸ್.
Last time it is reached, my lord, it is reached. B group, it is reached.
ಅವಾಗ ಒಂದು documents produce ಮಾಡಿದ್ರು. ಮೊನ್ನೆ I was served, day before yesterday, a copy was served.
Ship sees the.
And all hearing dates, fresh documents are produced.
Kalyan, seal number 31.
ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ದಾರೆ ಮೇಡಮ್.
My lord.
I'll dismiss it again then.
2-3 days time, my lords. The RTC, handwritten RTCs of 1965, we have approached the authorities. Or as with regarding to the other
1
documents.
week's time is the last chance.
Yes, my lords.
20th. Seal number 32, Sri Jagdish.
For the petition, kindly 2 weeks to comply the opposite objection dismissed for non-compliance.
Extending the order date 18/1/2024. Petition is granted. Weeks time to comply with the officer.
2 weeks, my lord. Type to comply. Can be 2 weeks, my lord, please.
Seal number 33. Aishwarya Hegde.
This case, I am appearing for respondent.
Please, my lord, appearing for the
6 and 7,
petitioners. My lord, the petitioners are the LRs of the original grantee, my lord. The grant was
First filed the application for vacating. First filed the application for vacating stay.
the respondent 6 and
6 and
7,
7,
my
my
lord. Then VC.
Are you ready?
Yes, my lord, I am ready.
You are for the purchase of the grantee.
Grantee, my lord. Were the LRs of the original grantee.
What is the stay that you obtained?
My lord,
What is the stay granted to you?
my lord, stay of the order dated 21/2 of 2023 passed by the deputy commissioner, my lord.
That was dismissing your appeal.
Please, my lord, my appeal was not entered in on the fact that there were 28 years of delay in approaching the DC.
What is the stay that you?
Stay the operation of the order dated 21 to
Not
2020.
understand.
Please, my lord.
The 6th sale.
Please, ma'am.
And you made an application when?
My lord, the first application to restore the land was made in the year 1983.
81, my lord.
81, 82, my lord.
81, 82, my lord. And it was restored in the year 1983. 3 acres of the land was restored back to the original grantee. My lord, thereafter, respondent number 5 preferred an appeal before the DC. And as per the order dated 7/5/1985, the matter was remanded back to the AC. My lord, then again, as per the AC's order dated 5/5 of 1986,
Within
2
30
acres of land was restored and 1 acre was
Yes, my lord.
held valid.
And why was it dismissed?
1 acre land was related after the period, my lord, after 18 years. That's why.
First instant, my lord, 81 application, it was allowed, my lord. Second time, my lord. After remand, my lord, he says, Supreme Court delay ಅಂತ ಹೇಳ್ತಾರೆ.
Annexure E, my lord. Deputy Commissioner has.
Within 4 years, application.
Yes, my lord. Within time they have filed.
The application for restoration is filed within 4 years, isn't it? The application for restoration is filed within 4 years.
Yes, my lord. In respect of 2 acres, in respect of 1 acre, it is after sale after 18 years, after prohibitory period. That's why the Deputy Commissioner has passed in respect of 1 acre. Another 2 acre.
You are concerned only with 1 acre?
Yes.
Yes, my lord. 1 acre.
That is in 72.
Please,
Yes, my lord. 53, 54 is grant.
Please, my lord.
Before the act came into force, beyond the period of alienation.
Please, my
Then
lord.
what is wrong?
My lord, no permission has been obtained, my lord.
This first sale is 72 before the act came into force.
No, first sale was in 66, my lord. The year
That was in respect of 2 acres.
2 acres.
That was in
The
respect
second
of
sale was in
Was
respect
in
of
the
1
year?
acre.
Please, my lord.
That is beyond the period of alienation.
Please, my lord.
Before the act came into force.
Please, my lord.
Then what is wrong?
My lord, be it may, my lord, we have been in possession for more than 71 years now, my lord.
How?
My lord, even in the RTC, it's reflected. Only in the year 2015, after the death of the original
We have
grantee,
sold the land. We have sold the land beyond the period of non-alienation.
Please, my lord.
Then you can't challenge that sale deed.
My lord, with all fairness, my lord, we have been in possession for more than 70 years and still in possession, and we are
No, my
continuing with that,
lord. No, my lord.
Jana. That is all.
My lord, even in the RTC, and it's still reflects our name, my lord.
That is only ground, Madam DCS.
Yes, yes, my lord. That is the only 1 acre pertaining to my lord. He says 1966 and 77. Page 32 will clear it.
Page?
Page 32, my lord.
32 or no, page 41. Next H alva.
Annexure H, my lord.
Annexure H 41 ಅಲ್ಲಿ ಪ್ಯಾರಾ 6 ಪ್ಯಾರಾ 6 ಅಲ್ಲಿ ಕ್ಲಿಯರ್ ಆಗಿ ಹೇಳಿದೆ.
Yes, my lord. Annexure H, page 30.
Page 45, my lord.
My page section 32, ಅದೇ para 6
Ah,
ಅಲ್ಲಿ
that is in page 4.
ಜಿಲ್ಲಾಧಿಕಾರಿಗಳ ದಿನಾಂಕ.
Please. The all of the petitions were granted 7 acres 38 guntas of land in survey number 68 in Belliganuru village of Kadur Taluk. The father of the petitioner sold an extent of 2 acres 7 guntas, 2 acres out of this said 7 acres 38 guntas on 36/1966. Year 1 Mallappa and retained the remaining 5 acres 38 guntas. Next paragraph. On 10/4/1972, the father of the petitioners sold 1 acre of the 5 acres 38 guntas that he had retained in favor of one Chennappa, and Chennappa in turn sold the land in favor of the fifth respondent here. As on the date of the grant in the year 51-52, the period of non-alienation was 15 years, madam.
Yes, madam.
15 years.
Please, madam.
And thus the alienation made by the father of petitioners in respect of 1 acre out of the 5 acres 38 guntas that he had retained in favor of Chennappa was beyond the period of non-alienation. In other words, the alienation made by the father of the petitioners in respect of 1 acre in favor of Chennappa cannot be an alienation in violation of the terms of the grant. The Deputy Commissioner, by the impugned order, has noticed this fact and has allowed the appeal of the purchaser. In my view, since the alienation by the grantee was beyond the period of alienation prescribed under the terms of the grant, and before the act came into force, the order of the Deputy Commissioner is just and proper and does not warrant any interference.
My lord, liberty to approach the civil court, my lord. We're in possession for more than 70 years, my lord. We are still in possession. Lord,
No, my.
liberty to approach, seeking.
R. Shashidhara.
The interim order is granted by this honorable court on 12/7. Alas, directed me to pay process fee within a week, my lord. I could not able to pay the process fee, my lord. That's why I filed application to modification.
Vacate ಆಗೋಗಿಲ್ಲ.
ಇಲ್ಲ, vacate ಆಗಿಲ್ಲ. ಮತ್ತೆ next date ಅಲ್ಲಿ extension ಆಯ್ತು. Next date ಅಲ್ಲಿ extension ಆಗಿದೆ.
ಮಾಡಿಫಿಕೇಶನ್ ಹಾಕೊಂಡಿದ್ದೀರಾ?
ಅದೇ ಅದು ಲಾಸ್ಟ್ ಕಂಡೀಷನ್ ಮಲಾಡ್ ವಿತಿನ್ 5 days ಅಲ್ಲಿ ಪ್ರೊಸೆಸ್ ಮಾಡಬೇಕಂತ.
Who's R4? ಎಲ್ಲ ಸರ್ವಾಗಿದ್ದಾರಾ?
ಎಲ್ಲ ಸರ್ವಾಗಿದೆ.
My humble request, my lord, the site was already restored to me, my lord, in the year 2016 itself.
That is not the issue before this honorable.
No, that is the issue, my lord, because he has purchased subsequent purchaser and everybody coming before this honorable court subsequent purchasers.
Covered by judgment, my lord.
Now already restored, my lord.
No, not restored.
Allah, in this case, kindly maybe look into my lord order. Annexer R5 to 6, my
Very
lord.
same AC order and DC order is very same AC order and DC order.
Allah, when 21 years after lapse, my lord, they are coming, questioning the AC order and DC order, which is confirmed in the writ appeal.
ಅಲ್ಲ, ಅದು ultimately this court has quashed this order ತಾನೆ?
Yes, ma'am.
That is why I have followed that order as a coordinate bench.
My humble request, my lord, kindly maybe restored, already restored the site, my lord, 2016 itself. I am paying tax to the TMC municipality, my lord. More than 14,000 I am paid already.
Naikre, the impugned orders have been set aside in WP. Which is the WP?
10360 of 22, my lord.
Then what else can be done?
Allah, my humble request, my lord, particularly writ appeal was already confirmed. The same site holder, they have come over only after lapse of 5 years. Their writ petitions are dismissed.
Magdum Sahibar order challenge ಮಾಡಿದ್ರೆ ಏನು ಮಾಡಿಲ್ವಾ?
ಮಾಡಿದೀವಿ, already writ appeal is pending.
ಅಷ್ಟೇ, ಇನ್ನೊಂದು writ appeal ಜೊತೆಲಿ.
ಅಲ್ಲ, ಸುಮ್ಮನೆ ಎಲ್ಲರಿಗೂ ತಗೊಂಡೋಗಿ ಹಾಕೋದಕ್ಕಿಂತ
ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ?
ಪೆಂಡಿಂಗ್ ಇಡಿ ಸ್ವಾಮಿ, ತಾವು ಪೆಂಡಿಂಗ್ ಇಡಿ writ appeal.
ಎಕ್ಸ್ಟ್ರಾ ಕೇಸ್ ತಾನೆ.
ಅಲ್ಲ ಪೆಂಡಿಂಗ್ ಇಡಿ ಸ್ವಾಮಿ, ಅದನ್ನ ಚಾಲೆಂಜ್
ಬೇಡ, ಬೇಡ.
ಮಾಡಿದೀವಿ.
It is not in dispute that the orders.
ಅಲ್ಲ
included
ನಾಟ್ ಡಿಸ್ಪ್ಯೂಟ್ ಅಲ್ಲ, ಆಲ್ರೆಡಿ ರಿಟ್ ಅಪೀಲ್
where
ಇಸ್
the
ಪೆಂಡಿಂಗ್.
subject matter of WP 10.
My learned friend is also known about the writ appeal.
This court by. and according to
ಅಲ್ಲ
this
at
court,
least ನಮ್ಗೆ ರಿಸ್ಟೋರ್ ಆದದ್ದಾದ್ರೂ ತಾವು ಹೇಳ್ಬೇಕು ಸ್ವಾಮಿ. ನಾವು ಪೊಸಿಷನ್ ಅಲ್ಲಿ ಇದೀವಿ ಈಗ.
had allowed the writ petition and quashed the orders of resumption passed by the assistant commissioner, which were also confirmed by the deputy commissioner. This order of the court in which has been followed by this court in WP 19558 for 2022 and connected matters by a separate order dated 8th of November 2024. In my view, in the light of the orders referred to above, this petition will also have to be allowed the same terms as in WP 10360 for 2022.
ಅಲ್ಲ my position kindly maybe look into my lord.
ನೀವು ಆ ರಿಟ್ ಅಪೀಲ್ ಹಾಕಿ ನಾಯಕರ ಟೈಮ್ ವೇಸ್ಟ್ ಮಾಡಬೇಡಿ.
Number 35.
ಸ್ಯಾಟಿಸ್ಫೈಡ್ ಮಾಡಿಸಿ ಅವಾಗ.
ರಿಟ್ ಅಪೀಲ್ ಹೋಗೋದು ಐತಿ ಸ್ವಾಮಿ. ಬಟ್ ವಾಟ್ ಅಬೌಟ್ ಮೈ ಪೊಸಿಷನ್ ಮೈ ಲಾರ್ಡ್?
If that was the argument, you should advance before Magdum Saab and got an order in your favor.
ಅಲ್ಲ this particular site my lord, they are the site owners, not land owners.
Yes.
But I appear for respondent number 10 and 11.
Respond number?
10 and 11, not 68 years, not delay in initiation of
I'll
proceedings.
file an objection to their IA.
But I will not argue on merits itself, not as a very short point. Land is converted.
See, ready.
But the issue is covered, not because not land is
File an
converted.
objection to their IA.
But may have it not next week itself, not the list. But can it be on not 17th or 18th?
19th.
19th. But with the understanding that the matter is covered, not this.
I have an understanding. I can't force him to get that understanding.
Allow. But my
19th
difficulty is.
19th.
But not may also note not that they'll not seek time, not because I have some difficulty.
You remind me that time. I'll not grant.
Very well, very well. Grateful.
For further consideration, see number 36. See number 36.
I have to put the
United.
My lord, 36. My lord, I beg to appear, my lord, I seek permission to appear through video conferencing.
Yes.
My lord, my party, my lord, is unable to, my lord, garner the amount, notwithstanding the efforts made by him. Therefore, my lord, matter may have to be argued on merits. I advise my party, my lord, but still, my lord, he pleads his inability to, my lord, to pay the 50%, which he has no sources at all.
ಮಾಡಿ ಹಂಗಾರೆ argument.
You Lakshman, can you have it on some other day? I mean, the part heard, my lord, after some time, my lord, waiting there, my lord, maybe. Obliged.
After.
Obliged.
Okay.
Date
17 January.
Obliged.
Before occasion, they have,
ಆಗಲ್ಲ.
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ, they have taken the interim order, my lord, they themselves have undertaken to pay 25% and taken the interim order.
Yeah, decide on merits.
Right.
No compromise. Decide on merits.
Please. Right, sir. Number 37, Srimati Anu Shayan.
ಏನಾಯ್ತು ಇದು?
4 weeks ಕೊಟ್ಟಿಲ್ಲ ಅಷ್ಟೇ, ಇನ್ನೆಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ. April 1st to April 24 ಕೊಟ್ಟಿಲ್ಲ ದುಡ್ಡು.
ಈಗ ಕೊಡ್ತಾರೆ ಬಿಡಿ, ಯಾಕೆ ಇದಕ್ಕೆ ನಾನು ಯಾಕೆ ಇಟ್ಕೋಬೇಕಿದ್ರು? ಮುಗಿತಲ್ಲ, ಬಂತಲ್ಲ ಸಂಬಳ ಬಂತಲ್ಲ.
ಅಲ್ಲ, ಅದನ್ನ ಒಂದು ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡ್ಬಿಟ್ಟು ಡೈರೆಕ್ಷನ್ ಟು ಪೇ ಫ್ರಮ್ April 1st ಅದು DMR ಕ್ರಿಯೇಟ್ ಮಾಡಿದ್ದಾರೆ, ವಾಪಸ್ ಬರ್ತಾ ಇದೆ ಹಂಗೆ.
But is petition survive? This petition survive for consideration?
ಎಸ್, ಅಲ್ಲ ಇಟ್ ಮೇ ಬಿ ಡಿಸ್ಪೋಸ್ ಅಷ್ಟೇ. ಅವರು ಈಗ VC-ನೂ ರಿಟೈರ್ ಆಗ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಟು ಬಿ ಅವ್ರ ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಇಲ್ಲಿ ಕೊಡ್ತೀವಿ ಅಂತ. ದೇ ಆರ್ ನಾಟ್ ಫೈಲ್ಡ್ ಅಫಿಡವಿಟ್ ಆಲ್ಸೋ. ಓನ್ಲಿ 4 weeks DMR ಕ್ರಿಯೇಟ್ ಮಾಡ್ತಾರೆ, ವಾಪಸ್ ಬರುತ್ತೆ, ತಿರ್ಗಾ ಕಳಿಸ್ತಾರೆ, ತಿರ್ಗಾ ವಾಪಸ್ ಬರ್ತಾ ಇದೆ.
ಮೇಡಮ್ ಏನಾಯ್ತು ಮೇಡಮ್ ಇದು?
ಓನ್ಲಿ 4 weeks ದುಡ್ಡು ಕೊಡ್ಬೇಕು ಅಷ್ಟೇ ಅವರು.
ಬಿಟ್ಬಿಡಿ 4 weeks ಏನಂತ?
ಅದೊಂದು ಅಬ್ಸರ್ವ್ ಮಾಡ್ಬಿಟ್ಟು ಇಟ್ ಕ್ಯಾನ್ ಬಿ ಕ್ಲೋಸ್ ಅಷ್ಟೇ, ಡಿಸ್ಪೋಸ್, ನಥಿಂಗ್ ವಿಲ್ ಸರ್ವೈವ್ ಅಷ್ಟೇ. ಇನ್ನೆಲ್ಲ ಈಗ ಕರೆಂಟ್ ಮಂತ್ ಕೊಡ್ತಾ ಇದ್ದಾರೆ. April 1st to April 24 ಕೊಟ್ಟಿಲ್ಲ ಅಷ್ಟೇ.
WP ಇದಲ್ವಾ?
37.3.
H ಪ್ರಕಾಶ್ ಯಾವುದು? H ಪ್ರಕಾಶ್
31, 37.1.
That is a survey for consideration. Where is Lakshmanarayana?
ಅದಿದೆ, ಅದು ಆಕ್ಚುಲಿ ಇಟ್ ಅಮೌಂಟ್ಸ್ ಪರಿಕ್ರಮ. Justice Bopanna order is there in Supreme Court in to even ಯಾರು ರಿಟೈರ್ ಆಗಿದಾರೋ ಅವ್ರಿಗೆ ರೀಇನ್ಶಿಯೇಟ್ ಮಾಡಬೇಕು ಅಂತ ದಟ್ ಇಸ್ ನಾಟ್ ಬಿನ್ ಟೇಕನ್ ಇನ್ ಸ್ಪೆಷಲ್ ಬೆಂಚ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಟ್ ಮಾಡಿದ್ದಾರೆ. ಬಟ್ ಸಿನ್ಸ್ ದಿ ಮ್ಯಾಟರ್ ಇಸ್ ಸೀಸ್ ಬಿಫೋರ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್, ದಿ ಸ್ಪೆಷಲ್ ಬೆಂಚ್ ಕ್ಯಾನ್ ಆಲ್ಸೋ ನಾಟ್ ಡಿಸೈಡ್ ದಟ್ ಇಶ್ಯೂ 65 years.
ನಿಮ್ದು ಯಾವ್ದು 37.3?
ನಂದು ಕ್ಲೋಸ್ ಮಾಡ್ಬೋದು. ಓನ್ಲಿ ದೇ ವಿತ್ ದ ಡೈರೆಕ್ಷನ್ ದಟ್ ದೇ ಶುಡ್ ಪೇ ದಿ ಅಮೌಂಟ್. ಎಲ್ಲ ಕೊಡ್ತಾ ಇದ್ದಾರೆ, ಓನ್ಲಿ April 1st to 24th ಕೊಟ್ಟಿಲ್ಲ ಅಷ್ಟೇ. Everything what they have undertaken, they have complied. With that observation, this petition can be disposed. Within some time, they have to.
But see the prayer of yours. You're asking for quashing of the order.
That has been done by this court because I am being reinitiated.
Like, if I dismiss the petition now, dispose of the petition without quashing annexure A, they'll throw you out again.
Pardon?
If I dispose of the petition, directing them only to pay that 14 days salary, your prayer in the petition becomes.
No, as a university professor, I am entitled to serve till 62 years. In parity, that is what this court has observed for the other Prakash and other role. Like them, there is an order for me to continue till 62.
I will release it from parted. Let it go to the regular bench. Release from parted.
And that your lordship may kindly order for that ಅಲ್ಲ, ಯಾಕಂದ್ರೆ your lordship has reinitiated me back to service. The annexure A will not survive. Once I have been reinitiated.
Let it come to the regular bench. My intention was that you get your salary.
And also your lordship was pleased to reinitiate me back to service. So the petition does not survive even if
make a statement and dismiss it as withdrawn.
Disposed as for the interim order. Your lordship has reinitiated me back. My prayer was not to terminate my service.
For admission. Number 38.
For petition, not.
Over, yes, Arjun.
Not petition filed by the wife, not divorce petition filed by the respondent before the senior civil judge. Not.
Elindale transfer.
My lord, Bangalore Rural Court to 1 hour senior civil judge, my lord. Two children are there, my lord.
Wife is before this court seeking for transfer of MC 634/2022, which has been instituted by her husband before the 7th additional senior civil judge, Bangalore Rural, the senior civil judge at Jammu State, 1 hour. This is the case of the petitioner that she has 2 children and she is residing with the parents at 1 hour. Therefore, it will be difficult for her to come out the bank to defend herself. She also submits that she has filed a petition seeking for maintenance in CMS 23/2023 before the civil judge, JMS 1 hour. In view of the above, in my view, the wife has made out a case for transfer. Accordingly, MC 634/22, pending on the file of the 7th additional senior civil judge, Bangalore Rural District, is withdrawn and transferred to the senior civil judge in Jammu State, 1 hour.
Obliged.
Number 39, Shri Hemant Kumar ji.
I apologize.
Petitioner, my
Your
lord.
lordship.
So this petition is referred to the respondent's counsel. Despite service of notice, he has not entered appearance, thereby signifying that he has no objection.
I apologize. Yesterday I
For the
remained absent
petitioner.
because I held up in court on 19, your lordship,
Wheelchair
for the respondent. Yes, your lordship, that respondent is on wheelchair because he is suffering from the varicose.
For the petitioner,
Every
my
4
lord,
months he has to
on
undergo.
Monday, it may be listed, my lord, on emergency region council has been for out of station, my lord.
Monday.
For Monday, yesterday it was listed.
Monday.
Much obliged.
Intermediate will be extended.
Number 40.
And for the responding, my lordships.
The wife's petition seeking transfer from Bangalore to Hiriyur, my lord.
There's a daughter, my lord. Okay.
For the respondent, my lordships, we are not served with the petition copy, my lordships. Even the summons has been not served for the respondent, but it is served for the address, but the respondent has not issued, has not taken the summons in this matter.
It's only for a transfer. What
But
do
we
you
have
say?
we have an objection on in this.
What objection?
We'll
What
take.
objection do you have?
We'll seek an instruction from my senior, my lordship, but the petition copy is not served this matter, so that
Used it. Give him a copy. Used it. Interim order maybe.
Seal number 41,
great for
Rudresha.
Sir, wife, petitioner is a wife not seeking transfer from the Nelmangla court to Asan, my lords.
The wife is before this court seeking for transfer of 56/2023, which has been issued by the husband before the second additional senior civil judge at Naramangla to the family court at Asan. Maklidara for India. No.
No.
The wife contends that she's residing at Asan with her parents, and therefore not be liable to Naramangla to defend herself. In my view, since it is not in serious dispute that the petitioner is residing in Asan, it would be appropriate to withdraw MC 56/23 pending on the file of the second additional senior civil judge, Nelmangla, to the family court at Asan. So since the parties are represented by the council, they direct to appear before the family court at Asan on so and so to take further
17 January. Seal number 42, Shri Nandesh Gowda GV.
Lord, the wife petition for transfer, my lord, from third additional principal judge family court to Davangere, my lord.
My lord,
So Bangalore to Davangere.
Bangalore is the Davangere.
for respondent, my lord, copy of the petition is not yet served, my lord. It may be served. I'll make submissions. Date may be given in the next week, my lord.
Used it. Give her a copy.
Obliged.
3, Srimati Ayamma.
For petitioner.
I appear for the respondent, my lord.
In this case, to transfer the suit pending before the Magade court to the Bangalore court where two suits for partition are pending. It's a larger suit, includes all the property. But one brother filed a suit only in respect of one property in Magade court.
But you are asking for transfer after 8 years.
But there,
You're asking for transfer after 8 years.
no, what happened? I was not aware of that, the suit pending before the Magade court. 2 months back, he filed application under section 10 of CPC to stay these proceedings on the ground that suit is pending. At that time, he came to know about that suit. Then I moved.
My lord, I filed an application for memo to dismiss the suit that is pending before Magadi court, my lord. Learned judge has not considered that memo. Saying that,
You're not pressing the suit in Magadi.
no, my lord. I filed a memo on 18/11/2022 saying that I am not pressing that.
ಅದೇ ಈ ಕೋರ್ಟ್ ನಲ್ಲಿ ಹಾಕಿದ್ರೆ ಸಾಕಿತ್ತು ನಾ ಕೋರ್ಟ್ ಅಲ್ಲಿ then it's all right, my lord. That may be noted.
This petition is filed seeking for transfer of verse 322/2016. Pending to the senior civil judge and JMFC Magdi to the 9th additional civil judge Bangalore, bracket CCH-5, where verse 1462/2016 and verse 683/2018 between the same parties and the same subject matter is pending consideration. So the Lord Council appearing for
Respondent number 1 and 2, my lord.
1 and 2 submits that the respondent number 1 and 2 had instituted was 322/2016 and they have in fact filed an application for dismissal of the suit.
Yes, my lord. On 18/11/2022, my lord.
18/11/2022. In view of the fact that respondent number 1 and 2 have filed an application for dismissal of the suit, the senior civil judge and JMFC Magdi is directed to pass orders on the said application and dismiss the suit. So consequently, this petition seeking for transfer of the verse 322/16
Disposed of.
do not survey for consideration. Petition is therefore disposed as become unnecessary.
Number 44.
Appear for petitioner, my lord, in this case.
ನಮ್ ರಿಪೋರ್ಟ್ ಬಂತ
ಇಲ್ಲ, ಅವರು ತಹಸೀಲ್ದಾರ್ ಹೇಳ್ತಾರೆ ನಮ್ಗೆ ಡೈರೆಕ್ಷನ್ ಸರಿ ಬಂದಿಲ್ಲ, ಸ್ಪೆಸಿಫಿಕ್ ಡೈರೆಕ್ಷನ್ ಬಂದಿಲ್ಲ ಅಂತ ಅಂದ್ರು ತಹಸೀಲ್ದಾರ್.
ಅದು ನಮಗೆ ಕಾಂಟ್ಯಾಕ್ಟ್ ಆಗ್ತಾ ಇಲ್ಲ, ಕಮ್ಯುನಿಕೇಶನ್ ಸಿಗ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ. ಹೋಗಿದ್ವಿ ಒನ್ ವೀಕ್ ಬಿಫೋರ್ ಹೋಗಿದ್ವಿ, ಪಿಟಿಷನ್ ಸಮೇತ ಹೋಗಿದ್ವಿ. ಕಮ್ಯುನಿಕೇಶನ್ ಆಗಿಲ್ಲ, ನಮಗೆ ಡೈರೆಕ್ಷನ್ ಗೊತ್ತಿಲ್ಲ ಅಂತೆಲ್ಲ ಅಂದ್ರು. ಸೊ ಅಗೇನ್ ಐ ಅಪ್ಲೈಡ್ ಫಾರ್ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಆಫ್ ದಿಸ್ ಆನರಬಲ್ ಕೋರ್ಟ್ ಆರ್ಡರ್. So I will go and approach to the Tahsildar and I will take the report from the Tahsildar. I want to after vacation.
Bangalore North Subdivision.
Might have informed my lord, my colleague, she is not here.
Monday na?
Monday, please.
No, after vacation ಕೊಡಿ ಸ್ವಾಮಿ, ಯಾಕಂದ್ರೆ no, I will take the certified copy of the order of the director.
Communicate ಮಾಡೋಣ ಇರ್ರಿ.
Communication.
Monday.
Yes, ma'am.
ಆಯ್ತು ಫೈನಲಿ ಮಾಡಿ ಸ್ವಾಮಿ.
ಯಾವ್ದು ಸರ್ ಇದು?
Till number 45,
Middle button.
Kumar Shetty.
Petitioner, my lord. So it's a transfer petition, my lord. Yesterday, your lordship had asked us to produce the resignation letter along with an address proof in Mangalore, my lord. What, sir? What is the document? My lords, in the page number 1 is the experience letter given by the previous company, my lord. Lords, kindly see page number 17, my lord. She got a new job just three weeks back, my lord. That is from work from home, my lord. And I have produced the bill of the Wi-Fi, my lord. That is page number 25.
ಎಲ್ಲಿದೆ ವರ್ಕ್ ಫ್ರಮ್ ಹೋಮ್ ಅಂತ?
Please, my lord. Page number 17, my lord. That is the offer letter from the new company. And page number 18, my lord. May be permitted to read the last second paragraph. This letter of intent outlines the principal terms of your proposed employment. Once the outstanding requirements have been satisfactorily met, including background checks and provision of your proof to work in remote India. That is for work from home, my lord. My lord, earlier, my lord, in the previous company, the petitioner was getting a salary of a package of 15 lakhs, my lord. In the new company, my lord, it is only for 7 lakhs, my lord. She has.
My lord, in spite of their filing dowry case, we filed RCR. We went and begged them to do everything.
You are now only for.
Now, if she doesn't want to come, I'll withdraw RCR, my lord. Kindly, I may be permitted to withdraw.
Not counsel for the husband submits that the husband wishes to withdraw MC 1165/2024, which he had instituted before the Principal Judge Family Court, Bangalore. Since the wife is not willing to resume cohabitation. In view of the above, the Principal Judge Family Court, Bangalore is directed to dismiss MC 1165/2024 as per the submission made by the husband before this court. So in view of the dismissal of MC 1165/2024, it is obvious that this petition seeking for its transfer do not survive for consideration. This petition is accordingly disposed of.
For hearing B group, seal number 46.
Yes.
Lords, I am appearing on behalf of the Petitions Council in writ petition 22712 of 2016.
Yes. There are two petitions.
There are two writ petitions, Lords. If I were to just give a small backdrop. Lords, one Muniga, son of Muniga, claims there is a grant in his favor in 1928-29 to an extent of.
Matter was heard on the last occasion.
The Lordships had heard this matter for some time then.
Yes.
There is.
The grantee or the purchase?
Lords, I am the grantee. Lord, that's the reason, Lords. I'll just, there is something more to it. There are two grantees and one purchaser. The first grantee is who has sold it to the purchaser. And I am the second grantee in terms of the chronology, not in terms of the genuineness of the findings of the grant which is made in the context of the findings recorded. Lords, one Muniga, son of Muniga, claims that 5 acres in survey number 140 of Doddukanalli village is granted to him in 1928-29 by the Tahsildar of Bangalore South Taluk.
How much? 5 acre?
5 acres in survey number 140 of Doddkanalli village.
140.
Yes, in 1928-29.
Muniga, son of Muniga.
Muniga, son of Muniga. By the Tahsildar Bangalore South Taluk. What is the present petitioner is also the son of Muniga, son of Muniga, not the 1928 Muniga, son of Muniga. There are two different people. The lordships are directed there, both of them to file affidavits. Both their names are same.
Your
So-
father was also granted the land.
Yes, my father was granted the land in the year 1964. 4 acres. 4 acres, 36 guntas.
Same survey number.
In the same survey number 140.
What is the name of the village?
Doddkannahalli village, Vartur Hobli. Doddkannahalli.
Your name is also Muniga, son of Muniga.
Yes.
Yes.
What
is the extent of 140? Large extent.
Survey number 140, the total extent appears to be 4 acres 36 guntas, which is presently in 5 different sub-survey numbers, 140/1 to 140.
Total extent of 140. Only 4 acres.
Only 4 acres 36 guntas.
Yes.
That's for 1928 Muniga, he files an application under section 4 of the PTCL Act, 5 of the PTCL Act, saying that he has sold the property in favor of the purchaser and he wants a restoration of the land.
What was that sale?
This sale takes place on
Before that also.
respondent number 11. ಎಷ್ಟು ಸೇಲ್ ಡೇಟ್ ನೋಡಿ, ಸೇಲ್ ಡೇಟೇ ಬರ್ಕೊಳ್ಳಿಲ್ಲ ನಾವು. ಅದೇ ಡೇಟ್ ಬಿಟ್ಟಿದ್ದೀರಾ ಯಾವತ್ತು?
Several sales before 93.
The first sale.
Give us.
ಅದೇ ಡೇಟ್ ಮಿಸ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಾ.
Where is part of the record?
Where is it?
ಕೊಡಿ. ಇಲ್ಲೇ ಇದೆಯಲ್ಲ.
57, 58, 60 in the EC, my lord.
First sale.
First is 57.
1957, the sale takes
First
place.
sale, then second sale is 58, third sale is 1960.
This is Muniga, son of Muniga, to whom?
My lord, as a matter of fact,
Eventually, it is come to the 11th respondent. After the 1950
his
57th
children,
sale
my
deed.
lord, KL Ramaya, Kappa Reddy.
Let's say purchase number 1.
Yes.
Then second sale.
Second sale, not first is Ramaya 57. Then that one Kuppa Reddy to Munishwam Reddy.
Date.
That is 31/3/1958.
P1 to P2. Correct? Second sale.
Yes.
Then, Lord, there's another sale of 1 acre 20 guntas in 1960 from one Guntappa to Motappa.
Is it the same purchase, second purchaser or?
No, it's another. But the extents are, the first two sales are 1 acre 26 guntas. The next one is 1 acre 20 guntas.
The 57 sale and 58 sale?
57, 58 are 1 acre 26 guntas.
Same property.
Same property.
Then the
Then
other portion?
The next portion, Lord, is 1 acre 26 guntas again. 9/5/1960 from one.
Portion is 1 acre 20 guntas. Huh?
Yes. I think it's 26. No, there seems to be a mistake because subsequent sale from the same person shows 1 acre 26.
Then the second portion sale?
This is the second portion sale. The 1960 is the second portion sale.
From Muniga.
No, it's also from one Guntapavu.
How can that be like?
Because total 5 acres.
Correct, but
The
Muniga,
first-
according to you, sold 1 acre 26 guntas to one person. That person sold it in the year 58 to another person.
Yes.
So you are saying in 60, another portion was.
Another portion was sold.
It is to be only by Muniga, isn't it?
None of them are by Muniga. It's by the children, I think, of Muniga.
So the 57 sale is also not by Muniga?
Not by Muniga. 57 sale also is not by Muniga.
By whom was it sold?
What?
By whom was it sold? Muniga's son?
It must be Muniga's son. I'm saying I don't have the exact details from the EC. We have all the sale deeds which have occurred. But before 64, there are at least 4 sale deeds. There is also an issue as to whether it's a granted land at all. The finding is it is not a granted land.
Now, who made the application for resumption?
Resumption is made by Muniga's.
1928 Muniga's children.
Muniga's children have made the application. My learned friend's client comes in the middle somewhere and makes
So
an
this-
application
this
to
is
himself
where-
as a respondent.
But
He
this
does
is
not make
where-
an application under section 4.
But
How
I
he
have not
can
sold the
come now.
property. This is where the problem arises, minutes. 1928 Muniga's application was filed for restoration. Assistant Commissioner at the first instance, then there was some disturbance in the property in 1996. That is how the writ petition is stated. That is what was the application filed before Assistant Commissioner. We sought for impleading saying that the property for which you are conducting the proceedings for restoration is a property which is actually in my possession because of a grant in 1964. Therefore, you cannot conduct these proceedings. So we went before the Assistant Commissioner. Assistant Commissioner dismissed the application. Then the appeal was filed. I had also filed an appeal. Lords, even the purchaser had filed an appeal. Kindly take page number 46, Lords, of the.
What happened to the appeal of yours?
Lords, in the appeal, my appeal was allowed.
Holding that your land was a subject matter.
Lords, yes, no, the reason why it is allowed, that's the reason why I'm requesting your Lords to kindly have a look at page 46. These findings, Lords, is something which probably regulates the entire gamut of the instant writ petition.
Order set aside. This order is set
I'll,
aside.
I'll point out, because what is factually stated there, it can never be set aside because that's a fact which is on geography. Page 46.
What according to you is the finding of this order?
Well, the finding is that 1928 grant is a bogus grant because the grant is said to have been made by the Tehsildar Bangalore South Taluk. Bangalore South Taluk itself came into existence under notification of 1940.
The grant was a bogus grant.
1928 bogus grant.
That grant was a bogus grant.
Yes.
The application for resumption will
Should
come
close.
to an end.
That's the reason, Milords. That's all what we said. Milords, we never said anything. The proceedings had to be closed because if there was no grant, the question of holding that there is any possibility of a restoration or resumption would not arise. Proceedings should have been dropped under the PTCL Act. Question of deciding anything on the merits did not arise. So kindly have a look at the findings, Milords, because this clinches the very issue.
Accept your statement.
Yes.
That
Lord,
the appeal was allowed.
my appeal was allowed on the ground.
There was no granted land at all.
There is no 1928 grant because the grant is said to have been made by the Bangalore Tehsildar South Taluk. South Taluk came to be constituted on 18/1/1940.
What happened after?
Lords, this was challenged before this honorable court. This honorable court, on the ground that the parties were not heard, in the sense, if your lordships were to see,
ಏನಾಯ್ತು ಹೇಳಿ allow ಮಾಡಿದ್ರೆ?
the writ petition was allowed and matter was remanded back. Now, the order which is presently under challenge before your lordships is the order where the deputy commissioner is again passed an order. Now, when the deputy commissioner,
Showing the appeal or dismissing the appeal?
Lords, now what he does is,
Dismiss the appeal.
yes, he dismisses the appeal by holding that the grant in my favor cannot be acceded to or it is not a valid grant because there is an earlier grant of 1928. This is the finding recorded by the deputy commissioner. That is the reason, my lords. If your lordships were to see page 46 and what is now recorded by the deputy commissioner, it is just like he says that there are records to show that there is a grant of 1928. If grant is already made for 1920 in the year 1928, 4 acres 36 kuntas of 1964 is not the land which could have been granted. So therefore, my claim, my grant is a bogus grant. It cannot be considered.
The appeal of the purchaser is also allowed.
Yes, appeal of the purchaser is also.
That there is no controversial terms of the grant.
Yes.
So your remedy is elsewhere.
Lords, the reason why I'm submitting this is, my lords, now the findings are recorded saying that there is a valid grant of 1928. That was a crucial question. Now, if I am in a position to convince your lordships that there was no grant of 1928, because that was the subject matter, until and unless the deputy commissioner records a finding as to the validity of a grant of 1928, based on which the application is made for restoration and resumption, the proceedings itself could not have been concluded. The deputy commissioner doesn't record a finding.
You basically converted the deputy commissioner's forum into a forum to adjudicate as to the overlapping grants.
Milords, now the question of overlapping grant would have been arisen, Milords, if we were outside the purview of the proceedings for restoration and resumption. Now, if restoration and resumption application is dismissed by recording a finding that there is a grant, no grant insofar as I am concerned, and on the basis of this order, my panis are changed. My entries were there, Milords, from the beginning. Milords, on the basis of this order, the entries which is standing in my name is changed into the name of this purchaser. I have never sold the property to them.
ನೀವೇ ಮಾಡ್ಕೊಂಡಿದ್ದು. You invited this.
ಅದೇನೋ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ, ಬಟ್ ಇವಾಗ ಸಮಸ್ಯೆ ಏನು ಅಂತಂದ್ರೆ the deputy commissioner has already passed this order. Now, Lords, may kindly have a look at page 46 for a minute, Lords. I'll just try to
The order says there is no record. References, there are records and therefore its finding is there. The order of the DC is no documents of any kind are there for the 1964 grant. Please see page 30, my lord.
I'll reach just.
How can you look at the order which is set aside to decide whether this order is correct
If
or
the
not?
deputy commissioner had dropped the proceedings saying that there is no grant of 1928, then it's a different matter. But that's not the finding. He records a finding that there is a 1928 grant and therefore there cannot be a 1964 grant.
No.
That's the reason why I said, Milords.
There are no documents you produce, sir.
Kindly have a
Please
look at
see
page
this,
46, Milords. In the first instance, it would be relevant to mention, Milords, after the.
What is running in my mind is, the only question in this proceedings was whether there was a granted land, whether there was an alienation.
Correct.
Now, suppose the purchaser had established that the applicable resumption was not maintainable because he had not violated the terms or because of some other reason. The purchaser sale is valid.
Milords, I have no difficulty, Milords, to hold that the purchaser sale is valid if the validity of the grant was not looked into or there was no finding which was recorded. But unfortunately, Milords, this is the sine qua non for exercise of jurisdiction under sections 4 and 5. If the deputy commissioner wants to rest himself, the assistant commissioner or the deputy commissioner has to assume himself the jurisdiction, there should be an existing grant. Now, unless there is this question is raised, because the reason why I'm referring to the earlier order of the deputy commissioner is that the question had arisen when the matter stood remanded back that there is no grant of 1928, 1929. Until and unless there is a finding as to whether there is a grant, the proceedings could not have taken place to this extent. At the most, what they could have done is they should have dropped the proceedings, saying that there is no grant of 1928, therefore we are dropping the proceedings. That's ultimately, this is how the assistant commissioner or deputy commissioner deals with the matter. Wherever an application for restoration resumption is filed, whether it is case, what is the nature of grant, whether there is a grant, what are the terms with which the grant is made, when the alienation takes place, so on and so forth. But that is a finding which is required to be recorded conspicuously in the light of what was already placed before the court. If this finding is not recorded, Milords, then the deputy commissioner.
Under the PDCL Act, all these questions can't be gone into at your instance.
Milords, at my instance, certainly it could not have been gone into. But
therefore,
Milords,
you reserve liberty to.
Milords, now the entries are changed. Pursuant to the orders of this deputy commissioner, the entries are changed. Milords, the whole difficulty is this. Kindly have a look at page 46 for 1 minute, Milords. So that, Milords, I'll just indicate, Milords, that this is an aspect which was already on the file of the deputy commissioner. And when the matter was remanded back, it was remanded only on the ground that there appears to be no reasonable opportunity which was extended for hearing the matter. Because it was said 2 dates of hearing and thereafterwards matter was posted for orders. So this honorable court remanded the matter on the ground that the opportunity for hearing is to be granted. But if this was what was actually considered and this is what fell for consideration at an earlier round, merely because the matter gets remanded, Milords, the records doesn't get eschewed itself. He had to consider these records. If he considered these records, I don't say that there will be a valid decision in my favor. I am not inviting a decision in my favor. But if it is brought to the notice of the authorities which is required to exercise the jurisdiction under sections 4 and 5, they are bound to give a finding as to whether there is a valid application in the teeth of a valid grant order.
Then you'll also have to accept that they have the authority to assume or give a finding that there's no grant in your favor.
But now,
that is a risk that you will take. Suppose you go down this line.
Yes.
If they have to give a finding as to whether there was a granted land or not,
yes,
they'll also have to take into consideration as to whether you have established there's a grant in your favor.
That question will not arise before that authority because the question is who has gone before them. The question is who has gone before them. Muniga, son of Muniga, 1928, if LRs goes before the court that there exists a grant, he is to decide whether that grant is there or not. As simple as that. If he says there is a grant, then the next question arises. Then I will come out.
But now that is what he has done. He has
No, that is not what is done, Milords.
That is, there is a grant of the year 28 and there has been an alienation in violation of the terms of the grant. But he has refused to exercise discretion
because of neck and his case, etc., etc. There's absolutely no difficulty. But the finding which is recorded, Milords, of 1928 as being a valid grant is something, Milords, which stares against the records which is already the part of the record, Milords, of the deputy commissioner. It runs contrary and falls foul, Milords, of what was already there before the deputy commissioner.
Should it be entertained at your instance?
Milords, the reason is this, Milords.
Who did not challenge that grant or you're standing on a different footing?
Milords, my standing is very simple, Milords. There is no entries which is standing in their names. I have produced 2012, 13 and onwards, I have produced the RTCs. Krishnamurthy is the name in whose name the RTCS is standing for 141, 140 bar 1 to 140 bar 5. I'm not saying that my grant has to be considered in PTCL, which is an error which is committed by the Deputy Commissioner, which your lordships will deal with it. I have no difficulty about it. But the first and foremost question is this, my lords. If the Deputy Commissioner does not return a finding that there exists a grant on the basis of which the application for restoration and resumption is made, he can't assume a jurisdiction, my lords, to even apply the principles under Nekanti's case.
According to me, your appeal was not maintainable at all.
That's my appeal, because the first assistant commissioner's order only said that both of them have not produced any documents. Therefore, I'm rejecting both the application. Therefore, it was necessitated that I had to prefer an appeal. Now the matter is merged with the orders of this honorable court, where this honorable court has remanded back the matter to consider the matter afresh. Now it is considered afresh. Now what falls for consideration, my lords, is this. Isn't it necessary? This is the core question, my lords. Isn't it necessary for the Deputy Commissioner to decide?
1928 guarantees appeal. They have also filed a writ petition against the order of the purchaser.
Purchaser has filed the appeal, my lords. Writ petition, yes.
Now, if that writ petition is dismissed, his grant and his purchase will be validated. If you are claiming a grant under the year 64, maybe your remedy is to withdraw this appeal and then go and raise some other proceeding, saying that that grant was bad and your grant was good.
Lords, this is the reason why I said.
Not under the PTCL Act.
Lords, I just want to say this. If subject to what your lordships may say, my lords. The only question which I am raising is this. When an application under section 4 and 5 is filed before the authorities for the purpose of restoration resumption, on the ground that a granted land is alienated without there being a permission or within the prohibited period. First and foremost question that would arise for consideration is as to whether this is a granted land. That is all the question. To say whether it's a granted land, the Deputy Commissioner is required to return, even to apply the principles under Nekanti's case.
According to me, the risk that you run is, suppose I affirm the order of the Deputy Commissioner, saying that there was a valid grant in the year 28.
He doesn't say that.
Your remedies come to an end.
Yes. I know that, Vinod.
Would you want that, or would you want to reserve your right to initiate separate proceedings, putting for the plea that whatever is available to you?
Vinod, the whole difficulty.
As of now,
Vinod, I understand, Vinod, but when a recording is specific recording is given, that there is no valid 1928 grant, and that whatever is claimed to be granted in 1928 is a bogus grant, because there was no Bangalore South Taluk. All the records produced by them show it is issued by the Tahsildar Bangalore South Taluk, Amildar Bangalore South Taluk. There was no South Taluk till 1940. It's now a person who steps into the shoes of the Muniga son of Muniga of 1928. If they were to get the entries replaced in the name of, in my name, from the years 2000, yes. Again, 2022, 24, 22, 23 onwards, it's changed. From 13, 14, I produced RTC extracts. May just
land is converted.
24, they have changed it. May
Land is converted, sir.
May just copy. But this is my problem. Because of the proceedings which has taken place, I understand, Millers. I know what your lordships would be feeling within that. What is that we have done by ourselves? I know that, Millers.
Revenue records can't control title. If they really have title, then they have to establish the title.
Not like that. Now, until and unless it was established that there was the lands for which the entries are already standing in my name, is the lands which they are claiming before a competent jurisdiction, court of competent jurisdiction, where there's any question of change of entries. Now the mischief has occurred.
The government is the person which granted the land. If it says it is granted to him, does not really lie in your mouth to say that it is wrong. If you claim that...
No, that is where, that's the reason why your lordships is there, my lords, to correct the governments.
Your claim is that there was no grant of the year 28-29. Your remedy is elsewhere, not under the PTCL Act is what I'm trying to tell you.
I fully understand, not what your lordships
PTCL Act, you're expanding the scope unnecessarily and giving them a lot of
leverage to record findings which they ought not to have been recorded. Is what I understand, but that is the grievance before the court.
Because I'm inclined to hold that your appeal itself was not maintainable. Since you are claiming that the grant in your favor was valid and not the grant at 28, the remedy under the PTCL Act was not available to you. The list in the PTCL Act was only between the purchaser and the grantee.
That's exactly the point.
The Deputy Commissioner had found that there was no grant. Would have rejected this. No, he has found that it is a grant.
That's the reason why I'm requesting your lordships may kindly have a look at the fallacy of the findings which is recorded by the Deputy Commissioner. There is a fallacy with which the findings are recorded. If
According
this
to
is
me-
exactly the point which I said, Milords, if the deputy commissioner holds that there is a grant in favor of the, it goes to the root of the matter because they are the people who are claiming title under 1928 grant. And I am saying that there exists no 1928 grant. The assistant commissioner says no, there is no 1928 grant. In the first round of the proceedings, the deputy commissioner says after calling for the records, entire records, he says that there is no 28 grant. Now the deputy commissioner, Milords, in the second round says,
Want me to examine the matter in minutes, you take the risk of foreclosing all your options. If I were to affirm the finding of the deputy commissioner,
very well, I'll take the risk, Milords, then. Correct, sorry. I'll ಕೇಳ್ಬಿಟ್ಟೆ ಅದಕ್ಕೆ ಒಂದ್ಸರಿ.
Allah, my learned friend sees the order of the DC. DC actually says there is no grant of 28, there is no grant of 64. And says even if there is a grant of 28, it is during the no rule period.
where is the order of the deputy commissioner?
Please see page 30.
Page number 81, Milords.
No. Please see page 30.
ಯಾವ್ದು ನಿಮ್ numbered petition ಅಲ್ಲ?
So the first assistant commissioner's order.
ಅಲ್ಲ
15 March 2011 order.
Yes.
Allah, the AC's order says both are not there.
Milords, that is the assistant commissioner's order. That is the reason why we were before the deputy commissioner. And therefore, I am requesting the Lords may
At
kindly
that
have a
point
look
in
at page
time, you couldn't have
46.
filed an appeal because the assistant commissioner said there is no 28 grant, there is no 64 grant.
Kindly have a look at page 46, Milords.
46 is set aside.
It is by the deputy commissioner.
But 46 is set aside, sir. That order is
Assistant
set
commissioner's
aside.
order is also set aside.
Both are set aside. Why are you relying on it then? This is the order, no? AC's order is set aside by the DC. DC's order is set aside by the High Court. Matter went back to DC. Then DC passes this order.
Dismissing the appeal.
Correct.
So,
AC order is gone. This is order. Which is the order, man?
Yeah, this is the operative portion of the appeal order. I'll come back at 2:30. I have a division mentioned 1 o'clock.
Yes, yes.
ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ?
ಅಲ್ಲ how ಇವ್ರಿಂದ ಮಾಡ್ತೀರಾ?
ಅವ್ರು ಕೇಳ್ಬೇಕಲ್ಲ.
Court officer?
2016 order ಅಲ್ವಾ? ಇದೇ ಅವ್ರು collect ಮಾಡಿರೋದಲ್ವಾ?
ಇಲ್ಲಿ ಯಾರು
Hello. Court officer. Court officer.
ಹೇಳಿ.
ಸಿಟ್ಟಿಂಗ್ ಇನ್ನೊಮ್ಮೆ ಮಧ್ಯಾಹ್ನ ಮೇಲೆನಾ?
ಮಧ್ಯಾಹ್ನ ಇದೆ.
ಓಕೆ, ಅಂಡ್ ಸೀರಿಯಲ್ ನಂಬರ್ 52 ಇನ್ನೂ ಅಲ್ಲಿ ಇದೆ ಅಲ್ಲ?
52 ಇದೆ.
52, ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು. ಸಾರಿ, ಊಟ ಮಾಡುವಾಗ ತೊಂದರೆ ಕೊಟ್ಟಿರ್ಬೇಕಲ್ಲ. Anyway, I'll come there in person. Thank you.
Court officer. Court officer. Court officer.
ಪ್ರವೀಣ್ ಸರ್ ನಿಮ್ಗೊಂದು ವಾಟ್ಸಪ್ ಕಳ್ಸೀನಿ ಜಜ್ಮೆಂಟ್ ಸ್ವಲ್ಪ ಮೊಬೈಲ್ ನೋಡಿ ಸರ್.
ಪ್ರವೀಣ್ ಸರ್
ನೋಡ್ತಾ ಇದ್ದೀನಿ ಸರ್. ಸರ್ ಹೇಳಿ.
ಆಯ್ತು, ಸೀರಿಯಲ್ ನಂಬರ್ 3 ನಿಮ್ಗೆ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದಾನ ಪ್ರಭು?
ಸೀರಿಯಲ್ ನಂಬರ್ 3 ಇಲ್ಲ ಸರ್, ಬಂದಿಲ್ಲ.
ಬಂದಿಲ್ಲ, ಒಂದು ಶಾರ್ಟ್ ಡೇಟ್ ಇಟ್ಕೋತೀನಿ. ಲಾಸ್ಟ್ ಟೈಮ್ ನಿಮ್ಗೆ ನೋಟಿಸ್ ಆಗಿತ್ತು, ಅದು ಸ್ಟೇಗೋಸ್ಕರ ಇನ್ಸಿಸ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದೆ, ನಮ್ಮವನು ಕಾಪಿನ ಕೊಟ್ಟಿಲ್ಲ.
ಇದು ಎಲ್ಲ ನಾನ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಇದೆ ಸರ್ ಇವತ್ತೆಲ್ಲ.
ಆಯ್ತು, ಒಂದು ಶಾರ್ಟ್ ಡೇಟ್ ಇಟ್ಸ್ಕೋತೀನಿ.
ಎಸ್ ಎಸ್.
ಆ ಫೈಲ್ಸ್ ಅಲ್ಲಿ ಹೋಗ್ಬಿಟ್ಟಿದ ಸರ್, ಬಂದ್ರೆ ಏನಾದ್ರು ಮಾಡ್ಬೋದಿಲ್ಲ, ಅದೊಂದು ದೊಡ್ಡ ಪ್ರಾಬ್ಲಮ್ ಆಗ್ಬಿಟ್ಟಿದೆ. ಕೋರ್ಟ್ ಆಫೀಸರ್, ಕೋರ್ಟ್ ಆಫೀಸರ್, ಕೋರ್ಟ್ ಆಫೀಸರ್,
ಸರ್ ಹೇಳಿ ಸರ್.
ಸರ್ ಇವು ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಫೈಲ್ ಸ್ವಲ್ಪ ಧಾರವಾಡಕ್ಕೆ ಕಳ್ಸಿಕೊಡ್ಬೇಕಿತ್ತು, ಅಂದ್ರೆ ಕಂಪ್ಲೈನ್ಸ್ ಆಗ್ತಾ ಇಲ್ಲ ಅಲ್ಲಿ, ಸ್ವಲ್ಪ ಇದಿತ್ತು.
ಸರ್ ಅದು ಡೇಟ್ ಇರುತ್ತಲ್ವಾ, ಅದು ಇಲ್ಲೇ ಇರುತ್ತೆ ಸರ್ ಫೈಲು.
ಹೌದಾ, ಮತ್ತೆ ಹೇಗ್
ಮತ್ತೆ
ಮಾಡೋದು?
ಹೋಗ್ ಬರೋದು ಆ ಡೇಟ್ ಅಲ್ಲಿ ಆಗೋದಿಲ್ಲ.
ಹಾ ಹಾ, ಸರಿ ಸರ್.
ಬಂಟಿ ಸರ,
ಸರ್ ಹೇಳ್ರಿ.
ಅಲ್ಲೇ ಕಂಪ್ಲೇಂಟ್ಸ್ ಮಾಡಕ್ ಯಾರನ್ನ ಕಲಿಗೆ ಅವ್ರಿಗೆ ಹೇಳ್ಬಿಡ್ರಿ, ನಾನು ಅದನ್ನ ಮಾಡ್ಬೇಕು. ಈಗ ನಮ್ದು 4ನೇ ಮೀಟರ್ ಅದೈತಿ.
ಹೌದಾ, ಅದ ದೊಡ್ಡ ಪ್ರಾಬ್ಲಮ್ ಆಗ್ತದೆ. ನಾವು ಈಗ ಸ್ಟೇಗ್ ಇನ್ಸಿಸ್ಟ್ ಮಾಡಿದ್ವಿ, ಪಾಪ್ ಸಾಹೇಬ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಇದು ಮಾಡಿದ್ರು.
ಈಗ ಸಬ್ಮಿಷನ್ ಮಾಡ್ಬೇಕು, ಅವ್ರಿಗೆ ಕಳಿಸಿದ್ರೆ ಮತ್ತೆ ಡಿಲೇ ಆಕೈತದ. ನೋಡೋಣ ಈಗ ಏನ್ ಮಾಡ್ತಾರ.
ಸರಿ ಸರಿ, ಓಕೆ.
ಬೆಂಗಳೂರಿಗೆ ಹೋಗೋಣ ನಡ್ರಿ.
ಪವನ್ ಸರ್ ಕರ್ಕೊಂಡೋದ್ರೆ ಹೋಗೋಣ ನಡ್ರಿ.
ಏನ್ ನಡ್ರಿ ಹೋಗೋಣ, ಅದಕ್ಕೇನೈತಿ.
ಪವನ್ ಸರ್ ಗಾಡಿ, ಚೇತನ್ ಸರ್ ರೊಕ್ಕ.
ಇದು ಕರೆಕ್ಟ್ ಹೇಳಿದ್ರು ನೋಡ, ಲಾಸ್ಟಿಗೆ ಹೇಳಿದ್ ಕರೆಕ್ಟ್ ಅದ.
ನಾವ್ ಬರೇ ಮಾನಿಟರ್ ಮಾಡೋದು ಕರೆಕ್ಟ್ ಐತಿಲ್ಲ ಅಂತ.
ಬಿಡ್ರಿ, ಸಾಯಿಬ್ರು ಬನ್ನಿ ಅಂತ.
ಅವರು ಜಾಯ್ನ್ ಆಗ್ತೀನಂತ ಸಾಹೇಬ್.
ಗೌತಮಿ, ಗೌತಮಿ, ಗೌತಮಿ. ಇಲ್ಲ ಅದು ಬೇರೆ ಕೂಡ ಅಂತ ಹೇಳ್ಬೋದು. ಓದ್ತೀನಿ. ಅದು ಮುಗಿಲಿಲ್ಲ ಅಂದ್ರೆ ಮುಗಿಲಿಲ್ಲ ಅಂದ್ರೆ
Court officer? Court officer?
ಅವ್ರನ್ನ ಆಪ್ಟಿಫಿಕೇಶನ್ ಬೇಕು ಅಂತ ಅದಕ್ಕೆ ಬರ್ಲಿ ಬಿಡಿ. ಆಪ್ಟಿಫಿಕೇಶನ್ ಏನಾಗುತ್ತೆ ಅಪ್ಲಿಕೇಶನ್ ಆದ್ಮೇಲೆ ನಾನು ಕೊಡೋಕ್ಕಾಗಲ್ಲ, ನಂಗೆ ಗೊತ್ತಾಗ್ಲಿ ಏನಾಗುತ್ತೆ.
Number 1 for pronouncement of order. Number 89, Sri Mudit Ashutosh Mutkur.
Second respond.
Is therefore dismissed.
Much obliged. Great.
Say number 90, Sri D.C. Sitaram Rao.
The appeal is thus dismissed, subject to the payment of the above direct cost rupees 25,000 to the second respondent.
Bill number 91. Shri Balaji Naidu.
I find no merit in this petition, and the same is therefore dismissed. Whatever you want, you ask in the review. Review ಆದ್ರೆ ಆಮೇಲೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಇದ್ದೇ ಇರುತ್ತಲ್ಲ. ನಾನು ಲಿಬರ್ಟಿ ಕೊಡಲ್ಲ, ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಆಮೇಲೆ ನೋಡಿ. Once you merit in this petition, the petition is accordingly dismissed.
Forward bench matter. Bill number 1.
My lord, I am appearing through video conference. The PF is paid, my lord. Yes, my lord. PF is paid, my lord.
The stated office to verify.
Lord, may I seek for an interim order, my lord?
First ಬರ್ಲಿ process serve ಮಾಡಿಸಿ.
Bill number 2.
Residency, lordship.
My lords, I appear for petitioner. My lords, for respond number 2, my lords, government advocate only, my lords, appears. In previous cases, my lords, the HCGP has appeared, my lords.
Notice R2 ಅಂತ ಹೇಳ್ದಲ್ಲ ನಾನು.
My lords, that order was not clear on that day because of some technical error.
That second respondent is the additional deputy commissioner. The SCGP is therefore directed to take notice for R2.
My lords, this is covered by judgment of my lords. Accused number 2, this honorable court has already quashed. My lords,
Anybody appearing for the state?
my lords, Mr. Praveen appears. My lords.
Not talking.
Sir, for state, my lord. Pending, notice time may be granted, my lord. I need to check, my lord. Now it has served the decisions, my lord.
Please.
3.
Week's accommodation, lord. My apology, lord.
Shri Pawan Dodati.
Lords, in this case, I appear for the petitioners. I have paid the process, my lords. Since, my lords, the file was not sent back to the Dharwad bench, my lords, I was unable to comply the office objections, and date was given today.
2 weeks time is going to comply with
Please.
the subject.
Please.
Number 5. Very good.
Weeks time.
Bill number 6. Shri Manta Shiramat. Bill number 7. Shri Amar Iramatat.
Post office notice to R2.
I am for the petition, my lord.
ಏನಾಗಿದೆ ಸರ್ವಿಸ್ ರಿಪೋರ್ಟ್?
Await the result.
Post office.
Bill number 8. Shri Avinash.
Stay may be extended, my lord. Serial number 7.
ಆಯ್ತು.
Bill number 8. Shri Avinash. Bill number 8.
Weeks time.
Bill number 9. Shri Avinash.
Weeks time.
For hearing on IA. Bill number 10. Shri Prashant Lakshmani.
Lords, I appear for the petitioner in this case, my lords. This is a matter, my lords, covered by the judgment of this honorable court. Here, my lords, for a single.
Who's R2?
Lords, R2 is the complainant, my lords, the brother of the deceased.
ಸರ್ವಿಸ್ ಆಗಿ ಬರ್ಲಿ ಹಂಗಾರ.
Please, my lords. Since matter was covered, my lords, I was insisting.
Without her, can I?
Please, my lords.
For admission. Bill number 11. Shri Batakurki.
11.
Bill number 11. Shri H.L. Batakurki. Bill number 12. Shri Anand
My
Kumar.
lord, I am for the petitioner in this case, my lord.
Yes.
The respondent number 2 filed a complaint before the, my lord, Mariammana Halli PS, my lord. Offense punishable under section 504, 323, 506, 498A, my lord.
OPS for R2.
Shri Basangaud T.
after vacation.
Please, my lord, please.
Seal number 13,
Petitioner, short accommodation.
Released.
10th. Seal number 14.
And for petitioner, my lords, 6 a short accommodation. Taken after vacation.
Kalburgi bench matters.
They matter.
Further consideration, seal number 1, Shri R.J. Busare.
Lord, appearing for petitioner, my lord. Lord, the government has filed a memo, my lord, along with the salary calculated from the year 2010 to 16, my lord. There is a difference even, my lord. The petitioner is also calculated, my lord, the salary, wherein, my lord, there is a difference of 3.5 lakhs, my lord. The government has calculated, my lord, 23 lakhs 33,000, whereas, my lord, the petitioner has calculated 26 lakhs 78,000. Only thing is that, my lord, the government did not take into consideration, my lord, the increments, every year increments, my lord, that has not been calculated in
And you
the.
served a copy of it on him.
My lord, I have prepared, my lord, I will serve to the government, my lord, and even, my lord, the government, it may be taken on 19th, my lord. Before that, my lord, I will serve and file.
19.
Please.
Seal number 2, Shri V.V. Patil.
I appear for response number 2. This is relating to the petitioners not have sought for merger of courts, wherein I not last several dates the government not is has to reply that with regard to the all the universities concerned.
Yes, Ravi Patil.
Ravi Patil not there. He is not in station. What has been informed.
On behalf of respondent, one I have filed the objections.
Ready, na? I'll take it up afterwards. I have not filed.
By rejected the proposal of the R2. Citing that.
Malars, one submission.
Yes.
What in this matter, what we earlier also submitted that the government has to take a stand with regard to the Malars. Earlier also they formulated the common cadre and recruitment rules of service personnel of the universities. And that is my instructions, Malars, are that it is at the completion, they are concluded. The only the requirement is, they have to submit and take a approval from the chancellor. What is required under section 52. Now the appears that the affidavit is filed, rejecting their claim. It doesn't, satisfy that, because earlier contempt, in the contempt also they have, the government has undertaken that they will prepare the common cadre and recruitment rules. It is not for this.
We'll finish it today. Please. We'll finish the main matter itself.
One date, I will submit some.
I have came all the way only to conclude my part.
Brought him along.
I have informed to his colleague. He was
not
not.
Then he would
I'll
have
finish off my for his reply. It could.
If the argument,
Virtually, both of us have finished the
take up for a hearing, government will come up with a they will prepare the entire university.
Our synopsis no hakidare. I'll take only 2 minutes of the floor.
Prepared because of the reason that the university, the government will reply.
The government has no role to play in this matter. Your lordship has already passed as a detailed order.
not ready.
Also that
not ready. He's mentally not ready to argue today.
He had virtually finished his part of argument. Now I do not know why he is seeking adjournment today. But 2 times, it was adjourned only because of a government advocate not ready. May I request for it could be heard for a while, then if requires, is.
I have other matters also today. Why are you?
Please.
Number 3, SG Mat.
You are subject to appear for the petitioners in 3.1 minute.
I pray for time, my lordship. It may be taken after the vacations, since the affidavit is ready and it need to be signed next. I have taken the instructions with regard to the continuation of the service of the petitioners. Details have been submitted.
I'll impose costs on
Finally, one date may begin.
ಒಬ್ಬೊಬ್ಬರು 5,000 ರೂಪಾಯಿ ಹೇಳ್ತೀನಿ. Cost.
Lordship,
3 ಸಲ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೀನಿ ನಿಮ್ಗೆ.
ಹೌದು ಅಂದ್ರೆ ಇಟ್ ಐ ಹ್ಯಾವ್ ಟು ಕಲೆಕ್ಟ್ ದ ರೆಕಾರ್ಡ್ ಫ್ರಮ್ ಆಲ್ ದ 3 districts, Lordship.
ಈ ಲಿಸ್ಟ್ ಎಲ್ಲಾನು ಅಲ್ವಾ?
Yes, all together.
3 to 7.
Main matter. Serial number 3.
In the meantime, in the meantime, Milords, if Milords could direct the government to Milords pay the arrears of salaries, Milords. So, yes.
January ನೋಡೋಣ.
Yes, Milords.
Serial number 3, 5, 6 and 7.
Yes, Lord.
3, 5, 6 and 7.
4 we are ready, my lord. Lordship would recollect, my lord, regarding regularization. My lord, on the last occasion, they also, my lord,
Number
submitted
4.
that.
4. We have submitted the working pattern of the university as directed by the Honorable
Ready na?
Court. Yes, Lordship. It is a case of mandamus, the direction may be given. It will be considered as per.
Random masala ಮಾಡಬೇಕು.
Yes, Lord.
Quashing is also there.
For Sudarshan. Sudarshan University.
Statement of objection.
He has filed statement and he also, my lord, on the last occasion submitted a chart, my lord, showing that whatever we request to him, that coincides with the.
Where is it?
He should be there. And we informed also, my lord, well in advance, and Chakshet is here. He has informed him orally also that.
Password ಮಾಡ್ಲಾ? ಹೇಳ್ತೀರಾ ಬರ್ತೀರಾ?
Yes, we sent the message, not received adjournment.
ನಮ್ಮದು ಬೇಕಾದ್ರೆ ಕೆಲ ಇಡುವಂತ can I argue my part and can we, my lord, before end this vacation, can we, next week?
ನೋಡ್ರಿ ರಾತ್ರಿ ಆನ್ಲೈನ್ ನಾಗ ಇಟ್ಟು.
My lord, 19th or 20th? 19th. Great.
One submission or serial number 6.
Before cancelled. One among which was the apparent.
Serial number 6 ಅಲ್ಲಿ there was a recommendation by the municipality Milords in the year 2013 itself for regularization, and the employees were
ಇದೆಲ್ಲ they go together ತಾನೆ 3, 6 and 7.
ಹೌದು regularization.
Even 5 also regularization. They are working in municipalities since more than 25 years. Since 98 they are working.
All right.
230 board matter. SP Prakash.
Purchasers petition. Land was granted in the year 1949-50. Sale was, my lord, in the year 1961. My only, my lord, ground is that the claim was made, my lord, 25 years after the commencement of the act, and therefore, my lord, is covered by the judgment of this court and the honorable apex court.
Notice for R1 to R3. Issue notice to R4 to R7. Interim stay.
Stay ಕೊಟ್ರು
Of
sir.
subsection we completed. In office objection ಏನು?
My lord, I have challenged constitutional violations of, my lord, section 5.
The note made deposited is accepted.
May I seek my handle?
Copy ಕೊಡಿ sir. ಪ್ರಕಾಶ್ ಸರ್ ಕಾಪಿ ಕೊಡಿ ಅಂತ.
Number 46.
ಕಾಪಿ ಇಲ್ಲ ನಂಗೆ.
Copy ಬೇಕಾ?
ನೋಡಿ without my lines valid.
May I request for Passover minutes? Senior counsel held up in another court order.
Number 7.
Mark over matters. Serial number 4.
Lord, I appear for the petitioner, my lord, respondent, my lord. I'm sorry. Lord,
Which one?
1940 grant.
And land was granted 22/10/1940. And for sale is 12/7/1951. The respondent number 23 has purchased 16/1/2009. She has farmed the residential layout and sold to the respondent number 23 to 49 persons. But again, 2011, the respondent number 23 has obtained the consent deed of my family. And she has obtained the consent deed On that time, my lord, she has executed the one, the gift deed to my family members. I accept this petitioners.
Why did the assistant commissioner reject your application?
Assistant Commissioner, my lord, they rejected the petition. No grant records are available.
Where is the order?
That is a finding, my lord, page number 41. Page number 41. 43, my lord, the second para before, my lord. 43. Applying the law principles laid down in the decision, in the absence of the original grant records, the very same nature of the grant in question rules under which it was granted, much less whether the temporary land grant was confirmed or not, cannot be ascertained in such circumstances.
What did the deputy commissioner say?
Deputy Commissioner, the Nekkanti Ramalakshmi case has a report. In page number 34.
Was the application for resumption made?
When
was the application for resumption made?
That is 2010.
2010-11, Lord.
2010.
How many years?
23 years.
30 years.
31 years.
Came into force.
Yes. The petitioners, the notice was not served some other, the respondents, the 25 to 49, the respondents. We approached the respondents, some site holders. They are willing to obtain the consent deed. These, the contesting the respondents are only the cavators. They are already sold the property.
What is your right?
Not my right, we are the petition is Nekkanti Ramalakshmi case delay in latches. Some time may be granted, for this some petitioner, the respondents approach the site is. Iವರು ಬೇಡ, remaining unserved the respondents.
ಯಾರು ಇಲ್ಲ ಸ್ವಾಮಿ.
ಇವರು ಎಲ್ರಿಗೂ represent ಮಾಡ್ತಾ ಇಲ್ಲ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
It is ಸಾಕು.
Some time may be granted. At least ultimately, the
ಇಷ್ಟು ಕಲೆಕ್ಷನ್ ಮಾಡ್ಕೊಂಡಿದ್ದೆ ಸಾಕು. ಆಗಿದೆಯಲ್ಲ ಮಿಕ್ಕಿದವ್ರದೆಲ್ಲ
ಇಲ್ಲ
ಕನ್ಸೆಂಟ್ ಡೀಡ್ ಎಲ್ಲ ಆಗಿದೆಯಲ್ಲ ಸುಮಾರು ಜನ.
ಅಲ್ಲ ಕನ್ಸೆಂಟ್ ಡೀಡ್ ಓನ್ಲಿ ದಿ ಮೈ ಫ್ಯಾಮಿಲಿ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 4, 5, 6 ಇಂದ ಮಾತ್ರ. Remaining except these petitions. Some time may be granted for.
How much time have I granted you so far?
But these unserved petitioners, unserved the
respondents. Time ಕೊಟ್ಟೆ. ಏನ್ ಮಾಡ್ಕೊಳ್ತಾರೆ ಮಾಡ್ಕೊಳ್ಳಿ ನೀವು ಅಂತ.
ಅಲ್ಲ ಅದು ಮಾತುಕತೆ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಮಾತುಕತೆ ಅಂತಾನೆ 3 ಸಲ ಕೊಟ್ಟೆ. Despite your opposition, I granted you 3 times.
ಅಲ್ಲ some time may be granted for. Ultimately, the matter is the delay and latches is there.
Division bench is dismissing applications with 8 years delay.
Yes.
There are 30 and odd years.
Some time may be granted, please. And these the approach the some site purchasers. The entire the land was farmed the layout and sold it.
Yeah.
Some time, please.
Blood.
Number 5.
Great.
Please, Malab.
Yes.
Lord, the LRs of the grantees are not the petitioner. The land bearing survey number 92 measures 4 acres 28 gunta. Lord, earlier, Lord, the deputy commissioner had addition to say that you can't entertain an appeal. This honorable court, Lord, in the writ petition, Lord, set aside the order and remanded back to the deputy commissioner. Lord, the deputy commissioner, Lord, on the similar ground, Lord, he has dismissed the appeal.
Commissioner dismissed the appeal.
The deputy commissioner has dismissed the appeal.
Where is the order?
Lord, the order passed by Lord this honorable court, Lord, that could be at
Deputy Commissioner.
Deputy Commissioner Annexure J, Lord, page 95.
96, my lord, page 95, 96, my lord.
The only reasoning, Lord, that could be, Lord, it can be seen at Lord para 90.
No, the assistant commissioner has given a finding that you have inserted your name in the register.
Lord, my submission
saying that
these poor fellows, Lord, how possibly, Lord, they can have occasion to manipulate the revenue records, Lord.
That is a finding of fact recorded.
No, he has not secured the original records. He has not secured the original record.
Kindly come to page 66. Page 66.
Please, Lord, he has said that. He has said that there is some correction. He never said,
Not some
my lord,
correction. He has elaborately reasoned as to why he is doubting your credentials.
No, it is not that, my lord, his own record. He is the custodian of the document. He is supposed to explain what probable circumstances, my lord, these corrections have taken place. But he is the custodian of the document.
Because,
my lord, some error find, that itself could not be, my lord, a factor, my lord, to decide the rights of the party. My submission is, my lord, your lordship may kindly appreciate, my lord, in the writ petition, this honorable court directed the deputy commissioner to consider the appeal on merit.
yes, he has
Earlier,
considered the appeal on merits. He has
No.
recorded a finding that there is nothing to indicate the land
Lord,
was granted.
he has reiterated, Lord, what are the findings, Lord, the reasoning given by the assistant commissioner, and he has not reappreciated the document. He has not even
Yes.
secured the document.
Not only looking into.
Yes,
the
in para 17 of his order, he has
Please,
reappreciated.
Lord, I
everything.
can read, Lord, I can read.
Only RTCs he has looked into, my lord. Records
ಮೇಲ್ಕಂಡ
only-
ಎಲ್ಲಾ ಅಂಶಗಳನ್ನು ಗಮನಿಸಿದಾಗ
He has not
ಮೇಲ್ಕಂಡ
gone into all the, my lord, he has not called for the any records, only by the RTCs, my lord, he says, ಅದು ಇನಾಮು ಮತ್ತೆ ಹಿಡಿವಳಿ ಲ್ಯಾಂಡ್ ಅಂತ ಹೇಳ್ತಾರೆ. I don't, my lord, you would have called for.
Para 17 of the order of the deputy commissioner note.
Yes, ma'am. Para 17, my lord, page 95. ಮೇಲ್ಕಂಡ ಎಲ್ಲಾ ಅಂಶಗಳು ಗಮನಿಸಿದಾಗ ಮೇಲು ಮಂಚೇದನಲ್ಲಿ ಗ್ರಾಮ ಮೂಲ ಮಂಜೂರಾತಿದಾರ ಹನುಮೇನಾಯಕ ಬಿನ್ ಹನುಮಾನಾಯಕ ಇವರಿಗೆ ಸರ್ವೆ ನಂಬರ್ 92ರಲ್ಲಿ ಮಂಜೂರಾಗಿತ್ತು ಎಂದು ನಿರೂಪಿಸುವಂತಹ ದಾಖಲೆಗಳು ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲ. ಅವರು ಸಲ್ಲಿಸಿರುವ ಸಾಗುವಳಿ ಚೀಟಿಯಲ್ಲಿ ನಮೂದಿರುವ ಮಂಜೂರಾತಿ ಆದೇಶ ಸಂಖ್ಯೆಗೂ ವಿತರಣಾ ವಹಿ ಮತ್ತು ಡಿಮ್ಯಾಂಡ್ ವಹಿಯಲ್ಲಿ ನಮೂದಿಸಿರುವ ಮಂಜೂರಾತಿ ಆದೇಶ ಸಂಖ್ಯೆಗೂ ತಾಳೆ ಇರುವುದಿಲ್ಲ. ಅಲ್ಲದೆ ಸದರಿ ಸರ್ವೆ ನಂಬರ್ ಮೂಲ ಸರ್ವೆ ಪ್ರತಿ ಪ್ರಕಾರ ದಿನಾಂಕ 21/6/62ರಲ್ಲಿ ಹೊಸದಾಗಿ ಸರ್ವೆ ನಂಬರ್ 92 ಎಂದು ನೀಡಲಾಗಿರುತ್ತದೆ. And
he has recorded finding that there is nothing.
ಹನುಮೇನಾಯಕ ದಾಖಲೆಗಳನ್ನು ಮೆಲೋಡಿ ಸೇಸ್ ಮಂಜೂರಾಗಿತ್ತು ನಿರೂಪಿಸುವಂತಹ ದಾಖಲೆ ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲ. ಅವರು ಸಲ್ಲಿಸಿರುವ ಸಾಗುವಳಿ ಚೀಟಿಯಲ್ಲಿ
Assistant commissioner had said the name is inserted.
Yes, ma'am.
He has said doesn't tally.
Yes. That is.
ಅಷ್ಟೇ ಅಲ್ವಾ?
Because, my lord, these findings, my lord, without seeing the original record.
All right. An application for resumption was filed by the petitioners and the assistant commissioner has.
Can I request at least not scrutinize the document at least, my lord?
Following reasoning, page 66 and mark Madin. The applicant being agreed by the said order preferred an appeal to the deputy commissioner, and the deputy commissioner has dismissed the appeal with the following reason, para 17 and 18. As could be seen from the above, both the authorities have recorded a finding of fact that there was no grant made in favor of the applicants. In fact, the assistant commissioner has gone on to record a finding that a blank space available in the grant register has been misused to incorporate the name of the grantee, and additional numbers have been given in the index. In my view, since the authorities have recorded a finding that the records had been tampered with to contend that there was a granted land, there is no justification to interfere the orders passed by the authorities. Consequently, petition is dismissed.
Please.
Number 17. Bill number 17.
For petitioner, my lord.
17. 17.
I'm not for petitioner, my lord. Needful done today.
It was should have been.
Only place time for.
Bill number 20.
Lord, regarding office objections, my lord, in the scrutiny note, my lord, submissions are made.
Scrutiny note. The council submission regarding office objection. 1 and 2 are accepted.
Yes, Lord, grant is of the year 1964, my lord. First sale took place in the year 1990 in favor of respondent number 11-1 Veluswamy.
1990.
1990, my lord. Petition for resumption of land was filed in 2001. There are two aspects, my lord. One is delay. The other is
Take notice.
CCB accepts notice. Respondents 1 and 2. Issue notice to respondents 3 to 11. Interim stay. Anyway. 46.
Could it be passed over? He's on his legs, my lords. I'll get him.
47. Appear for the petition.
Respondent number 3, 527.
Ready na?
ಇಲ್ಲ ಸರ್, ಸೀನಿಯರ್ ಔಟ್ ಆಫ್ ಬೆಂಗಳೂರು ಇದ್ದಾರೆ. 1 week ಟೈಮ್.
Relist.
Number 48 adjourned. Number 49, 3. Prakash Abba.
In this case, appearing for respondent 10 and 11, I placed 2 weeks time, my lord, 2 file Vakalat, my lord.
Relist.
Your Lordship, appearing for the petitioner in this matter, short pass over, Your Lordship, senior counsel.
Fine.
Your Lordship, it's been pending for a really long time, Your Lordship, and may be heard, short pass over.
He's filing Vakalat.
2 weeks time, please.
It may be had before the vacation, Your Lordship.
Relist date.
20th.
Much of it.
Number 50, 3. S.S. Sudhindra.
Hearing for petitioner. Kindly, this matter at Monday, my lord.
Lordship, I am for respondent.
My senior is held up in court hall number 9.
Nineteen.
Ah.
Number 51. 3. V. Prasad.
35 years delay in filing application. Lord, I am for the purchaser.
Who's opposing you?
ಅವರು ಮೂವ್ ಮಾಡಿದ್ದಾರೆ ಅವರೇ. Sought for interim order, Lord, it was not granted earlier. Lord, the deputy commissioner, Lord, passes a short order at page 11 annexure A. Merit ಮೇಲೂ ಆರ್ಡರ್ ಬರ್ದಿಲ್ಲ. Grantee was impersonated. Grantee was dead on 15/5/2001. In the name of the grantee, a petition is filed.
What was the petition that you had filed before the deputy commissioner?
Lord, challenging the order passed under annexure B. Annexure B is the order passed for resumption of land. This was challenged in before the deputy commissioner. What has happened is.
Read the order. Endorsement.
Endorsement is 10/6/19, Lord.
What does it say?
4-2 order was challenged, 4/2/19 was the order passed by the assistant commissioner for resumption of land. That was challenged before the deputy commissioner's order. What has happened is, Lord, the one Mr. Garla Bovi is the original grantee.
I was not able to understand this endorsement.
Annexure A ಅಂತ ಓದಿ ಅಂತ.
Annexure A.
Annexure A.
Endorsement.
That is what you have challenged.
ಈ ಬಗ್ಗೆ ಪರಿಶೀಲಿಸಲಾಗಿ ಪ್ರಶ್ನಿತ ನಲ್ಲಗುಟ್ಟಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 18ರ ಹೊಸ ಸರ್ವೆ ನಂಬರ್ 38ರಲ್ಲಿ 4 ಎಕರೆ 38 ಗುಂಟೆ ಎಕರೆ ಜಮೀನಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳ ನ್ಯಾಯಾಲಯದಲ್ಲಿ PTCL 88/2011-12. That is at annexure D, my lord. This is filed by one Garla Bovi who was dead as on that day. I have produced the death certificate also.
Please read complete.
ಈ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ತಡೆಯಾಜ್ಞೆ ನೀಡಲು ಕೋರಿರುತ್ತೀರಿ. ಹಾಲಿ ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳು ಹೊರಡಿಸಿರುವ ಆದೇಶಕ್ಕೆ ತಡೆಯಾಜ್ಞೆ ನೀಡಲು ಕೋರಿರುವ ಜಮೀನು ಮತ್ತು ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಬಾಕಿ ಇರುವ ಪ್ರಕರಣವು ಒಂದೇ ಆಗಿರುವುದರಿಂದ ನಿಮ್ಮ ವಾದ ಹಾಗೂ ಅಗತ್ಯ ದಾಖಲೆಗಳನ್ನು ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಸಲ್ಲಿಸಿ ಪರಿಹಾರ ಕಂಡುಕೊಳ್ಳಲು ತಿಳಿಸುತ್ತಾ ನಿಮ್ಮ ಮೇಲ್ಮನವಿಯನ್ನು ತಿರಸ್ಕರಿಸಿದೆ. This is pending, my lord, annexure D.
Then madam, he has dismissed the appeal like this.
ಅಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು my lord, it is pending.
In the name of the dead grantee, my lord, the petition is filed. He was dead as on, my lord, a death certificate as at page number 21, annexure E. Garlabovi is dead on 15/5/2001.
This 88/2011-12.
That is annexure D.
Annexure D, still it is pending before the assistant commissioner, my lord.
Some fictitious person has filed this petition, my lord. The next document is the death certificate of the grantee. He was dead on 15/5/2001. Then, my lord, the LRs filed the
What is the order of the assistant commissioner now?
assistant commissioner, that is, my lord, filed by the LRs of the grantee. Srimati Boyi Chaudakka, wife of Garlabovi. Two petitions were filed.
That is page 14, my lord, he allows the application and LR's application.
No, but what is the meaning of this endorsement? He has dismissed the appeal itself.
Yes, ma'am.
Where is your appeal memorandum?
Appeal memorandum is
How can you decide the appeal like this?
Yes, my lord. Yes. My lord, say subject matter of the both the pending before the assistant commissioner and order, my lord. Both are same and he was rejected. They have given.
And send it back.
Yes, my lord.
An order of
Detail
resumption
ordering.
by the LRs of the grantee was accepted by the assistant commissioner. And an order was passed on 4/2/2019,
Yes.
directing resumption of the lands. So being agreed, the purchaser preferred an appeal. And the deputy commissioner has issued an endorsement to the purchaser appellant, the following terms. In my view, the deputy commissioner could not have issued an endorsement. And in my view, the deputy commissioner could not have dismissed the appeal by issuance of such an endorsement, merely because another proceeding was pending for resumption. That cannot be a ground for the deputy commissioner to refuse to entertain an appeal. The deputy commissioner ought to have examined the validity of the order against which an appeal had been preferred before him. And he could not have directed the appellant purchaser to approach the assistant commissioner seeking for relief in the pending resumption proceedings. Therefore, we view that the impugned endorsement cannot be sustained and the same is accordingly quashed. The deputy commissioner is directed to consider the appeal filed by the petitioner. That is, number number
number ಕೊಟ್ಟಿದ್ದಾರೆ RA SC ST 1 of 19 and 20.
SC/ST 1 of 2019-20 on merits after hearing all concerned. Writ petition accordingly allowed.
Lord, interim order, my lord, there is no.
ಭಾಷೆ ಮಾಡಿದ ಇನ್ನೇನು?
Annexure is Lord, annexure B.
Not have an interim order for 5 years.
Correct, my lord. I can't tell the reasons, my lord. Interim order was not granted.
Order. Till the disposal of the appeal on merits, status quo be maintained.
Great.
We have notice order.
For 52, Jai Prakash Reddy.
To respond.
Yes.
My lord, the facts in brief are that on 21/5/1999, the Sago Licit was issued with a non-alienation clause for 15 years. Sale was on 25/2/2009 and challenged in 2013. And therefore,
You're for?
For the grantee.
petitioners are the purchasers before this court.
Who appears for the purchaser?
Jaiprakash.
Jaiprakash Reddy.
Court ಇರ್ಲಿಲ್ವಾ?
To that, that's what my lord, yesterday all these matters were listed and everyone they took a de-linked my lord. The previous matter is also 4-2 my lord. These are-
No, 97 is the grant.
Yes, my lord.
ಎಷ್ಟು ವರ್ಷ? 20 years ತಾನೆ?
Yes, my lord.
15 years
15
was
years
there.
was the
my lord.
condition.
This was within that 15 years time. It was in 2009.
Sale. 4-1 violation.
Where's Jaiprakash? Where's the order of the deputy commissioner?
And there was no delay, my lord, within the limitation, my lord, within 4 years, they have filed the application for restoration. Instant, my lord, assistant commissioner rejects the application saying that, my lord, there was no records and deputy commissioner, my lord, satisfies the AC order and this is
In fact,
4-2 violation.
The DC notice
Where is the
that-
finding record when that it was a granted land?
My
Deputy
lord,
Commissioner, my lord.
the deputy commissioner has noted that the grant certificate was in fact produced before the AC himself.
No, where
Though
does it
the
say it
AC
was a granted land? Schedule caste, schedule tribe. Where is the finding that it was a land granted to
My lord, I-
schedule caste, schedule tribe? That finding is necessary, isn't it?
Yes,
Yes, my lord,
And
the
he
finding.
says it is not, assistant commissioner says not. That finding.
Assistant
is-
commissioner says that it has not been, the grant certificate is not produced.
No, but all right, but
The
in-
DC says it is produced before the AC himself.
no,
I'll
the
just
grant
point
certificate
out.
may have been issued. But whether the land was granted to a person from the schedule caste, schedule tribe,
Yes,
where is
my-
that finding? I'll send it back to the deputy commissioner to give a finding as to whether the land was granted to a person from the schedule caste, schedule tribe. In the absence
Yes.
of that finding, how can
Yes,
we?
yes. Without any, my lord, here your deputy commissioner has no findings put it.
He simply says the grant was made, there's a violation of the grant conditions. Suppose it was a land granted to
To a non-scheduled.
then this will not apply.
My lord, page 28, my lord, deputy commissioner ಆದೇಶ ಹಾಗೂ ಕಡತದಲ್ಲಿ ಲಭ್ಯವಿರುವ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಮೇಲ್ಮನವಿದಾರರು ಹಾಜರುಪಡಿಸಿರುವ ಸಾಗುವಳಿ ಚೀಟಿ ಜೆರಾಕ್ಸ್ ಪ್ರತಿ ಹಾಗೂ ಸರ್ವೆ ದಾಖಲೆಗಳಿಂದ ಕ್ರಮಾಂಕ ಸೋನ್ಸೋ LND ಗುಂಡಪ್ಪರವರಿಗೆ ವಿವಾದಿತ ದೇವರಾಯ ಸಮುದ್ರ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 123 ಪೈಕಿ 2 ಎಕರೆ 25 ಗುಂಟೆ ಜಮೀನು ಮಂಜೂರಾಗಿ
ಎಲ್ಲಿ ಓದ್ತಿದ್ದೀರಾ ಮೇಡಮ್? ಎಲ್ಲಿ ಓದ್ತಿದ್ದೀರಾ ಪೇಜ್?
Page 28, deputy commissioner's order, my lord.
ಫಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್.
Yes, my lord, please. ಕಂಡು ಬರುತ್ತದೆ ಅಂತ ಹೇಳ್ತಾರೆ. ವಿವಾದಿತ ದೇವರಾಯ ಸಮುದ್ರ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 123 ಪೈಕಿ 2 ಎಕರೆ 25 ಗುಂಟೆ ಎಕರೆ ಜಮೀನು ಮಂಜೂರಾಗಿ ದಿನಾಂಕ 21/5/97 ಸಾಗುವಳಿ ಚೀಟಿ ನೀಡಿರುವುದು ಕಂಡು ಬರುತ್ತದೆ. ನಂತರ ಇದು ದುರಸ್ತಿ ಕೋಡಿಯಾಗಿ ಹೊಸ ಸರ್ವೆ ನಂಬರ್ 770 ರಚಿತಗೊಂಡಿರುತ್ತದೆ. ಈ ಮಧ್ಯೆ ದಿನಾಂಕ 25/2/2009 ನೋಂದಾಯಿತ ದಾಸ್ತಾವೇಜು ಸೋನ್ಸೋ ಎದುರು ಸಹ ಕ್ರಯ ಮಾಡಿರುತ್ತಾರೆ.
Pending ಇಲ್ಲ ಅಲ್ವಾ? That is land granted.
My lord, but survey record ನೋಡಿದೀನಿ and he says, my lord, ಸಾಗುವಳಿ ಚೀಟಿ issue register might be verified, my lord. ಸಾಗುವಳಿ ಚೀಟಿ issue ನೀಡಿರುವುದು ಕಂಡು ಬರುತ್ತದೆ.
Let him give a finding correct.
Please, ma'am.
An application for resumption was rejected by the assistant commissioner on the ground that there were no records indicating that the land had been granted.
My lord, may I?
Granted land. In appeal, however, the deputy commissioner has set aside the order on the ground that as per the Sagodi chit produced, it was clear that the land was granted in the year 1997.
Kumari.
The period of
For
non-use
Veena
was
Kumari.
15 years.
Please, ma'am.
And since the property had been alienated in the year 2009, that is within 15 years, the alienation had to be declared as null and void and the land was required to resume. So, however, it is noticed the deputy commissioner has not specifically required a finding as to whether the land in question had been granted to a person belonging to scheduled caste, scheduled tribe, as contemplated under the provisions of the PTCL Act. The deputy commissioner was required to give a finding if he was reversing the order of the assistant commissioner in accordance with judgment rendered by a division bench of this court in Pedareddy's case. Since the findings required in Pedareddy's case is not forthcoming in the order of the deputy commissioner, the impugn order was set aside and the matter is remanded to the deputy commissioner with the direction to him to record a finding in respect of the land in question as required in Pedareddy's case and pass approved orders in accordance with merit.
Number 53, Sri Bhaiva Reddy MS.
52 ಅಲ್ಲ sir?
In the last occasion, my lord, in the last occasion, I argued the matter. The respondent advocate was not present, and as a last chance, for them, for the appearance, my lord. I am for the grantee, my lord. Grantee. Initially, my application for resumption was rejected by the assistant commissioner. Thereafter, I appealed to before the deputy commissioner. There, the purchaser filed a memo at annexure D, my lord, page number 30.
When did you approach the assistant commissioner? How many years?
My lord, then now it has been resumed. Resumption has been
delayed.
13 my lord.
13.
Application.
2008.
Sale date?
1995 and 19.
How many? After nearly 18 years.
My lord, that is not the question, my lord. Here they admitted that there is a violation and they filed a memo before the deputy commissioner, and ultimately the land was in my favor. Now they have come before the.
They conceded that it was in violation.
Yes, my lord. No, at that time, at the time of resumption of land, there was no law of limitation, my lord. I filed an application for resumption. It was initially rejected and I appealed before the deputy commissioner at annexure C, page number 30, my lord. There, page number 33, my lord, annexure D, the respondent who is the purchaser, she filed a memo stating that the purchase was in violation of the PTCL Act and the sale may be declared as null and void and restore the subject land in favor of the original grantee. Thereafter, the matter was remanded to the assistant commissioner for resumption of the land. And
where is the order of the deputy commissioner pursuant to this annexure D?
Annexure C, my lord. Annexure C, that page number 30, my lord.
Annexure C, DC order.
Page number 32, my lord, DC order.
Where does he refer to this memo?
Memo is referred. May I read it on, my lord?
My lord, page 32 ಅಲ್ಲಿ my lord.
32.
He says, ಎರಡನೇ ಪ್ರತಿವಾದಿ ಶ್ರೀಮತಿ
ಅಗ್ನೇಸ್ ಗ್ಲೋರಿಯಾ
ಲಿಖಿತ
ಆರ್
ಮೆಮೊವನ್ನು
ಅವರವರು ಲಿಖಿತ ಮೆಮೊವನ್ನು ಸಲ್ಲಿಸುತ್ತಾ, ದಟ್ ಈಸ್ ಲೈನ್ ನಂಬರ್ 5, my lord. ಎರಡನೇ ಪ್ರತಿವಾದಿ ಶ್ರೀಮತಿ ಅಗ್ನೇಸ್ ಗ್ಲೋರಿಯಾ ಆರ್ ರವರು ಲಿಖಿತ ಮೆಮೊವನ್ನು ಸಲ್ಲಿಸುತ್ತಾ ಮೇಲ್ವನದಾರ ಕೋರಿಕೆಯಂತೆ ವಿವಾದಿತ ಜಮೀನಿನ ಹಕ್ಕನ್ನು ಮಂಜೂರುದಾರರಿಗೆ ಪುನರ್ ಸ್ಥಾಪಿಸಲು ಆಕ್ಷೇಪಣೆ ಇಲ್ಲವೆಂದು ತಿಳಿಸಿರುತ್ತಾರೆ. ಉಭಯತ್ರರು ವಿವಾದಿತ ಜಮೀನಿನ ಸಂಬಂಧವಾಗಿ ದಾಖಲಾತಿಗಳನ್ನು ಹಾಜರುಪಡಿಸಿರುವುದಿಲ್ಲ. ಹಾಗಾಗಿ ಮೇಲ್ವನ ಪುರಸ್ಕರಿಸಿ ಪ್ರಶ್ನಿತ ಆದೇಶವನ್ನು ವಜಾಕರಿಸಿ ಪ್ರಕರಣವು ಮರು ವಿಚಾರಣೆಗೆ 1ನೇ ಪ್ರತಿವಾದಿಗೆ ಹಿಂದಿರುಗಿಸುವುದು ಉಚಿತವೆಂದು ಕಂಡುಬಂದಿದ್ದು, ವಿವಾದಿತ ಜಮೀನು ಮಂಜೂರಾಗಿರುವ ಮೂಲ ಕಡತವನ್ನು ಪರಿಶೀಲಿಸಿ ನೈಜವಾಗಿ ಜಮೀನು ಮಂಜೂರಾಗಿದೆಯೇ ಎಂಬ ಬಗ್ಗೆ ಪರಿಶೀಲಿಸಿ ಮಂಜೂರಿ ಬಗ್ಗೆ ದೃಢಪಟ್ಟಿದ್ದಲ್ಲಿ ಕಾಯ್ದೆಯ ಕಲಂ 136 ಸೂಕ್ತ ಪ್ರಸ್ತಾವವನ್ನು ವಿಶೇಷ ಜಿಲ್ಲಾಧಿಕಾರಿ ಸಲ್ಲಿಸಲು ಅಗತ್ಯ ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ಸೂಚಿಸುವುದು ಉಚಿತವೆಂದು ಕಂಡುಬಂದ ಪ್ರಯುಕ್ತ ಈ ಕೆಳಗಿನ ಆದೇಶಿದೆ. ಕರ್ನಾಟಕ ಪರಿಶಿಷ್ಟ ಆದೇಶ ಜಾತಿ ಪರಿಶ್ರಮ ಕೆಲವೊಂದು ಜಮೀನುಗಳ ಪರಬಾರೆ ನಿಷೇಧ ಕಾಯ್ದೆ 1978 ರಂತೆ ಕಲಂ 5 ಅಡಿಯಲ್ಲಿ ಬೆಂಗಳೂರು ಪೂರ್ವ ತಾಲೂಕು ವರ್ತೂರು ಹೋಬಳಿ ಮುಳ್ಳೂರು ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 45 ಉಳ್ಳ 2 ಎಕರೆ ಜಮೀನು ಪೈಕಿ 1 ಎಕರೆ 20 ಗುಂಟೆ ಜಮೀನು ಬಗ್ಗೆ ಬೆಂಗಳೂರು ಉತ್ತರ ವಿಭಾಗಗಳು 18/12/2014 ರಂದು KSCST 35/23.
Then what happened thereafterwards?
Thereafter, at page number 34, my lord. That is the order of the assistant commissioner. The page number 37 is the order, my lord. In this annexure E, my lord.
Then after this,
page number 37, my lord. In these circumstances, petition filed by petitioner is allowed. It is held that the allegations of they filed 2 memos, my lord.
Then what is the order that you're challenging here?
Now they have once again come before the deputy commissioner filing an appeal, my lord.
Where is that appeal?
Appeal is annexure DA, my lord.
Has any order been passed on the appeal?
Not yet, my lord. It is pending, my lord. I challenge the pending proceedings before the deputy commissioner, my lord, which are not maintained for the second time.
It is annexure.
This copies for the other side.
My lord,
Annexure ಕೊಟ್ಟಿಲ್ಲ ಇಲ್ಲಿ. Where is the
annexure
B?
B. Annexure continue. Appeal. ಇದೆಯಲ್ಲ ಇದೆ. ಇದೆ. They say that they have come on the ground that they have entered into one agreement with one person and he has cheated them. Yeah, one KV Prasad. This on court, my lord, in a citation, may I pass the citation, my lord?
But the deputy commissioner is yet to prefer or decide the appeal.
Yes,
No, my lord. In this honorable court, may I pass the judgment of the division bench of this honorable court has held that
Stadium.
once the proceedings under section 4 and 5 of the PTCL Act are filed or initiated and the same are either withdrawn or dismissed on merits or fresh petition or second petition on the same cause of action and same subject matter under section 4 and 5 of the PTCL Act is not maintained. The matter is settled. They have withdrawn the claim, my lord. They have withdrawn by filing the memos that
There is no withdrawal. They have said no objection.
yes, and no, my lord, they have no objection and they say that their sale is in violation of the PTCL Act. The memo very clearly says at page number 33, my lord. May I read it?
I understand, but the deputy commissioner should dismiss the appeal, isn't it? How can you prefer a writ petition saying that the appeal?
No, my lord. Deputy commissioner allowed the appeal and
the assistant commissioner
dismissed the appeal, dismissed the petition initially. Then I appealed before the deputy commissioner. There the purchasers came and filed a memo.
On remand, they have conceded that the land can be resumed.
Yes, my
They
lord.
have no objection.
Yes, my lord.
On that basis, the order is passed.
Yes, my lord.
You are saying that no appeal can be preferred against that order.
Yes, my lord. They have withdrawn their claim, my lord, before the assistant
Deputy
commissioner.
commissioner will take into consideration these memos and decide.
Yes, my lord. No. Deputy commissioner has decided after taking the memos in consideration.
No, he is remanded, that's all.
He remanded. He remanded before to the assistant commissioner.
Then he decided.
What is the order that you want me to pass? Dismissing the appeal filed with the deputy commissioner.
Yes, my lord. Quashing the appeal.
Appeal is not yet decided.
Not yet decided.
How can I prevent him from filing an appeal?
Yes, my lord. That's what the judgment.
Judgment
the
says
citation.
a second petition for restoration can't be filed.
Once he has withdrawn the claim.
He has not withdrawn the claim. He has said the claim may be granted. This is a case in which the grantee had withdrawn the application. Therefore, a second petition for restoration can't be filed. That is the ruling.
Yes, ma'am.
But here, I will direct the deputy commissioner to decide the appeal, taking into consideration the two memos that are filed.
Yes. Let them go and.
That will be a better option for you.
Yes, ma'am.
An application for resumption was filed. And initially, the assistant commissioner rejected the same. Being aggrieved, the purchaser preferred. Who preferred the appeal first time?
First time we preferred the appeal. The grantee.
An appeal for resumption was filed by the grantee, which was initially rejected by the assistant commissioner, which led to the filing of an appeal by the grantee. Before the deputy commissioner, a memo was filed by the purchaser second respondent in the following terms. Next year. Thus, the purchaser considered that he had purchased, she had purchased the property in contravention of the terms of the grant and had thereby violated section 4 of the PDCL Act. On the basis of this memo, the Deputy Commissioner allowed the appeal and remanded the matter to the Assistant Commissioner, the direction to him to examine whether the land was a granted land and pass order accordingly. On remand before the Assistant Commissioner, the purchaser once again filed 2 memos in the following terms, annexure F and G. On the basis of these memos, whereby the purchaser conceded that she had purchased the land in violation of the terms of the grant, the Assistant Commissioner has proceeded to pass an order of resumption and has declared the sale deeds as null and void. Notwithstanding the memos that had been filed by the purchaser, conceding that the purchase made by her was in violation of the terms of the grant, the purchaser has nevertheless preferred an appeal. The grantee, being aggrieved by the filing of an appeal, is before this court seeking for a direction to quash the appeal that has been filed. It is to be noticed here that the Deputy Commissioner is yet to decide the appeal filed by the purchaser. So obviously, the Deputy Commissioner will have to take into consideration the memo that had been filed before the Deputy Commissioner on 10/5/2007, which is extracted above, and also the other 2 memos that were filed by the purchaser in the pendency of the proceeding of the Assistant Commissioner, which is also extracted above. So if the purchasers have clearly stated that she has purchased the property in violation of the terms of the grant, obviously the Deputy Commissioner will have to dismiss the appeal. However, the appeal cannot be quashed as requested by the petitioner, and all that can be done is to direct the Deputy Commissioner to decide the appeal on merits taken into consideration the memos that had been filed by the purchaser, whereby it was clearly conceded by her that she had purchased the property in contravention of the terms of the grant and that she had no objection for the resumption of the land. The Deputy Commissioner to pass an order in accordance with law as observed above within a period of 3 months. The date of receipt of a copy of this order.
Seal number 54 to 56 adjourned. Seal number 57, Shri Dasappa B.
I am the grantee, no. I am the grantee in this case, Your Honor.
Yes.
The land was granted in the year 1961. So it was sold in the year 1979, where it is a photo of the PDCL Act.
When did you make the application?
So it's 2013, Your Honor.
How many years? 34 years.
33 years. But new of the amendment will.
Amendment yearly. The division bench is dismissing writ petitions beyond 8 years.
One for a year. New of the amendment we claim it. Your Honor.
Notwithstanding the amendment, division bench is dismissing.
I filed a copy of the order, my lords, in my list of dates. At page number.
ಯಾವಾಗ ಸಿಗುತ್ತೆ ಮೇಡಮ್ ಅದು ಆರ್ಡರ್?
ಟ್ರೈ ಮಾಡೋಣ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಮೇಲೆ ನೆಕ್ಸ್ಟ್
ನಂಬರ್
ಮಂಡೇ
ನಂಬರ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ನಂಬರ್ ಕೊಟ್ಟಿದ್ದೀನಿ, ಅದರಲ್ಲಿ ಬೇರೆ ಇಲ್ಲ.
7 years itself it has been.
ಆರ್ಡರ್ ಕಾಪಿ ಬರಲಿ ಡಿಬಿ ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ?
I have filed ಮಾಡಿದ್ದೀನಿ. Regarding the limit, first quote, the Regarding the
Dixit
amendment not being applicable, Dikshit Sahib.
ಅದನ್ನ ದೀಕ್ಷಿತ್ ಸಾಹೇಬ್ರದಲ್ಲ ಫಸ್ಟ್ ಕೋರ್ಟಲ್ ಮಾಡ್ತಿದ್ದಾರೆ
On the light of this judgment only, judgments are.
ಸೇಮ್ ಜಡ್ಜ್ಮೆಂಟ್
This judgment is being cited and all petitions are being.
Look at the order in 10 pass because this order says both ways.
No, my lords, kindly see page.
What happens if the amendment is upheld?
My lords, even if the amendment is up, kindly see page 28 of my synopsis, my lord. It says that though the amendment, in light of the language, it makes no difference to the amendment at all. It makes no difference to the original act at all. Because it cannot change the.
That judgment also says I'm not commenting
on the constitutional validity. Though it is not, there is no commentary on the constitutional validity. The amendment, even if it is upheld, it has no bearing on the laws held by the Supreme Court is the finding. One submission, there's a application for status quo I filed. They have filed a suit for declaration of title on the ground that they are original grantees.
dismiss ಆಗಿದ್ದಲ್ಲ ಏನ್
The DC court is in my favor, my lord. Suppressing that, they've obtained a decree for declaration of title, obtained a decree, ex parte decree, and now they filed execution proceedings to vacate my possession, which is not maintainable. I filed an application, it is put up, my lord.
Though no notice is served before the honorable court, they have not appeared before the court, Your Honor. Expert order passed by the municipal civil judge, Your Honor.
No, execution proceedings are pending. Due to condonation of delay, my application for stay is not being considered in the appellate court.
You purely claim on the basis of the amendment. Your Honor.
Status quo in the meantime.
both the parties to maintain status quo.
Grateful.
58 adjourned, cell number 59, Shri Chidambara GS.
58.
Urgent, sir, 58 urgent.
Who appears for the petition?
Hearing for respondent number 5, my lord, in 58, my lord. 19th date.
59.
Cell number 59.
59, I appear for the impeding applicants. Yesterday I filed the application along with the Wakalat, my lord.
Stated
Same.
application pleading has been filed. Office to verify foot of the same.
Suresh Babu.
It's the purchaser's petition, Lord. Lord, the earlier round of litigation, Lord, it was contended that it is a auction purchase land, Lord. On that ground, the Honorable Court remanded the matter to the Assistant Commissioner. It again, Assistant Commissioner, without considering that aspect as forfeited the land, Lord. Thereafter, appeal was preferred. Appeal was dismissed for non-prosecution during the Corona time. And thereafter, an application is.
What is Deputy Commissioner?
Lord, thereafter, an application is filed for restoration of the matter, Lord. That application is also been dismissed.
Where is the order?
Lords, the order is at page 24. It's an order which was passed on the application which was filed for recalling the order, dismissing the matter for non-prosecution. And miscellaneous petition was filed.
An application for resumption was filed with the Assistant Commissioner. And the Assistant Commissioner accepted the application and passed an order for resumption and restoration of the land. So being agreed, an appeal was preferred by the purchaser. However, the said appeal was dismissed for prosecuted, for dismissed, for non-prosecution on 15/12/2020. Thereafter, the appellant made an application seeking for recalling of the said order. But the Assistant Commissioner, Deputy Commissioner has proceeded to reject the said application. In my view, the Deputy Commissioner ought not to have rejected the application filed by the appellant for recalling the order. It is to be noticed here that the appeal was dismissed from prosecution during the period when the COVID pandemic was raging in the country. And therefore of the view that sufficient cause had been made out for non-appearance on 15/12,
Oh, the 15/12/2020.
15/12/2020. And the impugned orders passed with the Deputy Commissioner on 15/12/2020 and also on. What is the date of this order?
This order is dated 5/4/22.
And 5/4/2020
5/4/22, Milord.
would have to be 22 now.
ಹೌದು 22 ಅಲ್ಲಿ ಮಿಸ್ಟೇಕ್ ಮಾಡಿದ್ದಾರೆ 2020
are quashed. The deputy commissioner and the appeal filed by the petitioner shall stand restored to file. The deputy commissioner shall consider the appeal on merits and pass approved orders in accordance with law.
And then the AC order status quo AC order
ಮತ್ತೆ ನಿಮ್ಗೆ
ಅಲ್ಲಿ ಇತ್ತು ಸ್ಟೇ ಇತ್ತು ಅಲ್ಲಿ
ಇಲ್ಲಿತ್ತಷ್ಟೇ.
ಇಲ್ಲಿ ಸ್ಟೇ ಇತ್ತು ಸ್ಟೇ ಇದೆ ಸುಮ್ಮನೆ. This honorable court and an order dated
Since the petitioner had the benefit of an interim order in this writ petition, the same interim order shall continue to the disposal of the appeal.
Seal number 61 adjourned. Seal number 62, Shri Vinod Prasad.
An application by the petitioner
For respondents, private.
under SC/ST Prohibition Act to get the land back.
ನೀವ್ ಯಾರಿಗೆ?
Now petitioner who is who granted grandson.
The grantee.
Yes, ma'am.
Now what they say earlier, his father grantee has already applied, it is rejected in 74 and thereafter 84. But grantee expired in 58 itself. There is no question of he applying in the 1974. That is the reason on the other day court asked them to get the records, whether it is true or not.
For the purchasers, loss of the
This is
purchasers.
the first order of the assistant commissioner rejecting your alleged father's.
My lord, there is Tahsildar says land is granted. Then they are related.
You said your father had made an application,
Grandfather.
your and that was rejected. Thereafter, one more application has been filed.
They say already twice application is rejected.
Where is that order?
Annexure F and annexure D.
Next year?
F and D, assistant commissioner and deputy commissioner. What they say
Next
is,
year was at the instance of Shivmurthy.
Shivmurthy is the grandson. He files an application for the regrant.
La, Prasadara, which is the first application filed by the grantee for restoration?
This is the first application filed Shivmurthy. Then what they say is your grandfather already.
Where is that?
There is no such grant because he applied in 58, it's expired in 58. Hence, there is no question of reapplying.
Page 18 ಅಲ್ಲಿ ಮೇಡಮ್ ನೆಕ್ಸ್ಟ್ ಎಫ್ ಅಲ್ಲಿ 20 on 22/7/1982 ಮೇಡಮ್
Any page number?
page 18 ಮೇಡಮ್ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ಸ್ ಆರ್ಡರ್ annexure F ಮೇಡಮ್
Which paragraph?
ಎದುರುದಾರರ ವಕೀಲರು ದೇರ್ ಮೇಡಮ್ ಆಫ್ಟರ್ 10 lines ಮೇಡಮ್ in between ಮೇಡಮ್
ಈ ಮೇಲಿನ ಸ್ವತ್ತಿಗೆ ಪ್ರಕರಣ ಸ್ವತ್ತಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಅರ್ಜಿದಾರರ ತಂದೆಯವರಾದ ಆಲಪ್ಪ ಬಿನ್ ಅಸಾದಿ ಆಲಪ್ಪ
ಯಾವುದೇ ಪರಸ್ಪರ
ಈ ಹಿಂದೆ ಅಂದರೆ 79-80ನೇ ಸಾಲಿನ ಶಿವಮೊಗ್ಗ
ತಾತೆ ಹಾಗೂ ಸ್ವಾಧೀನ ಅನುಭವ ಹೊಂದಿರುತ್ತಾರೆ ಎದುರುದಾರ ಮುಂದುವರೆದು ಮೆಲಾಡ್ ಫರ್ದರ್ ಮೆಲಾಡ್ ಇಲ್ಲಿ ಹೇಳ್ತಾರೆ PTCL ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸಿದ್ದು 80ನೇ ಸಾಲಿನಲ್ಲಿ ಶಿವಮೊಗ್ಗ ಉಪವಿಭಾಗ ನ್ಯಾಯಾಲಯದ ಪ್ರಕರಣ ಸಂಖ್ಯೆ RRCKR 723-79-80ರಲ್ಲಿ PTCL ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸಿದ್ದು ಸದರಿ ಅರ್ಜಿಯು ವಜಾ ಆಗಿ ಎದುರುದಾರರ ಪರವಾಗಿ ಆದೇಶವಾಗಿರುತ್ತದೆ. ಸದರಿ ವಿಚಾರವು ಅರ್ಜಿದಾರ ತಂದೆಯವರಾದ ಹಾಲಪ್ಪ ಬಿನ್ ಹಾಲಪ್ಪ ಇವರಿಗೂ ಯಾವುದೇ ಪರಸ್ಪರ ಸಂಬಂಧವಿಲ್ಲವೆಂದು ಹಾಗೂ ಯಾರು ವಾರಸುದಾರರು ಇಲ್ಲವೆಂದು ಮಾನ್ಯ ತಹಸೀಲ್ದಾರ್ ಹೊನ್ನಾಳಿ ಇವರ ವರದಿಯನ್ನು ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳು ತಮ್ಮ ನ್ಯಾಯಾಲಯಕ್ಕೆ ತರಿಸಿಕೊಂಡು ಈ ಪ್ರಕರಣದ ಅರ್ಜಿದಾರ ಅರ್ಜಿಯನ್ನು ದಿನಾಂಕ 22/7/82ರಂದು ವಜಾ ಮಾಡಿರುತ್ತಾರೆ. ವಜಾ ಮಾಡಿದ್ದು ಸ್ಪಷ್ಟವಾಗಿರುತ್ತದೆ. ಎದುರುದಾರರು ಪ್ರಮುಖವಾಗಿ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯಕ್ಕೆ ತರಬಯಸುವುದೇನೆಂದರೆ ಅರ್ಜಿದಾರ ಹೆಸರನ್ನು ದುರುಪಯೋಗ ಮಾಡಿಕೊಂಡು ನಾನು ಹೊಟ್ಯಾಪುರದ ಹಾಲಪ್ಪ ಬಿನ್ ಕೆ ರಂಗಪ್ಪ ಎಂದು ಸೃಷ್ಟಿಸಿಕೊಂಡ ಉಪವಿಭಾಗಾಧಿಕಾರಿ ನ್ಯಾಯಾಲಯವು ಶಿವಮೊಗ್ಗ ಪ್ರಕರಣ ಸಂಖ್ಯೆ PTCL 183, 84, 85ರ ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸಿದ್ದು ಈ ಹಿಂದೆ RRCR KA 725-89-89 ದಿನಾಂಕ 82 ಅರ್ಜಿಯನ್ನು ವಜಾಗೊಳಿಸಿದ್ದು ಅದರ ಡ್ಯೂಪ್ಲಿಕೇಟ್ ಅರ್ಜಿ ಎಂದು ಮಾನ್ಯ ನ್ಯಾಯಾಲಯವು ಪರಿಗಣಿಸಿ ಅರ್ಜಿಯನ್ನು ದಿನಾಂಕ 3/6/87ರಲ್ಲಿ PTCA ಕಾಯ್ದೆ ಅಡಿಯಲ್ಲಿ ಅರ್ಜಿದಾರ ಅರ್ಜಿಯನ್ನು ವಜಾ ಮಾಡಿರುತ್ತಾರೆ. ಎದುರುದಾರರು ಮುಂದುವರೆದು ಮಂಡಿಸುವುದೇನೆಂದರೆ ಅರ್ಜಿದಾರಿಗೂ ಹಾಗೂ ಈ ಪ್ರಕರಣ ಸ್ವತ್ತಿಗೂ ಹೊನ್ನಾಳಿ ತಾಲೂಕು ಸಾಸ್ವೆಹಳ್ಳಿ 1ನೇ ವೃತ್ತ ರಾಂಪುರ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 166ರಲ್ಲಿನ ಬಿಟ್ಟ ವಿಸ್ತೀರ್ಣದ ಸ್ವತ್ತಿಗೂ.
There are two orders.
Yes, madam, there are 2 orders.
How are you related? You said to the
Kindly,
grant.
page 15 may kindly be looked into. He expired in 58 itself.
Yaro?
Death certificate, Halappa. Man who expires in 58, can he file an application in 84 or 74?
Yeah, page number 15.
1958, page number 15.
59 is,
Page 15.
this is Ottayapurada Alappa.
Ha, Ottayapurada
And,
Halappa.
The grant
15
was,
4/58.
no, the application was mailed by whom?
That's the reason they say, court asked them to produce the records. A dead man cannot apply. They say first time in Shimoga, now it is in Davangere. Let them show it. Then it's a matter.
You are claiming to be Alappa, son of Asadi Alappa, correct?
Your grandson, man who, yes.
What is there to show that you are the grandson?
I have given the Tahsildar certificate is there. I have given family tree. Kindly annexure C may kindly be looked into. Annexure C 1 page earlier.
Annexure
C. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಶಿವಮೂರ್ತಿ ಹಾಲಪ್ಪ ರಾಂಪುರ ಸೊ ಅಂಡ್ ಸೊ ಕೋರಿದ್ದು ಅದರಂತೆ ದಾಖಲೆ ಪರೀಕ್ಷಿಸಲಾಯಿತು. 2ರಂತೆ ಸದರಿ ಜಮೀನು ಸಂಬಂಧಪಟ್ಟ ಮರಣ ಪ್ರಮಾಣ
C.
Annexure C. They say we are related.
Sir.
And the grantee, deceased grantee and myself are related. They, as per.
No, I will not go by this. What is there from your side to show that what is your father's name and what is his father's name? What is there to show?
Next earlier page, family tree.
Family tree is prepared as per your request.
But this is has been.
What is the document that you have to show?
This is
That you are the, you must have some document to show the grant was made in favor of your grandfather.
Yes.
Then you should show that your grandfather had XYZ sons.
Yes.
What is there to show?
Earlier B and C. These are.
I will not go by this.
No, what I say, my lord, is.
This annexure B and C are prepared as per your request.
No.
As per the information
Annexure
given by
A is my. Annexure B is the recommendation by Deputy Tahsildar. He certifies it.
The certificate attestation is made on the basis of your submission, not independently. What is there to show? Birth certificates of your father, of yours, indicating that.
I think Annexure B, recommendation by the Deputy Tahsildar and intern recommendation by.
Correct. The family tree is prepared as per the document submitted by you, as indicated by you.
Yes.
That will not bind everybody.
I understand. If the revenue authorities, we don't dispute.
If you don't have anything to show that your father was the son of the original grantee, you are not prepared to entertain your claim.
Yes, I can say this much, my lord. First, they say earlier already your grandfather has applied and it is rejected. Now there is no possibility for him to apply because he expired in 58 itself. That number 1.
We don't know who's that death certificate.
But let them dispute, let them file objection, I'll meet.
You will have to first establish that you are the grandson.
That is the reason.
They can't prove the negative.
No. This was argued twice and court asked them to produce those
It
records.
be argued 3 times. My first question to is, what is there from your side to show that your son, your father was the son of the original grantee?
Well, what better document I can put be certified?
What document?
And I'll ask my party in another document, called by next week. ನಾನು ಕೇಳ್ತೀನಿ ಅವ್ರ ಕಡೆ. ಅಲ್ಲ, what better document ನಂಗೆ ಈಗ clarity ಬರ್ತಾ ಇಲ್ಲ. I can get a death certificate. I can give family certificate certified by the authority themselves.
I'm telling you the process.
I understand.
What authority does the Tahsildar have
So
to
what I
say?
say, my lord, subject to whatever court says thereafter. And procedure now, as of now, is when we say on affidavit give family tree, they look into and they give certificate.
So that should be You don't have to go to civil court then. You can go to the Tahsildar, get a declaration that there's even the son of.
That is what, that is, even other side doesn't dispute.
If you,
Contesting respondent doesn't dispute. And revenue department doesn't dispute.
you are the person who's saying.
Yes, I do
that the
concede.
person who made the
Now
application
what I
was
what
a
is-
non-existent person.
I understand, burden is on my shoulder, court has, I observe, I admit. But with something which is not disputed,
So I'll use the same argument against you. The assistant commissioner is superior to the Tahsildar.
but Tahsildar,
Assistant
yes,
commissioner.
yes, yes.
The Assistant Commissioner there 82 was satisfied that the applicant before him was the son of the grantee. So if one revenue authority has accepted that he is the son of the grantee,
Then he
why
grandson
should I accept it?
from the same
You want
family.
me to accept the family tree of the Tahsildar? I'll
Yes.
accept the version of the Assistant Commissioner.
But Assistant Commissioner based upon the report of Deputy Tahsildar and Tahsildar, if it differs, he should give reason.
The Assistant Commissioner not once, has twice accepted the application, entertained the application, rejected it. So I'll go by the fact that he has affirmed it.
Not once, not once. My what now they say your grandfather had applied, hence it is rejected. Not me.
ಯಾರಾದ್ರೂ ಸರಿ ಈ ಎರಡು ಸಲ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಈ ಸ್ಯಾಟಿಸ್ಫೈಡ್.
ನಾವು ಅದೇ ಸುಳ್ಳು ಅಂತ ಹೇಳ್ತಾ ಇದೀವಲ್ವಾ, ಒಂದ್ಸಲ ಆಗ್ಲಿ ಅಂತ 58 ತೀರ್ಕೊಂಡು ಮನುಷ್ಯ 74 ಹಾಕಕ್ಕಾಗತ್ತಾ?
Maybe your remedy was to challenge that order, saying that this order is a fraudulent order. You can't go file a third application. Tomorrow your brother will come and say, the person who made the application
that
is fraudulent.
I understood.
This can be.
What I say, my lord, is not my, your grantee himself has applied what they say.
You should have made an application for recalling the order of the assistant commissioner. Filing a third petition, fourth petition.
ಆಯ್ತು, ನಾನು ಅವರಿಗೆ ಹೇಳ್ತೀನಿ, ಏನಾದ್ರು ಇದ್ರೆ ಕೊಡ್ತೀನಿ.
Next Thursday.
ಅಲ್ಲ, maybe one more issue. Let them produce those two records.
You satisfy me first. I am not very happy about your documentation. You produce it.
ಅಲ್ಲ, ನಾನು ಕೊಡ್ತೀನಿ. ನಾನು
ನೀವು
ನಾನು I am not winning the case by default. That much I can understand. What I request the court is, ಇವರಿಗೂ ಅನ್ಯಾಯ ಆಗುದು ಬೇಡ, ಅಲ್ಲಿ ಕೊಟ್ಟು ಬಿಡ್ಲಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೇನೆ. ನಾನು ಅಪ್ಲೈ ಮಾಡೋರು ಕೊಡ್ತಾ ಇಲ್ಲ ಅವರು.
ಫಸ್ಟ್ ನಿಮ್ ತಂದ್ಕೊಡಿ, ಆಮೇಲೆ ನಾನು ನೋಡ್ತೀನಿ. ಫಸ್ಟ್ ನಿಮ್ದು ಕೊಡಿ, ಏನಿದೆ ಡಾಕ್ಯುಮೆಂಟ್.
ಆಗ್ಲಿ.
Number 63 adjourned. See number 64. The Madhukar Nadi.
This is not a grantee or this is not
Kindly
a
have it
purchaser.
call after vacation. Today.
But one submission.
See.
But based on the will, my lord, I am
ಪಕ್ಕದ ಕೋರ್ಟಲ್ಲಿ ಎರಡು ಮ್ಯಾಟ್ರಸ್ ಇದೆ.
ನೀವಿದ್ರಲ್ಲ ಬನ್ನಿ ಸಾಕು ನನ್ಗೆ.
based upon will, registered will.
Kindly have it next week.
Yes.
My lord, the one Goniappa, my lord, he executed a will. Not at the time of my lord, the death, since my lord, the will has been
Goniappa is the
executed
grantee.
with respect to my lord 1 acre 20 guntas of
Goniappa is the
land.
grantee.
Please, my lord.
Who's the grantee?
Grantee is one Goniappa.
He
But
executed
he is
registered will.
my lord, he is an executor of an will by bequeathing the property in my favor, my lord.
Who are you related to Goniappa?
My lord, related is, my lord, since I am at the time of my lord, the death, I am, my lord, taking care of my lord, all the, my lord, the Goniappa.
ಸಂಬಂಧ ಇದೆಯಾ ಇಲ್ವಾ?
ಸಂಬಂಧ ಇಲ್ಲ.
ಸಂಬಂಧ ಇಲ್ಲ.
ಸಂಬಂಧ.
You belong to which caste?
My lord, same Nayak caste, my lord. And now, my lord, after my lord, the execution of registered will, my lord, I filed a suit, my lord, seeking for declaration and my lord, the declaration with respect to my lord, the ownership. My lord, there, my lord, the one of my lord, the son, my lord, Rangappa, my lord, he made as a party as a defendant before the trial court in a OS number 490, my lord. 490/2013. Where, my lord, he compromised with me, my lord, by filing, my lord, the application order 23 rule 3, stating that, my lord, the will executed by my father is, my lord, in the name of me, he is going to admit, my lord. He is also admitted that, my lord, I am the absolute owner of, by virtue of, my lord, the will. But later, my lord, the suit has been filed during 2013, which has been disposed of 2016 after lapse of, my lord, the 3 years. But after that, my lord, the very same person, my lord, the Rangappa, who has, my lord, filed an application, compromise petition. But he once again, my lord, filed a petition before, my lord, say, resumption of land. Before, my lord, the assistant commissioner during 2019, after lapse of again, my lord, the 3 years. My lord, the assistant commissioner, my lord, comes to the conclusion that, my lord, since at the time of execution of the will, my lord, the testator did not, my lord, take permission from the government as per, my lord, the act. Hence, he held that, my lord, since, my lord, the execution of will itself is invalid. And, my lord, since there is no permission has been granted by the government, the transfer becomes, my lord, in violation of, my lord, the act. Thereafter, my lord, I filed an appeal before the deputy commissioner, where, my lord, since, my lord, some of, my lord, the persons who has filed an application, my lord, respond number 5 to, my lord, now, my lord, respond number 5 to 7. They filed, my lord, the petition application under section order 1 rule 10, saying that they are, my lord, the legal heirs of, my lord, the Goniappa. Without ascertaining, my lord, the documents, my lord, the deputy commissioner allowed, my lord, the application. And straight away, my lord, on the merits, my lord, the very same, my lord, the ground has been taken with the deputy commissioner. By rejecting my claim, my lord, seeking for ownership by virtue of the will. But the act itself, my lord,
So the assistant commissioner, the deputy commissioner said,
no permission has been taken.
Is a
No, please, man.
The assistant commissioner and DC have said a will is an alienation.
Will is alienation. But as far as my lord concerned with respect to my lord aspect of my lord section 5 of my lord, the transfer of
The act, my lord, if it is a condition.
Please read the definition of transfer.
please, man.
Kindly at Monday, my lord.
Madam, our legal question.
Section 3(1), my lord.
The
Me, transfer means sale, exchange, mortgage without a bill of portion. These are any other transaction not being a portion, partition among members of a family or a testamentary disposition and includes the creation of the child.
So two things are excluded.
Partition among the family members.
And the testamentary disposition.
Testamentary disposition.
The testamentary disposition not in respect of a family member. So a will can't be a transfer.
Please.
If the will is not a transfer, then how can the order of the assistant commissioner and DC be sustained?
I don't know the first instant, I'll see, my lord, whether it is a will or what, and the AC
It's a
also.
will, registered will, I have
Fine,
permission.
my lord. They say permission.
Where is the order of the assistant commissioner?
Assistant commissioner is my lord. Heading page number 32. What he's taken a contention, my lord. ಮೇಲ್ಮನಿದಾರ ತಂದೆಯವರಿಗೆ ಮದ್ಯಪಾನ ಹವ್ಯಾಸ ಇದ್ದು ಇದನ್ನು ದುರುಪಯೋಗಪಡಿಸಿಕೊಂಡು ಎದುರುದಾರರು ಮರಣ ಶಾಸನದ ದಾಖಲೆಯನ್ನು ನಿಷೇಧಿತ ಕಾಲಾವಧಿ ಒಳಗೆ ವಿಲ್ ಮುಖಾಂತರ ಸದರಿ ಸ್ವತ್ತಿನ ಸ್ವಾಧೀನವನ್ನು ಪಡೆದುಕೊಂಡಿರುತ್ತಾರೆ. ಮೇಲ್ಮನಿದಾರ ಮೇಲ್ಕಂಡ ಜಮೀನು ಹೊರತುಪಡಿಸಿ ಬೇರೆ ಯಾವುದೇ ಜಮೀನು ಜೀವನೋಪಾಯಕ್ಕೆ ಇರುವುದಿಲ್ಲ. ಅರ್ಜಿದಾರರು ಅನುಸೂಚಿತ ಬಡಿಕಟ್ಟು ಜನಾಂಗ ಸೇರಿದರಾಯಿತು. ನನ್ನ ತಂದೆಯವರಿಗೆ ಮುಫತ್ತಾಗಿ ಮಂಜೂರಾಗಿತ್ತು.
My lord. The assistant commissioner said it's a parabare. Will is a transfer.
Even as per my lord,
Be a transfer.
even as per section 5 of my lord, the Transfer of Property Act, my lord,
ಏನಿಲ್ಲ ಮೇಡಮ್.
Senior, senior.
ಪಾಸ್ವರ್ಡ್ ಮಾಡ್ತೀನಿ ತಗೊಂಬನ್ನಿ.
ಅಲ್ಲ, Monday.
ಪಾಸ್ವರ್ಡ್ ಮಾಡ್ತೀನಿ
Kindly, Monday, my lord.
ನೀವೇ ಓದ್ಕೊಂಡ್ ಬನ್ನಿ ಅಷ್ಟರಲ್ಲಿ.
Two matters ಇದೆ ಅಲ್ಲಿ ಕೂತ್ಕೊಟ್ರಿ. Monday.
ಮಂಡೇ ಆರ್ಡರ್ಸ್ ಬರುತ್ತೆ.
Monday.
Monday will be post for orders.
ಸೋಮವಾರ Monday.
65, Shri Mukesh Vicharati.
Your lordship, I am for the petitioner, your lordship. I seek time, your lordship. Short accommodation, your lordship.
This, how the writ petition is maintainable My lord, there are 4 branches independently granted and 1942,
Section ಇದೆಯಾ?
43.
Time ಕೇಳ್ತಿದಾರೆ.
ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ನಾನು, ನನ್ನ ಹೆಸರು ತೋರಿಸಿಲ್ಲ, ನಾನು ವಕಾಲತ್ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ ಮಂಡೇ.
Stated that Sri M. Srinivas has entered appearance on behalf of
Not the respondent number 2 and 3.
two government ka.
3 and 4, please. 3 and 4.
R4 ಗೆ ಕೆ ಮಂಜುನಾಥ್ ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ.
ಇಲ್ಲ, ರತ್ನಮ್ಮ 3, ಮುನಿರಾಜು 4.
Office to verify. And if so, put up the same.
Tuesday.
20th. Number 66 adjourned, number 67.
I appear for petitioner. The petitioner purchasers petition.
I appear for respondent.
My lord, the grant was in the 1980, my lord.
Serial number?
67.
Yes.
Sorry, 69.
Yes, Supreme.
Since I discovered that the matter was already argued, except seeking leave to withdraw the writ petition, I will not make any other submission.
Lord Counsel appearing for, have you filed a memo of your party?
Yes, memo is already filed much earlier to me coming on to the record.
They are seeking liberty. I'll oppose my.
ಅಲ್ಲ, liberty ಅಂತ ಏನ್ ಹೇಳಿಲ್ಲ, just said all the contentions may be left open to be asked there.
I have not granted that liberty.
ಅಲ್ಲ, liberty ಅಂತ ಕೇಳಿಲ್ಲ, ಅನ್ಸುತ್ತೆ, the office copy does not say so.
To sale permission and it was cancelled.
You have sought for liberty. I will not grant you liberty.
Liberty proceeding.
I think what has been said is to leave open all the claims and content. I'll leave it to the court. I will not negotiate on this either, because review petition is already pending.
Notwithstanding the memo that was filed on 30/11/2024, seeking permission to withdraw the writ petition, leaving open all claims and contentions. The urge in the review petition, Learned Counsel appearing for the petitioner submits on instructions that the petition may be dismissed as withdrawn, simplicity, without any further liberty being reserved to the petitioners. In view of the above,
Then ಹೇಳಕ್ ಬೇಡ.
writ petition,
I will.
then argue on merits. You cannot have it both ways.
Argument ಆಗೋಗಿದೆ ಅಂತಂದು. So I don't want to
Since
pursue,
you have come on record, I'll hear you. I can't say I will not hear you. But you cannot have it both ways.
because there's nothing shady about this, because the earlier writ petition also had appeared. And I'm
Not
also.
saying there's anything shady. You want to argue on merits, you argue on
ಇಲ್ಲ,
merits.
merits ಮೇಲೆ, because.
Want to withdraw, make a statement to withdraw
Yes,
unconditional.
we want to withdraw the writ petition and
Unconditional.
pursue our remedy there.
If you want, ಅದೆಲ್ಲ ನಾನು ಕೊಡಲ್ಲ ಅಂತ ಹೇಳಿದೆ ನೆನ್ನೆ. Want to withdraw, I'll permit to withdraw.
Let it be withdrawn.
Madam, I'm going to withdraw the writ petition without any liberty. As requested, writ petition is dismissed as withdrawn.
I think my friend also, I think he's appearing for the fourth petitioner.
Connected other matter, my lords. Memo ಇಲ್ಲ, memo ಹಾಕಿಲ್ಲ. We will also file a memo.
I'll record your statement.
Yes, ma'am.
Shri Siddharth HM, who appears for the fourth petitioner, also submits that he has instructions to withdraw the writ petition unconditionally. As requested, writ petition in respect of P4 is also dismissed as withdrawn.
Number 68.
Petitioner, I'm the purchaser. Land was granted in 1950, my lord. The first sale date, my lord, 1984, my lord. And second sale date is 2006, my lord. The repeat sale proceedings initiate, my lord, 2006, my lord, 2006 and 7, my lord.
This is what, my lord, after the completion.
23 years delay.
Conditions. 4-2, but 4-2 comes here. That is, my lord, 19th. Court officer.
Lord, in this matter,
4-2 permission.
the
is
assistant
required.
commissioner, my lord, 2 proceedings initiated. One proceedings in favor of the grantee, another proceedings in favor of the purchaser. That is annexure G, my lord. Very same assistant commissioner. We are respondent number 7. We are purchaser, post purchaser. Annexure G. Miller. Assistant commissioner order. 84 post purchaser.
It is after the period of non-alienation.
Howdu. Annexure G, assistant commissioner, the order in favor of the purchaser. That is the proceedings initiated 91/2006 and 7 by one Suresh, son of Venkatappa. That is, my lord, the order in operative portion, order page number 45.
The Nikkanti site ಮಾಡಿ my lord to delay.
This is the order passed on 6/8/21. Nikkanti Ramalakshmi case referred and delay is considered. Very same the assistant commissioner in the year of 2012. That is annexure B order was passed.
First proceedings ಯಾವಾಗ ಮಾಡಿದ್ದು?
First proceeding, ಎರಡು proceedings 2006 and 7. One the legal heirs of the grantee and wife and son.
Purchaser.
Yes, my lord. I am second purchaser.
Second purchaser.
2006
First
and
purchase.
Now first purchase.
Who's for the granting?
Grantee is my lord the Kadrappa alias Dayal Kadrappa.
ಯಾರು? ಎಷ್ಟನೇ ರೆಸ್ಪಾಂಡ್?
Respond of 5 and 6.
Respond
5 and 6.
5 and 6.
ಗಲತ್ ಹಾಕಿದಾರ?
ಇಲ್ಲ ಅವರು they are the notice was served, they are not appeared.
As per order, R5 is deleted. 18/7/20. R6 and R7 ಏನಾಗಿದ್ದಾರೆ?
7 ನಾವಿದ್ದೀವಿ.
Your, what about R6?
6 is son of the grantee.
No.
5 is
R5
wife. 6 is son.
ಸರ್ವ್ ಆಗಿದ್ದಾರೆ ಅವರು.
ಅದು ಸರ್ವ್ ಆಗಿದೆ.
ಇಲ್ಲ, you have deleted.
Deleted R6 and
R-
ಇದೆ. Yeah.
6 ಅಲ್ಲ 5 deleted.
If you delete R5.
R5 is deleted.
There,
R6.
she died, their son is already on record.
ಆ ತರ ಬರ್ದಿಲ್ಲ ಇಲ್ಲಿ.
R5 is deleted.
6 is son, already notice served. The notice was returned for R5 is died.
ಇಲ್ಲಿ R6 ಎಲ್ಲಿ ಸರ್ವ್ ಆಗಿದೆ? ಆಗಿದೆಯಾ?
ನೋಡಿ ಆಗಿಲ್ಲ.
ಇಲ್ಲೇನೋ ತೋರಿಸಿದೆ. ಹ್ಮ್.
17th ನ ಮಾಡುವಾಗ
17th my lord, January 7th.
17 January.
Please, my lord.
Number 69, Hegde Ramakrishna.
My lord, I have taken the ground that, my lord, limitation of, there is 21 years, but amended, I have not challenged the amended act. Now I have filed application seeking to amend the prayer and to take additional ground. my lord. Application was filed on 5th December, 2 application.
The application filed amending the petition. Whereby the validity of the amending act of amending it 30 of 23 is raised, is allowed amended petition to be filed.
Please, interim order extend.
Number 70 adjourned. Number 71, Sundaresh.
The CND certified copy, there is a directions for next week. There is a direction to file a certified copy of annexure C and D. But next week,
What is C&D?
CND is the order of the assistant commissioner. C is the order of the assistant commissioner, D is the jail permission order.
Yes. I dispense not needed.
Please,
I dispense with it.
dispensation. Please, dispense with the production of certified copy, I have no objection.
What do you want now?
And now I pray for next week, 1 week time.
Yeah, my lords, the question is, the condition in the permission is violated under PTCL Act anta ಅವ್ರು ಬಂದಿದ್ದು.
ನೀವ್ ಯಾರಿಗೆ?
Now,
Grantee.
grantee.
You sought for permission.
Permission, yes, the
Permission is
permission has been
granted.
granted subject to condition that he has to purchase the properties.
Who has to purchase?
That this grantee has to purchase the properties
So you're agreed by
out
that
of the
con-
sale.
You're agreed by that condition.
Yeah, this condition is violated. Yes, agreed by that
Who has
condition.
violated? You sought
No,
for
they
permission.
have to purchase, no, while purchasing the properties, but they have to verify.
Who has to verify?
The purchaser has to verify whether the condition is
To de-verify.
compliant.
You went to the government seeking for permission to sell.
Yes,
Government granted you permission subject to ABCD conditions.
conditions.
If you violated, how can you hold him responsible?
But because well, that condition only, well, last time I kindly see Annexure D.
Liability ಏನಿಲ್ಲ.
On the very same point.
How can you even come before this court? How can you go with the assistant commissioner?
Assistant Commissioner has passed an order for,
And you thereafter go to the assistant commissioner asking for resumption of the land that you have sold.
yes, yes,
Application seeking for.
that is only the ground.
Alienate the granted land was made. And the government accorded its approval. And consequently, the Deputy Commissioner also issued an official memorandum on 2/12/2005. On the basis of this permission accorded under section 4(2) of the PTCL Act, the granted land was sold by the grantee
Legal heirs of the grantees,
21
wife and
2006 in favor of one Gaila Anmaya. Gaila Anmaya alva?
Gali Anumaya sold in favor of Chinnappa.
Chinnappa.
He is the grantee. Gali Anumaya is grantee.
Was sold in favor of
Chinnappa.
Chinnappa Reddy.
21/2006.
Chinnappa Reddy.
The respondents 5 to 6 are
The-
there. Lars.
Elders of the grantee thereafter approach the assistant commissioner contending that the alienation made in favor of Chinnappa would have to be declared as null and void since the condition imposed while granting permission under section 4(2), that is for purchase of an alternative land, had not been complied with, and therefore the alienation was bad. The assistant commissioner, by the impugn order, has rejected the said contention, and the same has also been confirmed by the deputy commissioner. The elders of the grantee being agreed with these orders are before this court by way of this writ petition. It is not in dispute that the petitioners had sought for permission to sell the land which had been granted to their father, and the permission sought for by them was granted subject to certain conditions, including the condition to purchase an alternate land. If the petitioners choose to violate the condition imposed by the government for sale of the land, they cannot contend that the alienation made by them would be incorrect. In other words, the petitioners cannot make a virtue out of their vice and contend that the alienation made would have to be resumed under section 4(2). Under section 5, it is to be stated here that once an alienation has been made in accordance with permission accorded by the government under section 4(2), no proceedings under the PTCL Act can be invoked for resumption of the land. I find no grounds to interfere with the impugn orders. Petition is therefore dismissed.
Seal number 72, VA Sampath.
The second petition, my lord, the one of the legal heirs. In fact, my lord, we offered 50 lakhs, my lord, we were prepared to. They refused, my lord, the 50 lakh.
I'm for R4. We have filed the memo for retirement. Kindly remove the name. Yesterday we have filed.
In fact, my lord, yesterday, lordship informed the party was present today, my lord, to appear today, to engage someone today. The second petition, my lord, to one of the brother
initially filed a petition in there 2001. He withdrawn the same in there 2004. Now the second brother, my lord, filed in there 2016. My lord. The assistant commissioner, my lord, the set aside the order.
Yesterday when the matter was posted, Shri Badrinath content stated that the party had taken back the papers and he had filed a memo of retirement. The party was also present and was informed the matter will be taken up today. However, there is no representative on his behalf. So as a last chance, release the matter on Monday in the orders list. The office was directed to post the memo of retirement filed by Badrinath. Please. Much obliged.
Number 73.
I appeal for petitioner, my lord.
Yes.
Please, my lord, this is the occupancy rights is granted to respondent number.
Next week, my lord. Respondent.
It's covered by judgment of the full bench, my lord, that is Jafar case, my lord, Mohammed Jafar case. Granted the occupancy.
Next week, back and forth.
Your lordship kindly fix a date, my lord, which is covered by judgment.
Interim order.
20.
Please, ma'am.
Number 74. British Giri Rao. British Giri Rao. First. 19. Number 75.
I appeal for respondent number 10.
This matter, my lord, petitioner, before the division, there is some judgment in favor of the grantee. Kindly some date, I pray some time. Petitioner, pray some time.
My lord, kindly refer to order dated 21/6 of this case only. This honorable court has ordered that he has filed fraudulent documents, and this court has warned him that if your documents are fraud, then you are liable for serious consequences. That is the order.
No, it is not. That is not correct. I obtained the certified copies from the hollow copies. I had certified copies in my hand.
DC.
Not a single document is genuine document. All are
All,
fraudulent documents.
all are genuine document. I have certified copies. I got certified copies.
It is a paid grant. It is not a free grant. It does not come under PTCL at all.
Records for them, madam. Yes.
I have certified copies. It is no any fake. These are all original. Please.
Argument ಮಾಡಿ
ಅದಕ್ಕೆ ಒಂದು ಡೇಟ್ kindly.
ಇವತ್ತೇ ಡೇಟ್ ಅಲ್ಲ.
Please.
ಡೇಟ್ ಫಿಕ್ಸ್ ಆಗಿರ್ಲಿ.
Please.
ಮೂವ್ ಮಾಡಿದ್ಯಾರು?
ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ ನಾನು ಮಾಡಿ.
Who moved the matter? ನೀವು ಮೂವ್ ಮಾಡಿದ್ರ?
ನಾವು ಮೂವ್ ಮಾಡಿದ್ವಿ.
ನಾನೇ ಮೂವ್ ಮಾಡಿದ್ದು. I have moved.
Realist.
Number 76.
I appealed for 76 also, my lord.
One week time maybe.
It's only body time.
Date
Finally, seal number 77. Vivekananda for the petitioner. So this petition is filed for the grant of letters of administration. Copy of the death certificate.
Yes.
Lord, this petition is filed for the grant of letters of administration on the death of Mr. Alex Albert Raj Malapati, my lord, in Hawaii on October 2022, my lord. He had left certain immovable properties and movable properties which are listed in the affidavit of assets.
Are you related to them?
My lord,
Or you related?
father is related. Father is the petitioner of the,
Where have you said so?
I've stated that.
Para 7.
The net assets amounts to 80 lakhs and odd money. So I am ready to pay the maximum court fee.
You are the only son?
Yes, my lord.
No daughters? So
In fact, he got drowned in the US, which is also stated in the death certificate.
your wife is not alive?
She also got drowned, my lord. Both were in the US.
This petition is filed under section 278 of the Indian Succession Act with the grant of letters of administration. That's the estate of Albert Raj Malapati. The petitioner is the father of the deceased. The deceased passed away on October 20th of 2022. Where did he at Haiku in Maui County, Hawaii, in the US. The deceased had left behind him the properties stated in the affidavit of assets. The petitioner submits that apart from himself, there are no other legal heirs of the deceased. It is also stated that the wife of the petitioner and the mother of the deceased also passed away in the very same drowning accident. The citation was issued and published in the newspaper on 11th of October 2024. There has been no claim put forth pursuant to the said citation. In my view, since the petitioner is the father of the deceased, he would be entitled for the grant of letters of administration as sought for. Consequently, the registry is directed to issue letter of administration in favor of the petitioner, subject to the complaints of the rules regarding.
Mine's one submission, my lord. As far as letters of administration is concerned, they insist on administration bond. But I've got exemptions in the past which I'm just furnishing for the various matters of mine which I've given. Because I've been promptly filing my inventory and final accounts. So hence, that kindly may be dispensed. The filing of the security bond by the surety may kindly be dispensed, and the execution of the security bond by the petitioners also may kindly be dispensed, my lord. In each of these orders, they have dispensed.
Why do you seek for exemption? What will happen if you execute?
No, my lord, the procedure is long, but since I am filing it on time and I have done it in the past, I am seeking exemption so that.
So if you file it within time, why do you require?
No, my lord, the procedure is, you have to get a surety of a like sum and all of these. So hence, my lord, since I've got exemptions in the past in these matters of mine, I would also pray before this Lord, honorable court, that I may be granted exemption.
Since the petitioner is under the father of the deceased, the requirement of filing a security bond or the execution of a security bond is dispensed.
Both, my lord. In fact, this both can be added till we. If both of these could be added, my lord, it will be explicitly clear.
I've said that, isn't it?
Yes.
Number 78, Chicken Gowda. Petitioner permit. For respond number 5.
Lords, lease is only in respect of 1 acre 22 guntas of land. The last will be kindly the unamended petition produced on Annexure G, this honorable court's order. Page number 55. Okay. Yes, please. Last para 5 on page 59. Directly I will come. Learned counsel for the writ petitioner in WP 573/2006. That is not filed by respondent number 4. Contains that the proceedings of the government of Mysore bearing order number so and so dated 19/20 April 1962 Annexure A accorded sanction for confirmation of an extent of 1 acre 22 guntas of land in survey number 32 of Harenahalli village, Humsur Taluka, Mysore district, in favor of the petitioner's father on payment of offset price of 15 rupees per acre. Per contra, learned counsel for the petitioner in WP number, that is the petitioner hearing 5533/2007 contains that the order dated 1962 Annexure A was not the subject matter of consideration before the Assistant Commissioner nor Deputy Commissioner. And in that view of the matter, both the authorities below fell in error in assuming a fact in the absence of relevant material. Then para 6, last 4 lines. Under the Act, the Assistant Commissioner is required to decide the factual question as to whether the grantee belonged to the scheduled caste on the date of grant, the nature and consideration for the grant and the conditions attached to the grant. Admittedly, the Assistant Commissioner did not record any findings on the basis of only order Annexure A in respect of 1 acre 22 guntas. Thus, the sheet anchor of support for the petitioner grantee son was the order Annexure A, which was not subject matter of consideration. In the absence of consideration over the relevant material, the Assistant Commissioner cannot but be said to have committed on an error in recording a finding in that 1 acre 20 guntas of land was in fact granted to the deceased Kenchaya, the grantee. The Deputy Commissioner in turn too, without ascertaining the nature of the grant in respect of 1 acre 22 guntas and more appropriately the material Annexure A in a cavalry manner, directed 1 acre 22 guntas of land to be forfeited to the state. the grievance of the petitioner in both of the writ petitions are well founded. In the result, writ petition is allowed. The order of the deputy commissioner insofar as it relates to the direction in to forfeit 1 acre 20 guptas of land in favor of the state is quashed. So also the order of the assistant commissioner declaring as null and void the sale transaction in respect of 1 acre 22 guptas in survey number 79 is quashed. The proceeding is remitted to the assistant commissioner, Hunsur subdivision, Hunsur, for consideration afresh over the extent of 1 acre 22 guptas of land in survey number 79 of Haryanahally village, Hunsur Taluk, with reference to annexure A dated 24/1962 in WP number 4570 so and so by extending reasonable opportunity to both of the parties to submit. This is the order. So the list is with respect to 1 acre matter remitted to the assistant commissioner. The assistant commissioner order annexure H to be found at page 63, my lords. Relevant page 65, para 2. ಎದುರುದಾರ ದಿನಾಂಕ 17/11/2007 ಹಾಜರಾಗಿ ತಮ್ಮ ಲಿಖಿತವಾದವನ್ನು ಮಂಡಿಸಿರುತ್ತಾರೆ. ಎದುರುದಾರರು 1980 ಅಂದ್ರೆ ದಟ್ ಇಸ್ ದ ಪೆಟಿಷನರ್ ಹಿಯರಿಂಗ್ 89ನೇ ಸಾಲಿನಿಂದ ವಿವಾದಗ್ರಸ್ತ ಜಮೀನಿನಲ್ಲಿ ಸ್ವಾಧೀನದಲ್ಲಿದ್ದು ಸದರಿ ಪ್ರದೇಶದಲ್ಲಿ ವಾಸವಿದ್ದು ವಾಸದ ಮನೆ ಕಟ್ಟಿಕೊಂಡು ವಾಸವಿರುವುದಲ್ಲದೆ ಪೌಲ್ಟ್ರಿ ಫಾರ್ಮ್ ಸಹ ನಿರ್ಮಿಸುತ್ತಾರೆಂದು ಅಲ್ಲದೆ ವ್ಯವಸಾಯಕ್ಕೆ ಅನುಕೂಲವಾಗುವ ವಿದ್ಯುತ್ ಪಂಪ್ ಅಳವಡಿಸಿ ಬಾವಿ ಸಹ ಇದ್ದು ತಮ್ಮ ಸ್ವಾಧೀನವನ್ನು ಸಮರ್ಥಿಸಲು ಗ್ರಾಮ ಪಂಚಾಯಿತಿ ಕಾರ್ಯದರ್ಶಿ ಆರಕ್ಷಕ ವೃತ್ತ ನಿರೀಕ್ಷಕರ ಬರೆದಿರುವ ಪತ್ರದ ನಕಲನ್ನು ಹಾಜರುಪಡಿಸಿ ಈಗಾಗಲೇ ಲಿಖಿತ ತಕರಾರಿನ ಮಂಡಿಸಿರುವ ಅಂಶಗಳ ಪ್ರಕರಣದ ವಿವಾದಿತ ಜಮೀನು ಪರಭಾರೆಯಾಗಿಲ್ಲವಾದ ಕಾರಣ ಪಿಟಿಸಿಎಲ್ ಕಾಯ್ದೆ ಈ ಪ್ರಕರಣ ಒಳಪಡುವುದಿಲ್ಲವಾದ ಕಾರಣ ಪ್ರಕರಣವನ್ನು ಕೈ ಬಿಡಬೇಕೆಂದು ಕೋರಿರುತ್ತಾರೆ. ದೆನ್ ಆನ್ ಪೇಜ್ 66 ದಿಸ್ ಇಸ್ ಇಂಪಾರ್ಟೆಂಟ್. ಹಾರನಹಳ್ಳಿ ತಾಲೂಕು ಹುಣಸೂರು ತಾಲೂಕು ಹರಿಯನಹಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 32 ಅರ್ಜಿದಾರರ ತಂದೆ ಕೆಂಚಯ್ಯ ಇವರಿಗೆ PCD ನಿಯಮಗಳಲ್ಲಿ 2 ಎಕರೆ ಭೂಮಿ ಮಂಜೂರಾಗಿದ್ದು ಭೂ ಮಂಜೂರುದಾರರಿಂದ ಮಂಜೂರಾತಿ ವಿಸ್ತೀರ್ಣ 1 ಎಕರೆ 22 ಗುಂಟೆ ವಿಸ್ತೀರ್ಣದ ಜಮೀನಿನಲ್ಲಿ ಹೆಚ್ಚುವರಿ ಸ್ವಾಧೀನದಲ್ಲಿರುವುದು ದರಖಾಸ್ತು ಪೋಡಿ ದುರಸ್ತಿ ಸಮಯದಲ್ಲಿ ಗುರುತಿಸಿದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಭೂ ಮಂಜೂರುದಾರರು ಹೆಚ್ಚುವರಿ ಸ್ವಾಧೀನದಲ್ಲಿದ್ದ ವಿಸ್ತೀರ್ಣವನ್ನು ಸದರಿಯವರಿಗೆ ಭೂ ಮಂಜೂರಾತಿ ಮಾಡಲು ಅಂದಿನ ವಿಭಾಗಾಧಿಕಾರಿಗಳ ಸಂಖ್ಯೆ LND 1 so ಡೇಟೆಡ್ 9/3/62 ಪತ್ರದಲ್ಲಿ ಶಿಫಾರಸುತ್ತಾ ಸರ್ಕಾರಕ್ಕೆ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಸಲ್ಲಿಸಿದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಅಂದಿನ ಮೈಸೂರು ಸರ್ಕಾರ ಸಂಖ್ಯೆ RD so ಡೇಟೆಡ್ 19/24/1962 ಕೈಗೊಂಡ ನಡುವಳಿಯಲ್ಲಿ ಭೂ ಮಂಜೂರುದಾರನು ಮಂಜೂರಿ ಜಮೀನಿಗಿಂತ ಹೆಚ್ಚುವರಿ ಸ್ವಾಧೀನದಲ್ಲಿದ್ದ 1 ಎಕರೆ 22 ಗುಂಟೆ ವಿಸ್ತೀರ್ಣದ ಜಮೀನನ್ನು ಸಹ ಎಕರೆಗೆ ₹15 ತಗ್ಗು ಬೆಲೆ ಅಪ್ಸೆಟ್ ಪ್ರೈಸ್ ನಿಗದಿಪಡಿಸಿ ಹಾಗೂ ಸದರಿ ಮೊಬೈಲ್ಗಳನ್ನು ಮಂಜೂರು ದಿನಾಂಕದಿಂದ ಪೂರ್ವ ಕಂದಾಯ ನಿರ್ಧರಿಸಿ ಮಂಜೂರುದಾರರಿಂದ ವಸೂಲಿ ನಿಬಂಧನೆಗಳು ಒಳಪಟ್ಟು ಮಂಜೂರಾತಿ ಆದೇಶ ನೀಡಲಾಗಿರುತ್ತದೆ. ಆದೇಶ ಆಯ್ದ ಭಾಗ ಸ್ಯಾಂಕ್ಷನ್ is accorded for confirmation of an extent of 1 acre 22 guntas of land in survey number 32 of Haryanahally so and so. Then next para. ಈ ರೀತಿ ಸರ್ಕಾರವು ಭೂ ಮಂಜೂರಾತಿ ಮಾಡಲು ಪೂರ್ವಾನುಭವ ಅನುಮೋದನೆ ಅಥವಾ ಅನುಮತಿ ನೀಡಿದ ತದನಂತರ ವಿವಾದಿತ ಜಮೀನಿಗೆ ಟ್ಯಾಕ್ಸ್ ಅಸೆಸ್ಮೆಂಟ್ ಫಿಕ್ಸ್ ವಿಧಾಯಕ TT ಪಾವತಿಸಿಕೊಂಡಿರುವುದಾಗಲಿ ಅಥವಾ ಮಂಜೂರು ಮಾಡಿದ 1 ಎಕರೆ 22 ಗುಂಟೆಗೆ ವಿಸ್ತೀರ್ಣದ ಜಮೀನನ್ನು ಸೇರಿಸಿ 3 ಎಕರೆ 22 ಗುಂಟೆಗೆ ವಿಸ್ತೀರ್ಣದ ಜಮೀನಿಗೆ ಸಾಗುವಳಿ ಚೀಟಿಯನ್ನು ಪರಿಷ್ಕರಿಸಿ ಭೂ ಮಂಜೂರುದಾರರಿಗೆ ಪರಿಷ್ಕರಿಸಿದ ಸಾಗುವಳಿ ಚೀಟಿ ನೀಡುವುದು ತಹಸೀಲ್ದಾರರ ಕಡತಗಳಲ್ಲಿ ಕಂಡು ಬಂದಿರುವುದಿಲ್ಲ. Though government has recommended for this excess of 1 acre 22 guntas to be granted to the respondent's first father, the original grantee, he did not pay either the assessment, back assessments, or the offset price. Therefore, what he paid was only in respect of 2 acres. Only on the basis of, well, the sanction granted by the government that 1 acre 22 guntas should be given to original grantee Kenchaya. Now in 2007, when the matters are pending, litigating either before the special deputy commissioner or before this honorable court, the respondent has produced. Yes. Annexure R4.
R4.
Yes.
Yes.
Right.
So this 1 acre 22 guntas. So he has paid that
No, no.
assessment charges.
Annexure R1, sir. Sorry, Annexure R1, page 12. ಅದರ ಟೈಪ್ಡ್ ಕಾಪಿ ಇಲ್ಲಿದೆ, ಪೇಜ್ ನಂಬರ್ 14. ಅದರೊಳಗೆ ಮೇಲೆ ಪ್ರಿಯಂಬಲ್ನೊಳಗೆ 62 ಎಲ್ಲ ಕೋಟ್ ಮಾಡ್ತಾವ್ರೆ ಆರ್ಡರ್. ರೆಡ್ ಲೆಜರ್ ನಂಬರ್ LND so dated 9/3/62 from the division in his letter dated 9/3/62 read above had stated that one Kenchaya was granted an extent of 2 acres of dry land in survey number 32 of Harinhalli, Hungsur Taluk, Mysore district under DCD rules was found to be in excess enjoyment of 1 acre 22 guntas of at the time of Pakka Podi over and above the original grant, and has recommended this extent may be confirmed in favor of Kenchaya at an offset price of ₹15 per acre, subject to the recovery of back assessment from the year of grant. This is the order of the year 1962. Then order sanction is accorded for the confirmation of extent of 1 acre 22 guntas of land in survey number 132 of Harinhalli, Hunsur Taluk, Mysore district in favor of the Kenchaya at an offset price of ₹50 per acre, subject to the recovery of back assessment from the year of grant. Then it was forwarded to the Tahsildar.
So 1 acre 20 guntas also is granted.
ಮಾಡಿದ್ರು ಆ ತಹಶೀಲ್ದಾರ್ ಇವರು ಅವ್ರು ವಸೂಲು ಮಾಡಲಿಲ್ಲ, ಇವರು ಕಟ್ಟಲಿಲ್ಲ. Therefore 1 acre 22 guntas of land was never, but subsequently, as I submitted just now, in the year 2007, yes. Sagoli fixed. Has been issued, page number 28, my lords, annexure R4.
Oh, he has paid the money now.
No,
There is a Sagodi chit issue.
when the matters were pending here, he paid. That is in the year 2008.
It is accepted by them.
Huh?
It is accepted by
Yes,
them.
accepted by the government. No, my submission is, he was granted, sanction was accorded for grant of 1 acre 22 guntas, provided he pays the back assessment. Then also the offset price.
Because
of
he
rupees
did not
15 per
pay.
acre,
Because
but he didn't pay.
because he did not pay, they did not cancel the order of sanction. Subsequently, they have accepted this amount. And issued him a
But in the
Sagodi
year 2007, when the matters were pending,
Yes,
just
sir.
in order to favor him.
It is up to them, isn't it? It is their land. If they choose to accept the money belatedly, you said that is bad.
No, my submission, my lord, is that when an order is passed within a reasonable time, he must pay, which he has not
It
paid.
is not your land.
So
You can-
automatically, in my humble submission, automatically the sanction fails.
You are the purchaser of this 1 acre 22 guntas.
I have purchased 3 acres 22 guntas.
So his
3 acres
title-
22 guntas.
His title stands perfected by virtue of the payment subsequently. Therefore, your title is valid. For this, your title was.
My submission is, my lords, Assistant Commissioner has made an observation that he has not paid, therefore the land belongs to the government. That itself shows, that's now I read page number.
As on that date, yes, it was not paid. It is only an irregularity.
Yes, page number,
It is, that's not meaning,
60,
but it was not found in the file.
no.
It doesn't
That-
observe in the order.
That they cannot
The
give such
butcher
an
was not found in
explanation.
the file. They
Page
had
number
paid it.
66
But
of the order
they
of
were
the assistant
removed.
commissioner after remand, he says. "ಈ
No,
ರೀತಿ
Mr.
ಸರ್ಕಾರ-
Kanwar, assuming that the money was paid belatedly, how does it improve your case?
Because I know my loss, I am not going to get it. Because even for that land of 1 acre 22 guntas, wherein I am presently residing and cultivating and raising the crops, it is a government land. It has to be put in the general pool under the land grant rules. I have already made, I have instructions to submit that I have already made an application for regularization of 1 acre of land. And even I didn't
if the
dispute
land-
before the deputy commissioner.
If the land is available for grant,
Yes,
if the land is ordered to be resumed because it was a granted land and was sold in violation of terms of the grant, then you can't claim unauthorized possession.
that is one way of submission, my lords. My submission is, since he has not paid for 1 acre 22 guntas in the year 1962, even though the order was passed, after lapse of 50 years, more than 50 years, in the year 2008, he pays it. There is something fishy in this matter. When the matter was pending before this court,
Nothing
why therefore this land belongs to?
Want to give, they want to give effect to that order. It is for them to accept.
I have made an application for regularization. I have no objection regarding,
If you are claiming under a title deed,
yes,
you can't claim unauthorized possession.
for
Claiming
regularization.
under a sale deed. Therefore, no question of you saying that you are an unauthorized possession. Unauthorized possession means you have no title,
I have no title as against the government.
but you are claiming under a title. It was an invalid title.
It's invalid title. So it relates back to the
Invalid
date of my purchase.
That invalid title becomes valid the moment the lacuna in the title is rectified. Or you can't get.
My submission is rectified when?
ಯಾವಾಗ
Question is rectified when?
Yes,
Whether, that's the reason why I amended and sought for quashing of that order of the 2008.
ನೀವು ಅವ್ರ ಜಾಗ ಅವ್ರು ಯಾವಾಗ ಬೇಕಾದ್ರೆ ಇಸ್ಕೊಳ್ತಾರೆ.
Because let it be the government land 1 acre 22 guntas. I have also applied for regularization. Let him also apply for regularization.
Should he apply
He
for
cannot
regularization?
make a backdoor entry.
It is already granted to him. Where is the question of regularization?
1962, it has been granted.
62 sanction is there. If I won't utilize it in a reasonable time, what happens to the order of sanction? It fails.
You are acting in public interest now.
My lord, internal communication, my lord, Tahsildar said.
Here the government is colluding with respond number 4.
They want to help them. They brought in a law. Where is the question of colluding? It's open. They want to help people like this.
When the matter is pending before this court, let this court, until the finalization of this order.
High court matter is pending before the
Yeah.
high court.
Ah.
But that is because of ಖಾತಾ ಮಾಡಬಾರ್ದು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು they have given the.
When there is an order of stay, how can the government proceed with the granting of 1 acre 22 guntas? When that itself is a list, that itself is a list before this court. How can do that?
You purchased a land from a person who had no title, correct? According to you, had no title
Yes,
when you purchased,
yes.
but subsequently, the lacuna of the title was rectified. So you acquired valid title.
Rectified with a modified intention to support the respond number 4.
ಯಾವಾಗ ತಗೊಂಡಿದ್ ನೀವು?
Coming 89 ನಲ್ಲಿ.
89.
Since 89, I'm in possession. Prior to that, my vendor was in possession.
28/6/1989.
ಈಗ ಈ ರಿಟ್ ಪಿಟಿಷನ್ಸ್ ಶುರು ಆದ್ಮೇಲೆ ಅವಾಗ ಕಣ್ಣು ತೆಗಿತಾರೆ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 4. ಇಲ್ಲ ನಮ್ಮಪ್ಪ 62 ಎಕ್ಸೆಸ್ ಲ್ಯಾಂಡ್ 1 acre 22 guntas ಅವಾಗ ತೆಗಿತಾವನೆ. ಅದಕ್ಕೆ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಹ್ಯಾಸ್ ರೈಟ್ಲಿ ಅಬ್ಸರ್ವ್.
89 when he purchased the property, it was not a granted land. There was an order of grant.
Yes.
The order of grant is fructified only when the conditions of the grant are complied with. Suppose the grant conditions are complied with nearly 18 years after the alienation. Will it now become a granted land? Because the grant becomes complete only on the payment of that rupees 15 per acre. Until then, it is not a granted land. If it's not a granted land, then where is the question of violation of the terms of conditions of the grant?
Is not a violation. For a 1 acre 22.
Violation, it is government has, it was paid earlier, but it was not found in the file.
ನೀವು ಮಾರಿದಾಗ ನಿಮ್ಗೆ ಸಾಗುವಳಿ ಚೀಟಿ ಇರ್ಲಿಲ್ಲ. ನಿಮಗೆ ಮಾರಿದಾಗ ಸಾಗುವಳಿ ಚೀಟಿ ಇರ್ಲಿಲ್ಲ.
ಸಾಗುವಳಿ ಚೀಟಿ ಇರ್ಲಿಲ್ಲ.
Granted, the land was granted to.
ಸಾಗುವಳಿ ಚೀಟಿ ಇರ್ಲಿಲ್ಲ. ಸಾಗುವಳಿ ಚೀಟಿ ಕೊಟ್ಟಿದ್ದು ನಿಮ್ಗೆ 2007 ಇಸ್ವಿಯಲ್ಲಿ ಕಾಸು ಕೊಟ್ಟಾದ್ಮೇಲೆ.
ಹೌದು.
So by that time you had already sold the property.
No, I have not sold this property. I have not sold this property.
Then
this 1 acre 22 guntas is never sold by me. It is never sold by me.
then second Godra.
I have not sold. I have not sold.
I will give the correct figure.
I have never sold it.
No.
You are- That is
Point number 4, father.
Only was sold. 2 acres only was sold. It was resumed. It was resumed and there is no dispute.
Last time he told me 2 acres was sold in 69, second sale 74, 75 third sale, 75 by the first purchaser. 89 he
Only 2 acres.
So only 2 acres.
ಇವ್ರು ಯಾವಾಗ ತಗೊಂಡು?
Iವರು 89,
First, one ನಿಮಿಷ.
28/6/1989, they purchased 3 acres 25 guntas. 3 acres 22 guntas.
28/6.
28/6/1989, mine. Annexure B.
He conceded last time 2 acres, he has no problem.
Yes, it is reached finality.
He has no problem.
Yes.
Rest
This
of
is the
1 acre
finality
is-
ಅಂತಂದ್ರೆ ನಾನೇ ಬಿಟ್ಕೊಟ್ಟಿದ್ದೇನೆ.
1 acre 22 guntas, for which there is no sale deed at all, executed by me. I have not executed sale deed. At any time, I have not executed sale deed. Who? Either Kenchaya or the respondent number 5.
The purchaser executed sale deed.
He purchased it from one Karya Naik who had no title. He purchased it only, he was the owner of 2 acres. Karya Naik was owner of 2 acres, sir. But he purchased 3 acres 22 guntas. Without any sale deed.
Clarify ಮಾಡ್ತೇನೆ. I will clarify.
No.
First sale from original grantee was in the year 1969.
For 2
That is
acres.
on 26/6/1969.
For 2 acres.
2 acres.
Then second sale was
Then
74.
second sale was in the year 1974-75. Date
That
I
is
do
also
not
for
have.
2 acres.
One Shivaya.
That is only
Son
for
of-
2 acres.
That is for 2 acres.
Only 2 acres.
ಅದು 2 acres.
Third sale is
Then
75.
in 84-85,
No, third sale is
third sale
75.
only from Shiva Nayaka
Venkat.
to
Venkatesh.
Venkatesh.
That is also
Only 2 acres. Then in 84-85,
it comes, acres.
it has been sold again back to the original purchaser.
75 years 2 ಎಕರೆ ಮಾರ ಥರ್ಡ್ ಸೇಲ್.
house.
How?
ಥರ್ಡ್ ಸೇಲ್ ಆದ್ಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಸೇಲ್ ಯಾವಾಗ?
Fourth
Up
sale
to 2 acres.
84/85.
2 acres.
And when Karya Nayaka, it was sold once again back, the first purchaser from the Kenchaya original grantee,
ನಾನು ಹೆಸರು ಮೇಲೆ ಹೋಗ್ತಾ ಇಲ್ಲ.
ಹಾ.
First sale was in the year 69.
1969,
Second sale was in the year 74.
74-75,
Third sale was in 75.
74-75.
74/75.
Yes, and third sale is in 84-85,
84-85.
85.
Fourth sale.
And fifth sale back to first purchaser from the grantee is in the year 1984-85 once again.
Again,
Yes. And from him, there is the first purchaser, Karya Nayaka. I purchased it in the year 1989,
according
3
to
acres 20 guntas.
according to the fifth sale was back to the grantee.
Please. I purchased it 3 acres
Back to the
20
grantee,
guntas.
original.
The grantee sold it to you. The grantee sold it to you
Oh, yes.
in the year 89.
89, I purchased
Not
it.
a grantee, only he is also first purchaser. Karya Naik is the first purchaser, not original grantee.
Fifth sale.
Karya-
Fifth sale was back to whom?
Fifth sale was back to
What is
the
the name of
first
the first
purchaser,
purchaser?
Karya Nayaka.
What is the name of the first purchaser?
Karya Nayaka,
Karya Naika to
Karya Nayaka,
petitioner Mohan Raj.
son of late Siddhaya.
The fifth sale was back to Karya Naik.
Correct.
Yes.
So the person who sold the property to you was Karya Naika, the first purchaser.
89.
who had no title to sell you 3 acres, 22 guntas.
Yes.
So the grantee has never sold 3 acres, 22 guntas to you.
Yes. 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 So I purchased in 89,
Then if that is
3
so,
acres, 22 guntas.
no, if that is so,
Yes.
under section 5, any person in possession of a granted land, there's a presumption that there is a transfer contrary to the terms of the grant. Therefore, you will suffer an order of resumption.
Granted land is only 2 acres. Granted land as on day.
Who are in possession of land which has been granted to a person belonging to scheduled caste, scheduled tribe. Let us assume the grant was made in the year 2007. Let us assume, because the money was paid, but you are in the.
Money was not yet paid. Money was not paid. Only for 2 acres it was paid.
Let us
Not,
assume-
not
let us-
1 acre, 22
Let us
guntas.
assume the money was paid in the year 2007.
Only 2007 or 8,
The
yes.
moment that money is paid, it is a granted land. You are in possession of a granted land
If
to
from,
which there is no alienation. Therefore, by the grantee. Therefore, section 5 will come into operation and it will say that you are in possession of a granted land. There is a presumption there is a transfer in violation of the terms of the. You will have to yield possession.
deemed, alas, in my
Either way.
respectful submission, it may not be correct because when I purchased in 89, I purchased it from Karnataka.
I am not going by purchase now. The purchase is by the another purchaser who had no title to sell it to you.
He had no
Even
title in
according to
respect
you.
of 1 acre, 22 guntas.
So you purchased a land from a person who had no title. Now let us assume that that particular 1 acre 22 guntas
And
was granted by the government subsequently
Please.
to a person who is scheduled caste, scheduled tribe.
please,
If you are in possession of somebody's granted land, there's a presumption against you.
no, no,
You will have to yield possession.
my submission is in this way. My submission in this way, I may kindly be excused for making this submission. My lords, insofar as 2 acres is concerned, there is no this thing. I agree with it. Insofar as 1 acre 22 guntas is concerned, it is neither the land of my vendor, Karinayaka, nor that of the grantee.
I'll accept that.
Right.
I'll accept that.
Therefore, only sanction was made. Asking the Tahsildar or the lower rank authorities to collect the amount and then give the possession certificate. So the original grantee was never granted with any possession certificate because he has not paid anything. But they, during the pendency, they regularize it by taking the amount and passes the order and issues the possession certificate in the year 2008.
ಈ 1 ಎಕರೆ ನಿಮ್ಮ ಮನೆ ಇದೆಯಾ? ಈ 1 ಎಕರೆ ನಿಮ್ಮ ಮನೆ ಇದೆ. This 1 acre 22 guntas, your house is there now.
ಹೌದು.
No, well, according to us, it is in 2 acres. It is in
ಅದಕ್ಕೆ
2 acres.
there are 2 things open.
They should-
Now, out of 3
Yes,
acres,
survey records are there.
out of 3 acres,
Survey records have been.
my lords, out of 3 acres, 22 guntas, I have graciously given back 2 acres.
Graciously
sitting there
ಏನಲ್ಲ,
Because
your
because
father
it was, yes. ಈಗ 1 ಎಕರೆ 22 ಗುಂಟೆ ಬಡವ ನಾನು ಇದು ಮಾಡ್ತೇನೆ, ಇದು 2ನೇ ವ್ಯೂ ಇದು. ಅದಕ್ಕೆ ಇಷ್ಟ ಆಗಿದೆ, ಅದು ಬಿಟ್ಟು ಕೊಡಿ ಅಂತ ಅಷ್ಟೇ. Then I will make the application before the, I have made the application for regularization 1 acre 22 ಗುಂಟೆ.
ನಿಮ್ಮ ಮನೆ 1 ಎಕರೆ 22 ಗುಂಟೆಯಲ್ಲಿ ಇದ್ರೆ I'll consider
ಮನೆ
to
ಇದೆ.
sell that house.
ಎಲೆಕ್ಟ್ರಿಸಿಟಿ
that-
ತಗೊಂಡಿದ್ದೇನೆ.
Suppose that house is in the 2 acres, then you lost.
ಇಲ್ಲ ಅದ್ರೊಳಗಿಲ್ಲ. 1 acre 22 ಗುಂಟಾದ್ನೊಳಗೇನೆ ಇದೆ. Yes.
If he has a house there,
Yes.
I want to protect that house. Remaining,
I'll find out. We have to make this formal.
We'll find out it whether it is in 2 acres or 1 point.
Yes, sir. Yes.
if it's a 1 acre 22 guntas, ಅವ್ರ ಮನೆ ಜಾಗ ಪೂರ್ತಿ ಬಿಟ್ಕೊಟ್ಬಿಡಿ.
That can.
We'll get it back.
ಮನೆ ಜಾಗ
ಹೌದು.
ಮನೆ ಜಾಗ ಉಳಿಸ್ಕೊಳಕ್ ಟ್ರೈ ಮಾಡ್ತೀನಿ. ಮಿಕ್ಕಿ ಜಾಸ್ತಿ ಕೇಳಬಾರ್ದು.
ಅಲ್ಲ ಮನೆ
ನೀವು ಆಮೇಲೆ ಚೌಕಾಸಿ ಮಾಡಿದ್ರೆ ಪೂರ್ತಿ ಐ ಕ್ಲೋಸ್ ಇಟ್.
ಅಲ್ಲ, ಈಗ ಮದುವೆ ಮಾಡ್ಕೊಂಡು ಮಕ್ಕಳು ಬೇಡ ಅಂತಂದ್ರೆ ಹಂಗೆ ಇದು ಮನೆ ಅಷ್ಟೇ ಕೊಡಿಸ್ತೇನೆ.
But he is
ಯಾಕಂದ್ರೆ my livelihood is
not staying in that house, sir.
ಅಲ್ಲ,
my livelihood is on the.
ನೀವು 2 ಎಕರೆ ಬಿಟ್ಕೊಟ್ರೆ ದೊಡ್ಡ ಮನ್ಸು ಮಾಡಿದೀರಾ. ಇದು ಯಾಕೆ 1 ಎಕರೆ 22 ಗುಂಟೆ ಜಗಳ ಮಾಡ್ತಿದ್ದೀರಾ?
ಅಲ್ಲ, ಅವ್ರು ಜಗಳ ಮಾಡ್ತಾ ಇದಾರೆ. 2 ಎಕರೆ ಬಂದಿದ್ದು ದೊಡ್ಡ ಮಾತು ಅವ್ರಿಗೆ. ಅದನ್ನ ಜಗಳ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಈ 1 acre 22 ಗುಂಟಾಗಿ ಬಡವನಿಗೆ ಯಾಕೆ ಬಿಟ್ಕೊಡ್ಬಾರ್ದು? It is only for this reason that I am the resident Tamil Nadu. That also have 3 days.
2 ಎಕರೆ ಬಿಟ್ಕೊಡು ದೊಡ್ಡ ಮನ್ಸಿದ್ರೆ ಇನ್ನು 1 ಎಕರೆ ಬಿಟ್ಕೊಡ್ಬೋದು ನೀವು. ನಿಮ್ ಮನೆ ಉಳ್ಸಕ್ಕೆ ಪ್ರಯತ್ನ ಪಡ್ತೀನಿ.
ಅಲ್ಲ ಮನೆ ಪ್ಲಸ್ ಅದ್ರ ಸುತ್ತಲ ಏನೋ ಒಂದು ಬೆಳ್ಕೊಂಡು ಮಾಡ್ಕೊಂಡಿದ್ದೇನೆ ಅಷ್ಟೇ ನನಗೆ ಬೇಕು. ಅಷ್ಟು ಅದು ಉಳಿಸ್ಬಿಟ್ರೆ
Not personally cultivating, he is in Tamil Nadu, but he is staying.
ಎಲ್ಲರೂ ಇಟ್ಕೊಳ್ಳಿ.
ಹೌದು ಸರ್,
He is staying.
ಈಸ್ ಇಂಡಿಯನ್ ಸಿಟಿಸನ್.
ನಾನು ಧಾರವಾಡದವನು,
ಮನೆ ಜಾಗ ಸುತ್ತ-
ಬಂದು ಅದೇನೆ.
ಮನೆ ಜಾಗ ಸುತ್ತಮುತ್ತ
ನೀ ಧಾರವಾಡಕ್ಕೆ ಹೋಗಿ ವಾಪಸ್ ಅಂತಂದ್ರೆ ಹೆಂಗಾಗುತ್ತೆ?
22 ಗುಂಟೆ ಏನಾದ್ರು ಬಚಾವ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ ನೋಡಿ. 1 ಎಕರೆ, ಬಟ್ 1 ಎಕರೆ ವಾಲಂಟ್ರಿ ಬಿಟ್ಕೊಡ್ಬೇಕು ನೀವು.
1 acre 22 ಗುಂಟಾಸ್.
1 ಎಕರೆ 22 ಗುಂಟೆ ಇದೆ.
ಹಾ.
ಆ ಮನೆ ಜಾಗ ಒಂದು 22 ಗುಂಟೆ ನೀವು ಬಿಟ್ಕೊಡ್ಬೇಕು. ಮಿಕ್ಕಿದ 1 ಎಕರೆ ಬಿಟ್ಕೊಡ್ಬೇಕು ನೀವು. ನೀವು ಬಿಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನಾನು ಆರ್ಡರ್ ಮಾಡ್ತೀನಿ, ಪೂರ್ತಿ ಹೋಗುತ್ತೆ. ರಿಲೀಸ್ಟ್
Monday.
ಕರೆಕ್ಟಾಗಿ ವೆರಿಫೈ ಮಾಡ್ಕೊಂಡು ಬನ್ನಿ.
ಆಯ್ತು ಸರ್.
ಮಂಡೇ, ಥರ್ಸ್ಡೇ.
Area number 80, my sir. Because well matter, already lordship added the matter.
ಥರ್ಸ್ಡೇ ಹಾಕೊಳ್ಳಿ. Thursday hearing for staff.
Tuesday. Tuesday.
46, Monday, my lords. Further hearing,
4:30. 82, Monday 4:30.
ಸ್ವಲ್ಪ,
Monday
it
4:30.
may require some time, my lords.
Tuesday.
But it may require some time, my lords.
So what? From 4:30 till you finish.
Please, Tuesday.
83 after vacation, ಒಂದು ಸೆಟಲ್ಮೆಂಟ್ ಏನೋ ಟ್ರೈ ಮಾಡಬೇಕು. ಲಾಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ನಾನು ರೆಕಾರ್ಡಿಂಗ್ ಬಂದಿದ್ದೀನಿ ಆಸ್ LRs ಆಫ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 3. ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಐ ಟ್ರೈ ಫಾರ್ ಎ ಸೆಟಲ್ಮೆಂಟ್. ಲ್ಯಾಂಡ್ ಇಸ್ ಆಲ್ರೆಡಿ ಅಕ್ವೈರ್ಡ್, ಓನ್ಲಿ ಕಾಂಪನ್ಸೇಷನ್ ರಿಸೀವ್ ಮಾಡೋದ್ರ ಬಗ್ಗೆ.
Who's opposing?
ಪಿಟಿಷನರ್ ಮೇಡ
83 ಅಲ್ಲ?
I have informed him.
ಇನ್ಫಾರ್ಮ್ ಏನಿಲ್ಲ ಸ್ವಾಮಿ, ನಮ್ದೇನ ಇದಾಗಿಲ್ಲ.
Immediately
ಅಲ್ಲ,
after
ಲ್ಯಾಂಡ್
vacation
ಆಗಿಲ್ಲ ಸ್ವಾಮಿ, ಆಗಿಲ್ಲ ಅಂತ.
ನಾವು ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಅಂತ ನೀವೇನ್ ಹೇಳ್ತೀರಾ?
ಆಫ್ಟರ್ ವೆಕೇಶನ್.
Already 82 after vacation.
ಇಂಟ್ರಿ ಆರ್ಡರ್,
I have
ಇಂಟ್ರಿ
informed
ಆರ್ಡರ್
them,
ಮೇಲೆ ಎಕ್ಸ್ಟೆಂಡೆಡ್ ಮೇಲೆ. ಇಂಟ್ರಿ ಆರ್ಡರ್ ಮೇಲೆ 83.
Lords, may I make one submission, my lords?
Yes. More petition.
My lord, serial number 88, my lords, I'm for the petitioner.
Yes.
It may be add after vacation, my lords. May I request the interim order to be extended, my lords?
All right.
ಶಾಂತಪುರ ಕೇಳ್ರಿ, ಮತ್ತೆ ಅವ್ರು ಯಾಕೆ ಬಿಟ್ಟು
Lord, serial number 86, my lord.
Sir, court officer.
Vacation.
Sir, ಅದು 88 ಡೇಟ್ ಏನಾದ್ರು ಕೊಟ್ರಾ ಸರ್?
84
83 ಮೇಲೆ
ಸಾಹೇಬ್ರೆ 84 ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಮಾಡಿ.
86 after vacation.
84 ಆಫ್ಟರ್ ವೆಕೇಶನ್.
Sir, 86. Sir, 86. Sir, 80 Thursday na?
vacation.
Sir, 86 after vacation. Sir, 80 Thursday na, sir?
Sir, 88 sir ನಾನು.
Tuesday ಬರಲ್ಲ.
LFA. 87 after vacation.
Sir, 88 sir.
Petitioner, sir. After 82 after vacation, sir. 82. ಮೆನ್ಷನ್ ಮಾಡಿದ್ರು.
Sir?
ಕೇಳಿದ್ರು BN ಪ್ರಕಾಶ್ ಮತ್ತೆ ಆ ಕಡೆ ಅವರು. after vacation.
85 call after vacation.
Sir?
85. After vacation.
After vacation.
Sir? Sir, 88.
88 after vacation.
Sir, ಅದರಲ್ಲಿ ಇಂಟರ್ ಮಾಡಿದೆ ಸರ್, ಅದೊಂಚೂರು ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿ.
Extend ಆಗುತ್ತೆ.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು ಸರ್.